Hello and welcome to Unacademy. Let's revise Polity for Prelims 2025. I encourage you to download the PDF of this session, which I shall be uploading on my Telegram channel. The link to join the Telegram channel is provided in the video description. As part of our Conquer Prelims initiative, specifically with respect to Indian polity, I have covered the BEAR Act in 3 sessions. Then we discussed last 10 years, previous year's questions in 1 session. Then we discussed in 2 sessions current affairs of the period January to May 2024, and then current affairs from June to April 2025 as well. And today, this is the last revision, and let's hope we are able to comprehensively cover polity for your prelims examination and encourage us as well by liking the session and subscribe to our channel if you haven't yet. Let's get started. And first up, we will start with the executive, union executive, as well as state executive. Let's look at union executive first. You need to understand that union executive consists of president, vice president, prime minister, council of ministers, and the attorney general for India. When we look at the office of president, Constitution says under Article 52 that there shall be a president of India, which means our constitutional scheme cannot be imagined, cannot be envisaged to run even for a brief moment without somebody occupying the post of the president of India. There has to be the president of India. If the office of the president is vacant, then what will happen? Vice president will act as the president of India. Now, what if the office of vice president is also vacant? The constitution is silent on this aspect because constitution says there shall be a president of India. In absence of the president of India, vice president will act as the president of India till the time a new successor, the president, is elected. But what if there is a vacancy in the office of vice president as well? For that, a law was passed in 1969 by the parliament called President Discharge of Functions Act. And according to this law, which primarily means it is a statutory requirement, something which is not envisaged, provided in the Constitution. In absence of the Vice President, also, the Chief Justice of India will act as the President of India. If the office of the Chief Justice is also vacant, then a senior judge of the Supreme Court will act as the President of India till the time the successor is elected. This is Article 52 of the Constitution. Now, listen to me carefully. In the event of the occurrence of any vacancy, now vacancy can be because of death, vacancy can be because of resignation, vacancy can also be because the president can be impeached by the parliament. In that case, the vice president will act as the president of India until a new successor is elected. When the president is unable to discharge his functions, now listen to me carefully why the statement becomes important. Even if we have a president, but the president is unable to discharge his duties, maybe president is traveling abroad, or maybe the president is sick. In that case also, if the president wants, he can ask the vice president to act as the president of India till the time president is back or the president recovers. Then the president will occupy the post of the president of India. This vice president, while he is discharging the duties of the president of India, he will have all the powers, all the immunities which are available to the president of India. These facts are very important, can be relevant for your prelims examination. Now let's look at the question on your screen. Which of the following is or are mentioned in the Constitution of India? Let me know the answer in the comment section. The executive power of the Union is vested in the president. This is something that Article 53 talks about. Article 52, which says there shall be a president of India, and Article 53, all the executive powers are vested in the name of the president of India. But what is this executive power? This executive power is not defined in the constitution. Clear? But executive power will be vested in the name of the president of India. Is it also mentioned, according to the constitution, that the supreme commander of the defense forces or the supreme command of the defense forces will be vested in the name of the president of India? This is also explicitly mentioned in the constitution. The president is bound by the aid and advice of the Council of Ministers, except when the president is required under the constitution to act in his discretion. Is this statement correct? This statement is incorrect. B, two statements is the right answer. Why? Because constitution does not talk about discretion for the president. Constitution says under Article 74 of the Constitution that there shall be Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall act on that advice. That means it is mandatory for the President to act on the advice of the Prime Minister and Council of Ministers. The only thing that the President can do, President can ask the Council of Ministers, he consider this advice. But it is not mentioned in the Constitution that there is a discretion available with the president. That is something which is not provided in the Constitution. That is why B, two statements is the right answer. Then what is the qualification required for someone in order to become or contest the election to the post of the president of India? Constitution says this person has to be the citizen of India, must have completed 35 years of age, and this person should be eligible to become the member of the House of the People, which means this person should be eligible to become the member of the Lok Sabha. And at the same time, Constitution says that this person who has to contest election to the post of the President of India should not be holding any office of profit either. This is something that you have to keep in mind. Now let's look at the question on your screen. The holders of which of the following offices can contest elections to the post of the President of India without resigning? You have 1 minute. Let me know what is the right answer. The holders of which of the following offices can contest elections to the post of the President of India without resigning? If I am a governor, do I have to resign and then contest election, or the vice president or the union minister? What is the right answer? The holders of which of the following offices can contest elections to the post without resigning? Governor need not resign to contest election to the post of the president. Neither vice president of India, nor a union minister, nor a minister at the state level. But if you are a chairman at the Indian Statistical Institute in Kolkata, then you have to first resign and then contest election to the post of the President of India, because this is considered to be the office of profit. But, sir, you are randomly mentioning one office called Chairman of Indian Statistical Institute. Why do we need to remember this? This is relevant. Why? Because when Pranab Mukherjee became the president of India, when he contested election to the post of the president of India, his opponent was Mr. P.A. Sangma. And P.A. Sangma had alleged that Pranab Mukherjee did not resign as the chairman of the Indian Statistical Institute before contesting election. So, on the grounds of office of profit, Pranab Mukherjee should be disqualified. But then this petition was rejected, and Pranab Mukherjee completed his full 5-year term. Which means if you are a chairman of the Indian Statistical Institute, you have to first resign and then contest election to the post of the President of India. Others need not resign, which does not mean that you can be the vice president and president at the same time, governor and the president and at the same time. But you don't have to necessarily resign, which means once you're elected, you can resign from these positions. Which means 1, 2, 3, 4, B is the right answer. The explanation is that the president cannot be the member of either house of Indian Parliament. So you can't be the president and Lok Sabha or Rajya Sabha MP. But sir, Article 79, it talks about that Parliament consists of President, Rajya Sabha, and the Lok Sabha, which is correct. But that does not mean that the president is the member of the Lok Sabha or member of the Rajya Sabha. President is an integral part of Parliament, not a member of Lok Sabha or Rajya Sabha. And this president cannot be the member of either Lok Sabha or Rajya Sabha or Legislative Assembly or Legislative Council. But if such an individual has been elected, and when you are administered oath of office for the President of India, the date on which you enter office as the President of India, we can assume that you have resigned from such a seat, which means if you are a member of the Lok Sabha and then you have got elected as the President of India, then when you enter office, after oath is administered to you, we can assume that from that date you have resigned from your seat in the Lok Sabha or the Rajya Sabha or the Legislative Assembly or the Legislative Council. Clear? Now let's look at another question. Which of the following best describes the nature of Indian president's election? Direct election by the people of India. Is the president of India elected by the people of India? Yes, but not directly. The president is elected in an indirect election, which we will discuss today. Indirect election by an electoral college using the system of proportional representation system by means of single transferable vote. Or is the president nominated by the prime minister and then elected by the Lok Sabha, or elected by Lok Sabha and Rajya Sabha using first past the post system? You may be confused between D and B, but B is the right answer. How is the president of India elected? Number one, president of India is elected by an electoral college. That means elected by the people of India, but not directly, indirectly. Indirectly through their representatives. And these representatives are where? In the electoral college. An electoral college of the president consists of elected members of Rajya Sabha and Lok Sabha, elected members of state legislative assemblies. And state legislative assemblies include the Legislative Assembly of Delhi and Puducherry. Clear? Which primarily means what? It means that the nominated members of Rajya Sabha, they are not part of the electoral college. It also means that members of state legislative councils, they are also not part of the electoral college. So if the president of India is elected by the people, but not directly, indirectly through their representatives in the electoral college, this electoral college consists of elected members of Rajya Sabha and Lok Sabha, elected members of state legislative assemblies, including Legislative Assembly of Delhi and Puducherry, which means nominated members of Rajya Sabha, the members of the legislative councils, they are not part of the electoral college. Sir, what about the Legislative Assembly MLAs of Jammu and Kashmir? Because that is also a union territory which has a legislative council. My answer to that is the elected MLAs of J&K Assembly, they are not part of the electoral college. Why? Because if you have to change anything in this electoral college, Constitution says if you change the manner and method of president's election, for that what we need? We need a constitutional amendment under Article 368 of the Constitution. So if you have to change the manner and method of president's election, you need to amend the Constitution using Article 368. And for that, what type of majority is required? Both houses of Indian Parliament will have to pass a resolution by two-thirds of the members present and voting, plus majority of the total membership of the House. Then this proposal This bill has to be sent to all the state legislatures in India. And only when not less than half of these state legislatures ratify this constitutional amendment, only then this amendment can be sent to the president for assent, which means it requires special majority flavor 3 if you have to change the electoral college, which means, long story short, if you want J&K Legislative Assembly members to also be part of the electoral college, for that you need a bill to be passed by both houses of the parliament under Article 368. Get this bill ratified by not less than half of the state legislatures in India, and then it can be sent to the president for assent. And the president is elected through a system called proportional representation system, which means population plays a very important role. More the population of a particular state, more weightage, more value of votes that particular state will have when it comes to the president's election. And single transferable vote, which means a ballot paper will be provided to you, which means, remember, EVMs are not used for the presidential election. Ballot papers are used. And in ballot paper, on one hand, the name of the candidate would be mentioned, and on the other hand, you have to mark your preference. But is it necessary that you have to give many preferences, one, two, three preferences? No, you can give a single preference. First preference, mandatorily, you have to give. If you don't give first preference, then your vote will be invalid. So, first preference necessarily you have to give, but you can give as many preferences as there are the candidates. If there are four candidates contesting the president's election, you can give four preferences, one, two, three, four. But necessarily you have to give first preference. If you don't give first preference, your vote will be declared invalid. And then this voting takes place through secret ballot. That means you don't have to disclose your preference to anybody. And if you disclose your preference to anybody, if you show your ballot paper to anybody, this vote will be declared invalid, which also means that whip is not binding when it comes to presidential election. The whip issued by the political party is not binding in case of president's election because election takes place through secret ballot, which primarily means if a statement is given in your question paper that in the president's election, the members of the electoral college, they vote according to their conscience, not according to the party whip. This statement is correct. Clear? Now listen to me carefully. Election Commission of India, which conducts this election to the office of the president, it has directed that these ballot papers, because I told you EVMs are not used, ballot papers are used. These ballot papers are printed in two colors. This fact can be important for your examination. Two colors. Ballot paper would be green in color, which will be used by the members of the parliament. That means Lok Sabha and Rajya Sabha will use ballot papers printed in green. Similarly, for the members of the state legislative assemblies, including Delhi and Puducherry, the ballot papers would be printed in pink. This is something that can be relevant for your examination. But since I told you that the election of the president is done through proportional representation system, which means population plays a very important role, that is why we calculate value of votes. And previously, such a question has been asked in your examination. That is why it becomes important for your exam. What is the value of vote? How do we calculate the value of a vote of a member of the Legislative Assembly? So, for a member of the Legislative Assembly, the formula that we use is total population of that state divided by total number of elected MLAs into 1 by 1000. But this population figure, this is according to 1971 census. This is not according to the latest census. This is not according to 2011 census. Why? Because the last time when we saw increase in the number of seats in the Legislative Assembly or in the Lok Sabha, that was after the delimitation of 1973. And that delimitation was carried out on the basis of the census of 1971. After that, although delimitation took place in 2002, but we have frozen the number of seats till the census figures after the census of 2026 would be taken into account. That is what it becomes important. But also, value of vote of a member of the legislative assembly, it will vary from state to state because of the population. But the value of vote of an MP of Lok Sabha is equal to the value of the vote of the MP of the Rajya Sabha. That means the value of vote member of the parliament is same, which is arrived at by dividing the total value of votes that we have received here divided by total elected MPs of Lok Sabha and Rajya Sabha. But for this, what is it that you have to keep in mind? Maybe this question can be asked. Maybe because unpredictable service commission. Previously, once this question was asked, maybe it can be asked again. According to population figures, the census figures of 1971, because that census of 1971 figure is used to calculate the value of vote of each MLA in the legislative assembly. And the total value of votes of a state, the highest we see Uttar Pradesh, the second highest Maharashtra, then Bengal, then Bihar. But maybe you may be asked about the lowest value of vote of a state in this president's election. The lowest is Sikkim, followed by Mizoram, and Arunachal Pradesh and Puducherry. They have the same value, 480. May not be asked in the exam, but what if it is asked? Just keep in mind, in terms of the highest value, it is UP at the top, followed by Maharashtra, Bengal, and Bihar. And lowest, Sikkim, then followed by Mizoram and Puducherry and Arunachal Pradesh. Clear? Any issues? No. Okay. Once the President of India is elected, the tenure of the President of India, according to the Constitution, is 5 years. Provided that President may also resign from his office prior to completing 5 year term. And how will the President of India resign from his office? The President resigns from his office by submitting his resignation to the Vice President of India. And listen to me carefully. If a member of Lok Sabha wants to resign, as a member, for example, Dr. Shashi Tharoor might join the BJP, which means first he has to resign. So Dr. Shashi Tharoor will have to submit his resignation to the Speaker of the Lok Sabha, Mr. Om Birla. But it is not binding on Mr. Birla to accept the resignation of Dr. Shashi Tharoor. Mr. Speaker has to first ascertain whether this resignation is voluntary or whether he was coerced or forced into resigning from his seat. Which means only after an inquiry will the Speaker accept the resignation of an MP. But when it comes to the President's resignation, the moment President resigns by submitting his resignation to the Vice President of India, it is binding on the Vice President to accept the resignation. Clear? And the President's office, there may be vacancy not only because of resignation, but also because of impeachment. The President can be impeached. Now, where is this mentioned that the President can be impeached from his office? This is mentioned in the Constitution, but where? It's mentioned in Article 56. But sir, then what is about Article 61? We have read that President can be impeached under Article 61 of the Constitution. Article 61 talks about the procedure that needs to be followed to impeach the President. But Constitution says under Article 56 that the President can be impeached from his office on the grounds of violation of the Constitution. And then the President, this is something called to prevent interregnum. Because I told you under Article 52 of the Constitution, there shall be a President of India, which means this office cannot remain vacant even for a brief moment. Somebody has to occupy this office at all times. And what if the term of the President is 5 years, but we have been unable to conduct election to elect my successor? In that case, despite the fact that my tenure is 5 years, I will still continue to be the President of India even after my tenure is over, till the time my successor is elected, to prevent interregnum, because this office cannot remain vacant even for a brief moment. And at the same time, when I told you that the President can resign from her office by submitting the resignation to the Vice President, what is Vice President going to do with this resignation? Obviously, yes, he has to accept this. His eyes would lit up, because then he will have to occupy the post of the President of India. But he shall have to forthwith, immediately communicate this resignation to the Speaker of the Lok Sabha, informing him that there is a vacancy in the office of the President. Clear? But when it comes to impeachment, although it is mentioned in the Constitution under Article 56 that President can be impeached on the grounds of violation of the Constitution. But what is this violation of the Constitution? It is not defined in the Constitution. Until date, no President of India has ever been impeached. In fact, no process has been initiated either, which means, important statement, neither has any president been impeached from his office, nor has a process been initiated ever to impeach the President of India. But President can be impeached on the grounds of violation of the Constitution, and that procedure is provided under Article 61 of the Constitution. And what is that procedure? This matter can be initiated in either Lok Sabha or Rajya Sabha. That means it is not necessary that we have to initiate this process in Lok Sabha. Although, if you want to contest election to the post of the President of India, you have to be eligible to become the member of the Lok Sabha. But once you are to be impeached, this process can be initiated in either Lok Sabha or Rajya Sabha. How? One fourth of the members. If the process is initiated in Lok Sabha, one fourth of the members of the Lok Sabha will have to write to the Speaker that we want to impeach the President of India for a violation of the Constitution. This is where 14-day notice will kick in. That means Lok Sabha cannot initiate this process, cannot work upon this process unless and until 14-day period is over. After that, there will be voting in the Lok Sabha. If the Lok Sabha passes a resolution by not less than two-thirds of the total strength of the House, which means the toughest majority in the Constitution is required to impeach the President of India. Toughest majority, not less than two-thirds of the total strength of the House. If this motion is passed, then the matter travels to the other house, the Rajya Sabha. And the Rajya Sabha in this case will become the investigative house. The Rajya Sabha will have to investigate these charges which have been leveled against the president, that, dear president, you have violated the Constitution. And here, when the investigation will take place, the president may defend himself or herself. Either the president may defend herself, or the president may ask her lawyer to defend herself before the Rajya Sabha, before the investigating. But can Attorney General for India defend the president when a motion calling for her impeachment is to be decided by the House of Indian Parliament? No. Someone else, some other lawyer recommended by the president, roped in by the president, has to defend the president in the other house. But in this other house also, if it is proven that yes, the president has violated the Constitution because of these reasons, then if Rajya Sabha also passes a resolution by not less than two-thirds of the total strength of the House, then the president shall be impeached forthwith. Immediately, the president is impeached. This process can also become reverse, which means first the matter can be initiated in Rajya Sabha, and then Lok Sabha will become the investigator. These facts are very, very important. Get the conceptual clarity. Now, let's look at the question on your screen. Let me know what is the right answer. In which of the following circumstances can the President of India act in his own discretion without the aid and advice of the Council of Ministers. There is no mention of discretionary power of the president. This much you have to be clear about. But then the president can also use his discretion. His discretion can be in the appointment of the prime minister, because the constitution says the prime minister shall be appointed by the president. But who is this prime minister going to be? That is not mentioned. So, if after the general election there is a hung parliament, no political party has the majority of its own to form the government, in that case, in absence of the clear majority, the president can appoint anyone as the prime minister. But then the prime minister will have to prove his or her majority on the floor of the Lok Sabha, because that is what we call parliamentary democracy. What is parliamentary democracy? Anyone? Parliamentary democracy means prime minister plus council of ministers. They are responsible to, they are accountable to the lower house of Indian parliament, which is the Lok Sabha. So the appointment of the prime minister can be viewed as a discretionary power of the president in case there is no political party which has got the majority. Or dissolution of the Lok Sabha. Normally, Lok Sabha is dissolved by the president on the advice of the prime minister. Because in 1971, when the Lok Sabha was dissolved on the advice of the prime minister, it can be done. Even if the term of the Lok Sabha is still not over, we still have a couple of years. But the president is bound by the aid and advice of the prime minister when it comes to the dissolution of the Lok Sabha. But what if there is no political party which has the clear majority, and we can't appoint a prime minister because nobody is taking claim to form the government? In that case, the Lok Sabha can be dissolved so that it paves way for the conduction of fresh election, the fresh general election. In that case, dissolution of Lok Sabha when no party has a clear majority. Summoning of parliament is not the discretion of the president. Promulgation of ordinances can be done only on the advice of the government. Dismissal of a minister from the cabinet only on the advice of the prime minister, because the constitution says the prime minister shall be appointed by the president, and on the advice of the prime minister other council of ministers shall be appointed by the president, which means we can't even imagine president appointing somebody disregarding the advice of the prime minister. That is something which is not envisaged in the constitution. Clear? Question number 5. Which of the following is not a form of veto power available to the President of India under the Constitution? Absolute veto, suspensive, pocket, qualified veto. Some are saying C, some saying D. Which of the following is not a form of veto power available to the President under the Indian Constitution? Is absolute veto available to the Indian President? Is suspensive veto available? Is pocket veto available? Is qualified veto available? What is the right answer? D. None of these vetoes are available. There is no such thing as veto available to the president. But then, under Article 111 of the Constitution, we talk about assent to bills. When a bill has been passed by the both houses of the Indian Parliament, it is sent to the president for assent. What are the options available with the president? Number one, president may give her assent. When the president gives assent, the bill is passed, it becomes a law. Second, the president may withhold assent. The president may say, I'm not going to sign this bill. I'm not going to give assent to this bill. By public notification, the president will declare, I'm not going to sign this bill. Then what will happen to this bill? This bill will go back to the parliament. That does not mean this is the death of the bill. This is what we call in legal language absolute veto. But does constitution mention absolute veto? No. Does constitution mention veto at all? No. That is why the answer to this question is there is no such veto power available with the president under the Indian constitution. No, zero. And this we can link it to the governor as well. And you might have read about when the president yesterday asked 14 questions to the Supreme Court. Article 143 was invoked. And what is Article 143? The president may refer any matter to the Supreme Court, asking the views of the Supreme Court on this matter. But this matter, and this is what we call a presidential reference, this matter can be either a pre-constitutional matter, that means something which happened prior to the commencement of the Constitution, or it can be a post-constitutional matter. If it's a pre-constitutional matter, it is binding on the Supreme Court to give its advice. But if the Supreme Court says on this matter we have no advice to give, even that statement that on this matter we have no advice to give, this will be viewed as an advice because that is the advice that Supreme Court has given. We asked Supreme Court for an advice on this pre-constitutional matter. Supreme Court is saying on this matter we have no advice to give. We will say that this is your advice, that you have no advice. Okay. But if it's a post-constitutional matter, it is the discretion of the Supreme Court. Supreme Court may or may not give this advice. But it is only advice, which means it is technically not binding on the government. Clear? But sir, why this presidential reference was invoked by the president? For that, we need to understand with respect to the governor, what is this power can be important for your exam because this is a landmark judgment that was given by the court. There is something called Article 200 and Article 201 of the Constitution. What is the difference? I'll change the ink color. Under Article 200, when a bill has been passed by the state legislature, it is sent to the governor. What are the options available with the governor? Governor may either give her assent. The governor will say, okay, I'm signing this bill, bill becomes an act. Or the governor may withhold assent. Previously, we thought that when the governor is publicly declaring by a public notification that I am not going to sign this bill is dead, it can never become a law. But in Punjab case, Supreme Court said no. When the governor publicly declares, I'm not going to sign this bill, that does not mean death of the bill. That means the governor will have to send this bill back to the state legislature for reconsideration. And if such a bill is passed again by the state legislature, it is binding on the governor to accept that bill. When a governor sends the bill back to the parliament, to the legislature for reconsideration, that is what we called suspensive veto, although not mentioned in the constitution. But in legal language, we say suspensive veto when the governor has sent the bill back to the state legislature for reconsideration. But can governor, or for that matter, president, send a money bill back? No. A money bill can be either given assent by the president or the governor, or can be withheld. The assent can be either given or withheld. You can't send a money bill back for reconsideration. But if there is a non money bill, which the governor says, I'm not going to sign this bill, then as soon as maybe, the phrase as soon as maybe, you have to send this bill back to the state legislature for reconsideration. And if the bill is passed again, you have no other option but to sign. But then under Article 201, there is another option available with the governor. What the governor can do, governor can reserve that bill for the consideration of the president. Governor can reserve that bill for the consideration of the president. Then can you tell me what is the option available with the president? President may either give her assent, or the president may withhold assent, or the president will say, "Dear governor, take this bill back to the state legislature, ask them to reconsider." And then the state legislature has 6 months to reconsider that bill. But if the same bill is passed again, what is the option available with the president? Constitution says the president may act accordingly. That means there is no such thing mentioned for the president that now you have to sign it. It is there for the governor, but not for the president. And you may be aware of the controversy in Tamil Nadu, and I don't have to explain that again because this is a revision. But long story short, a two-judge bench of the Supreme Court in Tamil Nadu case now interpreted this phrase as soon as maybe to mean what? Impose time limit. That if there is a bill which is passed by the state legislature, it is sent to the governor. And Council of Ministers advise the governor sign this bill. Governor says, no, I'm not going to sign this bill. You have to say this in 3 months, not more than that. In 3 months, you say, I'm not going to sign this bill. Because when in 3 months you will say, I'm not going to sign this bill, what will happen? This bill will be sent back to the state legislature for reconsideration. Now, when the same bill is passed again, what is the option available with the governor? Governor has 1 month to sign it. Or what governor can do? When a bill is passed by the state legislature, sent to the governor, governor may reserve that bill for the consideration of the president. And Supreme Court has said, dear president, when such a bill has been reserved for you, you consult us. We will tell you whether to sign this bill or not, which was viewed as judicial overreach or judicial adventurism or judicial despotism, as some people would call it. But be that as it may, that is relevant for mains examination, not specifically for your prelims. But time limit has now been prescribed by the Supreme Court. But this phrase, as soon as maybe, has been interpreted by the court to impose time limit, 3 months, 1 month, so on and so forth. It involves interpretation of the Constitution. And Constitution is clear on this. If we need to interpret any provision of the Constitution, that can be done by a 5-judge Constitution bench of the Supreme Court. So if at all you had to interpret this phrase as soon as maybe to impose time limit, 3 months, 1 month, could not have done by a 2-judge bench. Maybe you should have set up a 5-judge bench of the Supreme Court, because it's a constitutional matter, and any matter involving interpretation of the Constitution has to be decided under Article 145, Clause 3 by a constitution bench of the Supreme Court, which should have not less than 5 judges. But be that as it may, the point is, why did the President of India invoke Article 143? There were other options available with the president, or there were other options available with the government. What were the other options? This judgment was given by 2-judge bench. Right or wrong? Right, sir. You're not satisfied with the verdict given by the Supreme Court. What is the alternative? What is the option available with you? Review. File a review petition. But the purpose is, review petition can be filed before the Supreme Court within 30 days of this judgment. within 30 days of this judgment. And who will hear this review petition? The same two judges who heard the original case. And if you are unable to convince them, because a review petition is accepted on two grounds: either you have pointed out an error in this judgment, or new facts have been discovered in this case. If you are pointing out an error or a new fact has been discovered in this case, then the two judge bench will review it and then will hear it again. Will ask the Supreme Court to hear it again. But what if the same bench of two judges say, no, there is no error, no new fact have been discovered, which means your review petition is dismissed. Then what is the other alternative? File a curative petition. And if a curative petition, the success rate of a curative petition is less than 0.5%, which means majority of the curative petitions are dismissed. Which means then the government used the only other option, which means not the review or the curative petition, but used a presidential reference under Article 143. Does that mean if in this presidential reference, the court, 5 judges agree that yes, a two-judge bench should not have done this, Article 142 cannot be invoked in this case, things like that, that does not mean the original judgment will get changed. You still will have to file a separate case to review the original judgment. Clear? Which of the following is not a form of the veto available to the president under the Indian Constitution? Constitution does not talk about veto at all. You may have read in your books that Indian president does not have a qualified veto. That is why I gave this option only 4 as well. But there is no veto whatsoever, according to the Constitution, available for the president. Clear? Very nice. Which of the following statements is or are correct regarding the ordinance making power of the governor of a state? So, president has the power under Article 123 to promulgate ordinances. And the same power is available to the governor as well under Article 213 of the Constitution. Now, can you tell me what is the right answer? An ordinance can be promulgated only when the state legislature is not in session. Correct? The governor, before issuing an ordinance, has to be satisfied of the existence of circumstances rendering it necessary to take immediate action. Is the statement correct or incorrect? This statement is also correct. C, both is the right answer. What does that mean? Listen to me carefully. Under Article 213 or under Article 123 of the Constitution, ordinance making power. And for that, either one or both houses should be prorogued. They should not be in session. Which means if Lok Sabha is in session, Rajya Sabha is not, ordinance can be promulgated. Legislative Assembly and Legislative Council both are in session, you can't promulgate an ordinance. Either one or both houses of the legislature or either one or both houses of the parliament should not be in session. That means this house should be prorogued in order to promulgate an ordinance. Can an ordinance be promulgated to amend the Constitution? Can the president promulgate an ordinance to amend the Constitution? No, this is not the power. Why? Because Constitution is clear that you can amend the Constitution only under Article 360, because that is explicitly provided under Article 13. More specifically under Article 13, Clause 3, that the 13, Clause 2, that the state shall not enact any law to delete, modify, abridge fundamental rights. What is the definition of this law? Is provided under Article 13, Clause 3. Law includes rules, regulations, bylaws, customs, usages, ordinances as well. That means even through ordinance, you cannot amend the fundamental right, which primarily means you can't amend the constitution, which means constitution can be amended only under Article 6(8). And this ordinance can be promulgated only on the advice of the Council of Ministers. That means it is not a discretionary power of the president or the governor. But something was happening in Bihar, and because of that, a landmark case was delivered by the court in 2017, Krishna Kumar Singh. Long story short, what happened is that ordinance was promulgated by the governor, but it was not tabled on the floor of the legislature. Because an ordinance can be promulgated when either one or both houses of the parliament are prorogued, or one or both houses of the state legislature are prorogued, which means maximum validity of an ordinance is what? 6.5 months, because the parliament must meet as often as possible, but in such a manner that the time between the last day of the previous session and the first day of the next session should not be more than 6 months. And once parliament has now been convened or legislature has been convened, within 6 months, within 6 weeks, you have to replace this ordinance with a bill. And when the minister introduces this bill, minister has to tell the legislature what was the tearing hurry to introduce an ordinance, to promulgate an ordinance, why we could not wait for the legislature to convene. And if this bill, which is replacing the ordinance, is not passed within 6 weeks, then ordinance lapses. So, in case of Bihar, 256 times ordinance was promulgated without tabling it on the floor of the legislature. And Supreme Court said in 2017 that promulgating ordinance without introducing a bill in the legislature amounts to committing fraud on the constitution. So you can't do that. And governor, when you have to promulgate an ordinance, you have to be satisfied whether circumstances existed, whether there was an immediate need for such an action. Only then you can promulgate an ordinance. If there was no necessity for an immediate action, we could have waited for parliament to convene. We could have waited for the legislature to convene. We will strike down your ordinance. So both these statements, which means can an ordinance making power of the president or the governor be subject to judicial review? I will give you a simple answer to this question. Anything can come under judicial. Judiciary can review anything, despite the fact that constitution explicitly mentions that there are some things which are beyond the scope of the judiciary, beyond judicial review. Even then, judiciary can review. In fact, I've told you that judicial review as a concept is not mentioned in the constitution. But we trace the concept of judicial review from Article 13 and Article 226 or Article 32 of the Constitution. And this judicial review, Supreme Court has said, is part of the basic structure of the Constitution. Right or wrong? Right. But then Constitution says that when a bill is certified as a money bill by the speaker, this certificate by the speaker is final and binding. Even then, on this there can be judicial review. Because when Aadhaar was designated certified as a money bill by the speaker, matter is before the court. The court will have to decide whether that certificate of money bill for Aadhaar is correct or incorrect, legal, illegal, constitutional, unconstitutional. Similarly, Constitution makes it clear under Article 260 that to adjudicate interstate river water disputes, Parliament can enact a law, and through that law, you can even exclude the jurisdiction of the Supreme Court. Even then, Supreme Court gets involved in interstate river water disputes. So there is nothing, absolutely nothing beyond the scope of judicial review. In fact, we say it's explicitly mentioned in the Constitution that because of the separation of powers, the proceedings of the House are not subject to judiciary. But even then, judiciary can interfere. If the statement is asked, according to constitution, anything can be subject to judicial review, you have to mention that this is an incorrect statement because constitution does not talk about judicial review directly, or not everything is under judicial review because there are some exceptions to the jurisdiction of the court. But according to practice, anything can be reviewed by the judiciary. The answer is yes. Clear? Great. So where was I? Judicial review for the ordinance making power? Yes. If, let's say, for example, Rajya Sabha is in session, Lok Sabha also is in session. Can the president promulgate an ordinance? No, because at least one of the house has to be prorogued, has to be not in session. But it would be constitutional, it would be legal for the president that you can prorogue one house just for promulgating an ordinance. If you want to promulgate an ordinance, but both house of the parliament are in session, you can prorogue one house just to promulgate an ordinance. Can do that, that is legal. And that Supreme Court has said in multiple judgments, it is legal. Clear? In the Indian context, constitutionalism ensures A. Supremacy of the parliament, judicial dictatorship, control over arbitrary power, effective policy making. Let me know what is the right answer. Great. There is no such thing as supremacy of the parliament. Indian parliament is not sovereign. Unlike British parliament, because the British parliament is sovereign. British parliament can do anything. There is no limitation on the powers of the British parliament. British parliament can do anything. So there is no supremacy of parliament in India. There is supremacy of the constitution in India. Constitution is supreme. But what do we mean by constitutionalism? Constitutionalism in simple terms means that the government can and should be legally limited in its powers, and that the legitimacy of this government will depend upon whether it is observing those limitations or not. How do we ensure that the government or the state is limited in its powers? Doctrine of limited government, that the powers available with the government are not unlimited. There is a limitation on the powers of the government. Limitation is popular sovereignty. The ultimate power is with the people. There is a check through periodic elections on the use or misuse of the government power, state power by the state. If it is misusing its power, which means the limits that constitution imposed on the state, it is misusing those limitations, it is violating those powers, then you can vote out that government from power in the next election. So it is through this popular sovereignty, which lies with the people, that we ensure constitutionalism in India. Similarly, through rule of law, anybody can sue or be sued. No one shall be deprived of his life or property except according to the procedure established by law, or except you have violated the law, you have committed the breach of law. If I'm an ordinary person teaching you polity right now so that you are well prepared for the upcoming prelims examination, and suddenly there is knock at my door and the police says, gentlemen, come, we will take you to Siberia, you're under arrest because why are you teaching polity for kids? Now this is a misuse of the power because I have not violated any law. So the rule of law, which is a limitation on the state power, it is getting violated. But we have rule of law because if the government does this, if the state does this, we have independence of judiciary. You will go to the court, my lord, our teacher has been arrested, keep him behind bars, but only after 25th of May. Till then, let him teach us. After that, do whatever you have to say. And by the way, if we clear prelims, then you have to release him on parole to finish his conquer beans. After that, take him again. Constitutionalism, long story short, means that the government can and must be, should be legally limited in its powers. And the legitimacy of the government will depend upon whether it is observing those limitations. So, through this constitutionalism, what we can ensure control over the arbitrary power of the state, because state cannot arbitrarily pass laws or make rules depriving people of their right to life and personal liberty. So C is the right answer. Okay, very good. Which of the following thinkers? There was once, I think it was 2012, when a question was asked on dialectical materialism. Dialectical materialism can be viewed from the writings of which of the following thinkers? And if you are a student of political science, sociology, or for that matter, any discipline, you would know that we are talking about Karl Marx. Talks about dialectical materialism. Maybe since a lot of talks have been going on constitutionalism over the past 1.5 years, which of the following thinkers is closely associated with the development of modern constitution? What's the right answer? Marx, Locke, Rousseau, Hegel. Constitutionalism, this modern constitution, can be seen through the writings of American political scientist John Locke. So B is the right answer. Clear? Then there is a lot of talk. In fact, there was a question in CDS examination as well related to totalitarianism. Hannah Arendt, I think it was in 1951. Yes, I've mentioned it here. The origins of totalitarianism. She has emphasized that this is not only the extreme authoritarianism. What is a totalitarian regime? It controls every aspect of your life. In a sense, what you wear, what you eat or drink, who are you talking to, what is the profession that you can prophesize. It controls every aspect of your life. You may not even have freedom of speech and expression. So the kind of totalitarian regime that we saw was depicted by George Orwell in his famous novel 1984. That's a totalitarian regime. The big brother is watching you. Hannah Arendt writes that totalitarianism strives not only to dominate political life but to control the inner life of citizens, making them mere functions of the state. So you're normally, what we say in a liberal society, what you do in your private life, that is none of the business of the state. The state can't enter the private bedroom of citizens because that's the private space where the state should not be present. State has to be absent there. But in a totalitarian regime, not only your political aspect, but your inner life is also controlled and dictated by the regime. So there is crippling impact on your freedom of speech and expression. So you should know what is a totalitarian regime. So you can't think of totalitarian regime as something which is good for freedom of speech and expression. If you have never encountered this term, maybe you get a sense that totalitarian regime means something that a government which works for the totalitarian society, for the total well being of everybody. No, it's a repressive regime. Let me know what is the right answer. Which of the following statements best describes a characteristic of a totalitarian regime? Totalitarian regime encourage freedom of speech and independent media. No, they will restrict it. Totalitarian regimes, political opposition is tolerated and often encouraged. No, political opposition is evaporated. Totalitarian regime exert extensive control over all aspects of citizens' lives, including political, social, and cultural activities. You're right. Let's look at that fourth statement because you should read all the statements. Totalitarian regimes prioritize decentralization of power, ensuring checks and balances within the government. Why would a totalitarian regime do this? Totalitarian regime would encourage centralization of power. So it is C, the right answer. Right? Great. Let's look at another question. According to the Constitution, when there is a vacancy in the office of the President and the Vice President, then the Chief Justice of India shall act as the President of India. Justice Hidayatullah is the only citizen in independent India to have held the positions of Chief Justice, Vice President, and Acting President of India. President is elected by an electoral college consisting of elected members of both House of the Parliament and state legislative assemblies. Let me know what is the right answer. Sir, how can you mention such a statement? By that logic, should we remember all these personalities as well and their contribution? There was once a question asked, I think, a couple of years ago, that Shri Devi Lal in 1991 contested election from three constituencies. So sometimes this bouncer is also thrown at you by the UPSC, right? According to Constitution, when there is a vacancy in the office of the President and the Vice President, then Chief Justice of India shall act as the President of India. This statement is incorrect because this is not according to the Constitution. This is according to the law passed by the Parliament in 1969 called the President Discharge of Functions Act 1969. Because Constitution says President, and if the President is not there, then the Vice President will act. What if Vice President is also not there? This is a contingency, and to address this contingency, Parliament enacted a law in 1960. Statement 1 is incorrect. Was Justice Hidayatullah the only citizen in independent India to have held the positions of Chief Justice, Vice President, and Acting President of India? Is yes. Third statement can be confusing for you. President is elected by an electoral college consisting of elected members of both Houses of the Parliament and State Legislative Assembly. Sir, this is wrong. No, this is correct. But, sir, what about elected MLAs of Puducherry and Delhi union territories? That is not mentioned here. Is the statement incorrect? No. The statement can become incorrect if I use the term only. If I would have mentioned that president is elected by an electoral college consisting of only elected members of both houses of the parliament and state legislative assemblies, then it would be incorrect. But this is not incorrect because the term only is not there, which means it includes Delhi and Puducherry as well. Done? So 2 and 3, C is the right answer. Let's look at another question. The oath or affirmation by the president is mentioned in the third schedule of the Constitution. If a motion calling for the impeachment of the president is moved in the House, the same House shall also investigate the charges against the president. If both houses of the parliament pass a resolution approving of impeachment of the president, then the president stands impeached at the expiry of the 14 days of the passage of that resolution. Which of these statements are correct? Almost a tie between A and D. The oath or affirmation by the president is mentioned in the third schedule of the Constitution. This is incorrect. Why? Because it's not mentioned in third schedule. It is mentioned in the text of the Constitution itself. The oath of president, the oath of vice president, the oath of the governor is mentioned in the text of the Constitution itself in their respective articles. Whereas the oath for a candidate to contest election, the oath of the judge of the Supreme Court or High Court, the oath of the CEG, the oath of the Prime Minister, although not directly mentioned, the oath of the Minister, the oath of the Minister of State, all these are mentioned in the third schedule of the Constitution. But the oath of President, Vice President, Governor is mentioned in the text itself. If a motion calling for impeachment of the House is moved in a House, then the same House, no, the other House becomes the investigative House, which means, and we have discussed this previously, if the motion is introduced in Lok Sabha, then Rajya Sabha acts as the investigation house. If both houses of the parliament pass a resolution, then the president is impeached forthwith, which means immediately. You don't have to wait for 14 days to impeach the president. How many such statements is or are correct? D. None of these statements are correct. D is the right answer. Okay? Lovely. Now, Constitution also talks about vice president. And for vice president, what do we know? We know that there are two important roles assigned to the vice president by the Constitution. One is that you are act as the ex officio chairman of Council of States, which is the Rajya Sabha. And second, whenever there is a vacancy in the office of the President of India, you have to act as the president. Act for how much time, how many years, how many months, till the successor is elected. These are the only two roles prescribed by the Constitution for the Vice President of India. Which means, is the Vice President of India member of the Rajya Sabha? He is not. Vice President of India is the ex officio chairman of Council of States. Despite the fact that you are not a member of Rajya Sabha, you preside over Rajya Sabha because you are the Vice President. And in absence of the President, when there is a vacancy in the office of the President, the Vice President will act as the President of India till the successor is elected. And how is this Vice President elected? The Vice President is also elected by the people, but not directly, indirectly, through their representatives in Electoral College. And who all are part of the Electoral College? Members of both Lok Sabha as well as Rajya Sabha. Which means, are nominated members also part of the Electoral College to elect the Vice President of India? Yes. In case of President, only the elected members. In case of Vice President, all the members of Lok Sabha and Rajya Sabha, which means nominated members as well. Clear? But in order to be eligible to contest election to the post of the Vice President of India, what are the qualifications required? You have to be the citizen of India. You must have completed 35 years of age. You should not be holding any office of, but at the same time, you should be eligible to become a member of Rajya Sabha. Very important fact. In order to contest election to the post of the President of India, you have to be eligible to become the member of Lok Sabha. But for the Vice President, you have to be eligible to become the member of the Rajya Sabha. And if you are qualified, then you can contest election. Once you are elected, your term is 5 years. If your term is 5 years, that doesn't mean you can remain in office for all these years, which means you can also resign before completing this term. And how will Vice President resign? By submitting resignation to the President, which means President and the Vice President, they resign by submitting their resignation to each other, and it is binding on both these entities to accept their each other's resignation. Clear? You may also be removed. But what are the grounds on the basis of which the Vice President can be removed? These grounds are not mentioned in the Constitution. Grounds for removal or the impeachment of the President is mentioned, a violation of the Constitution. But grounds for the removal of the Vice President is not mentioned. And this can be important for this year's prelims exam because we saw a campaign launched by the opposition. They wanted to remove the Vice President of India. And they gave various reasons because he's partisan, he's this, and that. But the grounds specifically are not mentioned in the Constitution. That means on any ground, he can be removed. Grounds are not mentioned. But when we look at the Constitution, it says that your term is 5 years. But even before completing 5 years, you may resign by submitting your resignation to the President. or you may be removed as well. Who has the role in the removal of the Vice President of India? Is the role available only to the Rajya Sabha, or does Lok Sabha also have a role? Rajya Sabha, Lok Sabha both have a role. But this process can be initiated only in the Rajya Sabha. For president's impeachment, the process can be initiated in either Lok Sabha first and then Rajya Sabha, or first Rajya Sabha, then Lok Sabha. And in case of vice president, this process can be initiated only in the Rajya Sabha. And once the Rajya Sabha passes a resolution, and what is the majority required to pass that resolution? That majority is what we call, yes, effective majority. Not simple majority, effective majority. Because constitution says majority of all the then members of the council. That is what we call effective majority. And once the Rajya Sabha passes a resolution by effective majority, then this resolution has to be accepted by the Lok Sabha. And Lok Sabha will have to pass this resolution by simple majority. And once Lok Sabha also passes this majority, this is what we call agreed to by the House of the People. When we say agreed, that means majority is simple majority in Lok Sabha. Clear? And once both the houses pass this resolution, the vice president is impeached forthwith. Vice president is removed forthwith, not impeached, because impeachment is the term that we use only for the president of India. There was a question that a student had asked me um, in my Telegram group, I think. Does vice president also continue to remain in office till the time his successor is elected? Yes. Vice president shall, notwithstanding the expiration of his term, because the term is 5 years, you will continue to hold office unless and until the successor enters office, unless and until your successor is elected. That is something that you have to be clear about. Okay? Done? So, this is related to the Vice President of India. And Vice President of India, as I told you, the oath of President, Vice President, Governor is provided in the text of the Constitution itself. The oath which is administered to the President, he takes or she takes the oath to defend the Constitution. But Vice President takes the oath that I will bear true faith and allegiance to the Constitution, and I will faithfully discharge the duty about which I am about to enter. The Vice President does not take the oath to defend the Constitution. That is the difference that you have to keep in mind. If at all there is a challenge to the election of the President or the Vice President, for example, I told you about P.A. Sangma wanted the courts to disqualify Pranab Mukherjee because he was holding an office of profit when he contested the election. That was his allegation. Such a case can be filed only in the Supreme. That means all the matters relating to the election of the president or the vice president can be filed only before the Supreme Court. And the Constitution says the decision of the Supreme Court shall be final and binding. Clear? That is related to the Vice President of India. Now, let me know the answer to this question. The union ministers hold office during the pleasure of the Prime Minister. There is no provision in the Constitution which makes the President answerable to the Parliament for the acts of the government. While in India, the Prime Minister can be a member of either House of the Parliament. In England, the Prime Minister shall be a member of the lower house of the British Parliament. Which of these statements is or are correct? The union ministers hold office during the pleasure of the Prime Minister. This statement is incorrect. They hold office during the pleasure of the President. And this is what we call doctrine of pleasure, which means Council of Ministers That is what we call parliamentary democracy. Very important term. Multiple times has been asked in your prelims examination. Council of Ministers are collectively responsible. This is what we call collective responsibility. Are collectively responsible to Lok Sabha, the lower house of the Indian Parliament. That is why, if there are some motions such as confidence motion, such as no confidence motion, such as censure motion, such as adjournment motion, all such motions can be introduced only in Lok Sabha, cannot be introduced in the Rajya Sabha, because it is through these motions that you hold the Council of Ministers accountable to and responsible to Lok Sabha. But if Council of Ministers are collectively responsible to the Lok Sabha, they also have individual responsibility. And individually, they are responsible to the President of India through this doctrine of pleasure. Because I told you, Constitution says under Article 74, there shall be Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall act on that advice. Then the same Constitution says Prime Minister is appointed by the President. And on the advice of the Prime Minister, other Council of Ministers are appointed by the President. Which means, although you are appointed by the President, but only on the advice of the Prime Minister, that does not mean constitutionally you are holding office during the pleasure of the Prime Minister. Although that is the fact itself. De facto, you are holding office because of the pleasure of the Prime Minister. But according to the law, you are holding office during the pleasure of the President. And at any point in time, the President can say, I am revoking, withdrawing my pleasure, and I'm removing you from the Council of Ministry. But President can do that only on the advice of the Prime Minister. Without that advice, no. The Union Ministers hold office during the pleasure of the Prime Minister. This statement is incorrect. There is no provision in the Constitution which makes President answerable to the Parliament for the acts of the government. Yes, there is no such provision. You can hold government accountable to the Parliament, but you can't hold President accountable to the Parliament. Because President is not acting on her own. President is acting on the advice of the Prime Minister and Council of Ministers. Hold them accountable to Parliament, not the President. While in India, the Prime Minister can be a member of the either house. This is correct. 2 and 3. B is the right answer. In India, the Prime Minister can be either from Lok Sabha or Rajya Sabha. For example, we have the Prime Minister now who is from Lok Sabha. Previously, we had Dr. Manmohan Singh who was from Rajya Sabha. Indira Gandhi, in her first term, she was from Rajya Sabha. Shri Deve Gowda was from Rajya Sabha. So it is that the Prime Minister can be either from Lok Sabha or Rajya Sabha. But in case of Britain, in case of UK, the Prime Minister necessarily has to be the member of the lower house of British Parliament, which is what we call House of Commons. Clear? Great. According to the Constitution, which of the following is not the duty of the Prime Minister vis-a-vis the President? Let me know in the comment section what is the right answer. To communicate to the President all decisions of the Council of Ministers relating to the administration, submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. To communicate to the President any legislative proposal she may call for, to communicate to the President the steps being taken by the Union in a state where there is breakdown of constitutional machinery. What's the right answer? B, D. According to the Constitution, to communicate to the President all decisions of the Council of Ministers relating to administration, this is the duty of the Prime Minister towards the President. You have to communicate. Now, a decision has been taken by a minister to submit for the consideration of the Council of Ministers. Any decision which has been taken by a minister, but council has not taken a decision together, but minister has taken that decision. The president will submit it to the council. Please take this decision, consider this decision because the minister has taken the decision, but I want you together to consider it. To communicate to the president any legislative proposal she may call for. After Operation Sindoor, you must have read that Prime Minister went to President because she is the supreme commander of Indian Armed Forces and communicated to her what happened, exactly what happened. Because you have to keep her informed because she's the de jure head of the state. And any legislative proposal she may call for, you have to communicate it to the president. But this is something which is not mentioned in the constitution. To communicate to the president steps being taken by the union in a state which is under where there is a breakdown of constitutional machinery. So C3 statements are correct. Because here in statement number 4, the approach is from the president. President receives a report from the governor of a state that in our state there is a breakdown of constitutional machinery. And then the report is sent to the president. President is asked, please impose president's. And then the president refers this matter to the cabinet, asking the cabinet, what should I do with this report of the governor? Should I impose president's rule under Article 356 or no? So C, 3 statements is the right answer. Now, according to constitution, which of the following is not the duty? So these 3 are the duties. This is not the duty. So the real answer then becomes A. Only one statement. A is the right answer. That means only one statement. 4th statement is incorrect. Other statements are correct. Question number 14. According to the Constitution, the President appoints the Attorney General for India for a period of 3 years. The remuneration of the Attorney General for India is determined by the Parliament. According to the Constitution, the Attorney General for India resigns on the resignation of the Council of Ministers. Constitution talks about Attorney General for India, I think under Article 76 of the Constitution. Who is this Attorney General? We say he is the foremost law officer of the country, law officer of the union, the topmost lawyer of the government of India. It is this Attorney General who represents the union government whenever a case against union government is filed in the courts. And it is the responsibility of this Attorney General for India to defend the union government in the courts, to give legal advice to the government, and to appear before the Supreme Court in an Article 143 reference. Because I told you, when these 14 questions have been asked by the President to the Supreme Court may set up a 5-judge bench of the Supreme Court to hear this presidential reference. Who will present the viewpoint of the central government before the Supreme Court under Article 143 reference? That will be the Attorney General for it. And we say Attorney General is the chief advisor, legal advisor of the government of India. But who is this Attorney General going to be? Attorney General for India is appointed by the President, but obviously President does not have a discretion. President appoints somebody as the Attorney General who is recommended by the government, recommended by the Prime Minister. And this Attorney General should be somebody who is qualified to be appointed as the Supreme Court judge. Mind you, Attorney General should not be the Supreme Court judge. Because under Article 50 of the Constitution, we say that there shall be separation of powers between the executive and judiciary. Attorney General is part of the executive. How can somebody who is part of the executive at the same time be also part of the judiciary? That's not possible. That would be violation of Article 50. But you have to be qualified to be appointed as a Supreme Court judge. And what is the qualification required for someone in order to be appointed as the Supreme Court judge? You have to be the citizen of India and judge of one or more high court for 5 years, or advocate in one or more high courts for 10 years, or in the eyes of the president, you should be a distinguished jurist. That means you have to be necessarily the citizen of India. And if you are a citizen of India, you should be the judge of one or more high courts for 5 years. If not, citizen of India and advocate in one or more high courts for 10 years. If not, citizen of India, and in the eyes of the president, you should be a distinguished jurist. These are the qualifications required for someone in order to be appointed as the Supreme Court judge. And these qualifications are required for someone in order to be appointed as the Attorney General for India. So, in order to be appointed as the Attorney General for India, you should be qualified to be appointed as the Supreme Court judge. And normally, this Attorney General is appointed for 3 years, but that is not mentioned in the Constitution. Normally, this Attorney General is appointed for 3 years, but that is not mentioned in the Constitution. According to the standard practice, Attorney General is appointed for 3 years, which can be extended also. And this term is on the basis of doctrine of pleasure, which means you will remain in office as long as you enjoy the pleasure of the President of India, which means at any point in time you can be removed as well. And this Attorney General for India is allowed private practice. Apart from defending the union government in the courts, you can also do private practice as well. You can also take criminal cases. But to take up criminal cases, you need prior approval of the President of India. And as the Attorney General, you have all the immunities, all the privileges which are available to MPs. These privileges are available to you as well. What are these privileges basically? Which means you can attend a parliamentary session, which means you can speak in parliament, which means you can attend it as well, which means you can be a member of any parliamentary committee. But the only thing that you will not have, you don't have voting rights. You can't vote in the parliamentary committee. You can't vote in the Lok Sabha or the Rajya Sabha because you are not a member of the parliament. But you have the privilege because all the privileges which are available to the MPs, these are available to the Attorney General as well, which means you can speak in the parliament, you can be present in the parliament, you can be a member of any parliamentary committee without any right to vote. What is the question asking you? According to Constitution, the President appoints the Attorney General for India for a period of 3 years. This is not mentioned in the Constitution. This is according to the standard practice because Constitution says Attorney General is appointed by the President and remains in office during the pleasure of the President. The remuneration of the Attorney General is determined by the Parliament. No, the remuneration is determined by the President, not the Parliament. According to Constitution, the Attorney General for India resigns on the resignation of the Council of Ministers. This is incorrect. Which of the given statements are incorrect? D. All these statements are incorrect. D is the right answer. Because this is not according to Constitution, this is according to convention, parliamentary traditions. Because if I am appointed as the Attorney General by the President to defend this central government before the court, tomorrow if there is a change in the central government, a new political party forms the government, I offer my resignation. That is a tradition, that is a convention, but it is not according to the Constitution. Clear? Very good. Question number 15. Which of the following statements is or are correct regarding a president's address? You would know that there is something called president's address. What is this president's address? The president will address both houses of the Indian parliament together. When? After the general election and first session of each year. And this is something that we have borrowed from United Kingdom, because the king or the queen in United Kingdom also addresses both houses of the British Parliament after every general election. And then every year, the first session of every year is addressed by the president, addressing both houses of the Indian Parliament. And what does president mention in that speech? The text of this speech is provided by the cabinet. Basically, what is going to be the objective of this government in the coming future? What are we going to achieve? What are the legislative proposals that we want to introduce? What have been our achievements? It is basically a political speech given by the president, because the text of the speech is provided by the cabinet. And once president gives this address, then there is general discussion on this president's address, both in Lok Sabha as well as Rajya Sabha. And then there is voting as well. And this voting is what we call vote of thanks on president's address. If this vote of thanks is passed in Lok Sabha by simple majority, because this president's address should be passed by simple majority, there is no threat to the government. But if Lok Sabha, while voting on this president's address, is not passing this president's address by simple majority, it amounts to what we call censure of Council of Ministers. Which means then we can assume that maybe the Council of Ministers, they have lost the confidence of the Lok Sabha. Which means then what the government has to do? Government has to drop everything and immediately introduce confidence motion in the Lok Sabha, because we can sense that you have lost the confidence of the Lok Sabha because you don't have simple majority. Which means you can run the government only as long as you have the majority in the Lok Sabha, and we assume that you don't have the majority. So drop everything else, introduce a confidence motion. If that confidence motion is passed by simple majority, you will continue. Otherwise, you have no other option but to resign. But the defeat of this president's address in the Rajya Sabha will have no bearing on the stability of the union government, because Council of Ministers collectively are responsible to, accountable to Lok Sabha, not to the Rajya Sabha. Right or wrong? Right. But look at the question on your screen. Which of the following statements is or are correct regarding a president's address? And a session of Lok Sabha is not prorogued after being adjourned sine die and subsequently reconvened to meet in the next calendar year. The president is not required to address both houses of parliament assembled together. Members who have not made and subscribed the oath or affirmation are not admitted to the venue of the address. I will add this statement under any circumstance. Tell me, what is the right answer? I'll give you 1 minute because this looks like maybe you have not read it anywhere. I'll give you 1 minute. Think about it and let me know what is the right answer. When a session of looks, because what did I tell you? President's address is after general election, there is president's address, president addressing both houses of the Indian Parliament. Then there is first session of every year. But for that, necessarily the session should have been prorogued because if the winter session of 2025 was not prorogued, which means it was adjourned sine die, and you know, adjournment sine die does not prorogue the session, does not terminate the session, does not end the session. Which means if the same session is convened again in the next calendar year, it won't be a budget session. It would be the continuation of the winter session. So it is not the first session of the new year, which means it is the old session. In this case, it is not mandatory for the president to address because it is not the new session or the first session of the next year or the next calendar year. It is the continuation of the previous session. So when a session of Lok Sabha is not prorogued after being adjourned sine die and subsequently reconvened to meet in the next calendar year, the president is not required to address both houses of the Indian Parliament. This is correct. Members who have not made and subscribed, because you are addressing both houses of the Indian Parliament, which means members of both houses of the Parliament. And you would know unless and until you have taken oath as the member, you cannot sit in the Parliament. You cannot participate in the proceedings of the Parliament. So, members who have not made and subscribed the oath or affirmation are not admitted to the venue under any circumstance. This is incorrect, which means the answer is A, only one. I am a newly elected MP of Lok Sabha or Rajya Sabha, and there is a joint address or the president's address. And in this venue, I want to be present, but I have not subscribed to oath. Then what will I do? I can still be admitted to this venue if two things are met. One of the two things are met. One is if I can show the election certificate. When I won the election, the returning officer who returns the winner gives me a certificate certifying that you have won the election from this constituency. If I can bring that election certificate, I will be admitted to this venue. Second, even if I don't have an election certificate, but I have Modi ji with me, Modi ji will tell somebody, no, admit him because he has also won the election. Even in absence of election certificate, if another member of the parliament vouches for my authenticity, that yes, this person has been elected recently, but he has not taken oath, even then I can be admitted to this venue. So when the statement says members who have not made and subscribed the oath or affirmation are not admitted to the venue under any circumstance. No, there are two circumstances. Even if you have not been administered oath or office or affirmation, you can still be part of this president's. Only one, A is the right answer. Let's look at another question on the screen. Under the Indian Constitution, addition or removal of a committee, a cabinet committee, is the prerogative of. It is not just Mr. Modi, it can be any member of the parliament who can vouch for me. Under the Indian Constitution, addition or removal of a cabinet committee is the prerogative of the Prime Minister. How many cabinet committees do we have? We have 8 cabinet committees. These cabinet committees, some facts you have to remember, these are not mentioned in the Constitution, which means these are extra constitutional bodies. or extra constitutional committees? Right? Right. But these are mentioned in rules of business and procedure. Cabinet committees can be broadly divided into two. Either these are standing or these are ad hoc. Ad hoc means for time period. For example, in 1962, a cabinet committee on war was constituted when there was India-China War of 1962. But once war got over, this cabinet committee was dissolved. But then there are cabinet committees, standing committees. For example, 8 such committees that we have: Appointments Committee of the Cabinet, Cabinet Committee on Accommodation, Cabinet Committee on Economic Affairs, Cabinet Committee on Parliamentary Affairs, Cabinet Committee on Political Affairs, Cabinet Committee on Security, Cabinet Committee on Investment, Cabinet Committee on Employment and Skill Development. These are the 8 cabinet committees. And the last two committees, which I mentioned, these were added in 2019. Otherwise, till 2019, we had 6 committees. In fact, during Manmohan Singh's time, we had 13 cabinet committees. So, what is the number of cabinet committees? That is the prerogative of the Prime Minister. There are some questions, some facts related to these cabinet committees. Stay with me for 10, 15 more minutes. After that, I will give you a break. Then we will shift to another segment. But stay with me for the next 15 minutes. Very important questions. Very, very high likelihood of these questions asked in the exam. Which of the following is or are the functions of the Appointments Committee of the Cabinet? Take a look at the statement on the screen and let me know what is the right answer. Appointments Committee of the Cabinet, there are two members. One is the Prime Minister, the other is the Home Minister. Important appointments which are to be made above the rank of Joint Secretary and above, these have to be cleared by the Appointments Committee of the Cabinet. Now, which of the following is or are the functions of the Appointments Committee of the Cabinet? To decide all cases of disagreement relating to appointments between the cabinet department concerned and the UPSC. For example, UPSC has recommended these appointments. The department related, concerned department disagrees with the UPSC. Then in such case, who has the final say on this matter? The final say is with the Appointments Committee of the Cabinet. To determine the guidelines or rules and terms and conditions to govern out of turn allotment of government accommodation. This is not the role of the Appointments Committee of the Cabinet. This is the role of the Cabinet Committee on Accommodation. And Cabinet Committee on Accommodation is headed by not the Prime Minister, headed by the Home Minister. To decide upon temporary upgradation of post to the level of Joint Secretary and above. If you want to upgrade a post to the rank of Joint Secretary or above, that is also to be decided by the Appointments Committee of the Cabinet. These facts are important. Just remember, these facts can be relevant for your exam. Nominating an executive director to the International Monetary Fund. Is this correct or incorrect? This is correct. 134D is the right answer. This was in the news recently. Why? Because India's representative, the executive director at the IMF, who was previously the chief economic advisor of the finance ministry, he had still 6 months left for his job, but then his job was terminated. Why? Because it is alleged that there was some corruption involved. For example, he is also an author. and he got a book published from the Rupa publication, and then a Union Bank of India ordered lakhs of copies worth 7.5 crores of this book written by the former chief economic advisor. So some form of quid pro quo, whatever. And basis that, the government terminated his appointment as the executive director of the International Monetary Fund, IMF. Because IMF, you would know, they have these representatives who are nominated by the governments. Um, so, nominating the executive director to the IMF is also the responsibility and function of the appointments committee of the cabinet. 134 is the right answer. Right? The appointments committee of the cabinet deals with the appointment of which of the following posts? Let me know what is the right answer. The appointments committee of the cabinet deals with the appointment of which of the following post? If you have to appoint a solicitor general, for example, Tushar Mehta, he is to be reappointed. The announcement has to be made by the appointments committee of the cabinet. Similarly, various additional solicitor generals. Attorney General for India? No, that's not the job of the appointments committee. It's appointed by the president. So is the governor of a state, appointed by the president. Appointments committee has no role there. Governor of the Reserve Bank of India or the deputy governor of the Reserve Bank of India? Yes. Appointment of the army chief, service chiefs. These are the recommendations. These are the functions of the appointments committee of the cabinet. 1 and 4. B is the right answer. Clear? Very good. Which of the following is or are the functions of the cabinet committee on parliamentary affairs? Cabinet committee on parliamentary affairs previously headed by home minister. Now it is headed by defense minister. Which of the following is or are the functions of the cabinet committee on parliamentary affairs? To scrutinize and to consider the attitude of the government on non-official bills and resolutions to be presented to parliament, whether on this private member's bill, we as part of the ruling party, whether we should vote in favor or against. What should be our attitude to this non-official, which means private members bill? That's the domain of the cabinet committee on parliamentary. To review legislations undertaken by the state legislatures from all India point of view. What do you think of this statement? Is it correct or incorrect? That bills are passed, laws are passed by the state legislatures. But it is this cabinet committee on parliamentary affairs which will review these bills, these laws, from the all India perspective to see whether it makes sense for the national unity or not. Is this the statement? This is correct. This is according to the Cabinet Committee on Parliamentary Affairs. This is according to the Cabinet Secretary website. This is correct. To consider proposals to summon or prorogue the House of Parliament. Yes, because we say the Parliament is summoned by the President. The President has the power to summon the Parliament, or the President has the power to prorogue the sessions of the Parliament. But that is done on the advice of the Prime Minister and Council of Ministers. And in specific sense, technically, it is done on the basis of the recommendations of the Cabinet Committee on Parliamentary Affairs, which is now headed by the Defense Minister. Clear? Question number 20. To deal with the problems relating to center state relations, to consider economic and political issues that have to be judged with a wider perspective, to deal with policy matters concerning foreign affairs that do not have external or internal security implications. Which of the above is or are the jurisdiction of the Cabinet Committee on Political Affairs? Cabinet Committee on Political Affairs is also known as the Super Cabinet, a powerful cabinet committee headed by Prime Minister. Let me know what is the right answer. I'll give you one more minute. Jurisdiction of Cabinet Committee on Political Affairs. Deal with problems relating to center state relations, correct? To consider economic and political issues that have to be judged with a wider perspective. Sir, shouldn't that be the job of Cabinet Committee on Economic Affairs? But we're also talking about political issues, which have to be viewed from a wider perspective. For example, if there are elections in Bihar and we have to give more funding to Bihar, wider perspective we have to look at. That will be decided by Cabinet Committee on Political Affairs. To deal with policy matters concerning foreign affairs that do not have external we have to deal with a foreign country, and the relationship with that foreign country has nothing to do with our internal or external security. How should we deal with that foreign country? What should be our relationship? On all these political matters, we have the super cabinet called Cabinet Committee on Political Affairs. So, one, two, three, all of the above is the right answer. Okay, great. To deal with all defense related issues, all defense related issues, to deal with issues relating to law and order and internal security, to deal with policy matters concerning foreign affairs, this time have internal or external security implications, to deal with economic and political issues impinging on national security. Which of the above is under the jurisdiction of the Cabinet Committee on Security? Cabinet Committee on Security, headed by the Prime Minister, and includes four top ministers: Minister of Home Affairs, Minister of Defense, Minister of Finance, and Minister of External Affairs. These are the four top ministers who are part of this Cabinet Committee on Security, headed by the Prime Minister. What is the right answer? To deal with all defense related issues, that's the job of the Cabinet Committee on Security. In fact, if you have to make defense purchases whose value is more than 1,000 crores, for that, you need the prior approval of the Cabinet Committee on Security. For example, we have to buy more Rafale jets from Dassault in France. For that, the first approval has to come from Cabinet Committee on Security. Then a contract can be signed. To deal with issues relating to law and order, internal security, what is the situation in internal security because of Operation Sindoor and because of the aggression by Pakistan. For that, we saw CCS meeting recently. To deal with matters related to foreign affairs, how should we deal with Pakistan? Because the relationship with this foreign country has an implication on our internal security. Who took the decision that we will keep Indus Water Treaty in abeyance? CCS. To deal with economic and political issues impinging on national security, we have an economic issue through trade. We are going to stop trade, direct, indirect trade with Pakistan. CCS takes the decision. D, all of the above is the right answer. Okay, great. Let's look at another question on your screen. The Prime Minister is the chairperson of which of the following funds? National Defense Fund, PM National Relief Fund, Prime Minister Citizen Assistance and Relief in Emergency Situations Fund, known as PM CARES, and CAMPA, Compensatory Afforestation Fund Management and Planning Authority. What is the right answer? National Defense Fund was established in 1962 to provide funds for defense related for people and their families who are working in the defense sector. Prime Minister National Relief Fund started in 1948 with the appeal made by the Prime Minister, the then Prime Minister Pandit Nehru, who invoked people and said, there are migrants who are coming from Pakistan to India. We want you to contribute for their well being. For that, Prime Minister's National Relief Fund was established, which was found wanting. And that is why during COVID 19 in 2020, Prime Minister announced another fund for COVID and those who are affected by COVID called PM Cares. So all these are headed by the Prime Minister. But Campa is not headed. C only 3 is the right answer because this is something which was directed by the court in very famous Goda Varman case, which was in the news of 2002. It is under Ministry of Environment, Forest and Climate Change because you have to compensate for example, this is a forest area or this is an area where you have to construct a factory or an industry and you want to cut the trees. For that, you have to provide compensation, compensatory afforestation. For that, there is a bill which is, for that, there is this fund which is placed in the public account of India. This Campa fund. And it is under Ministry of Environment, Forest and Climate Change. It is not headed by the Prime Minister. So 1, 2, 3, C only is the right answer. Clear? Okay. Now let's look at few other aspects of executive, and now we are moving towards the state executive. Do we need a break? I don't need a break, but I just don't want an overdose for you. Do you need a break? Yes, no? How many minutes? 1 minute break? Okay. Let's take a break for 30 minutes. Or let's first discuss governor and council of ministers for some time and then I will give you a break. Okay? Just stay with me. Constitution says that the governor is the constitutional head of a state. Can a same person be appointed as governor to more than one state? Yes. Although this was not originally part of the constitution, but it was added later through 7th Constitutional Amendment Act 1956. So there has to be a governor for every state. This governor is appointed by the president, although it is not mentioned in the constitution, but is appointed by the president on the recommendations of the prime minister. Is there a term mentioned for the governor in the constitution? The governor is appointed by the president, but he holds office during the pleasure of the president. But ideally, this term is for 5 years. And this 5 year term is provided in the constitution. Sir, what are you trying to say? I'm saying for every state, there is a governor who is the constitutional head of that state. But can the same person be appointed as governor to more than one state? Yes. That is something which is provided because of 7th Constitutional Amendment Act 1976. And remember, 7th Constitutional Amendment Act led to the states reorganization. Because at that time, we had Part A, B, C, D territories. Because of the 7th Constitutional Amendment Act, because of the States Reorganization Act, which was passed in 1956, Part A, B, C, D territories were done away with, and then it led to the emergence of 14 states and 6 union territories. Clear? So when the states were reorganized in 1956, that is when the need was felt that maybe the same person can be appointed as the governor to more than one state. So this was done in 1950. But this governor is appointed by the president. And according to the constitution, the term of the governor is 5 years. But this 5 year term is subject to doctrine of pleasure, which means at any point in time, the governor can be removed or governor can be transferred, which means this governor does not have security of tenure. Right or wrong? Right. But what is the qualification required for someone in order to be appointed as the governor of a state? Constitution mandates only two qualifications. One, this person has to be the citizen of India. If you are a citizen of India and you must have completed 35 years of age. These are the only two qualifications mentioned in the Constitution for someone to be appointed as the governor of a state. Yes, there are conventions. Conventions means unwritten rules that in order to be appointed as the governor to a state, the chief minister shall be consulted. Or in order to be appointed as governor to Karnataka, you should not be a resident of Karnataka, but this is something which is not mentioned in the Constitution. These are conventions, unwritten rules which have evolved over a period of time. But what is the constitutional function of this governor? Constitutionally, Article 163, for example, it says there shall be a council of ministers headed by the chief minister to aid and advise the governor. Who shall act on that advice? Except when this governor has to act in his discretion. So, the statement that I had mentioned when we were discussing the office of the president, that was basically the statement with respect to the governor. There shall be chief minister, council of ministers, aid and advise the governor, who shall act on that advice, except when the governor has to act in his. But what are these discretionary powers not defined in the constitution? But constitution does say something which is often not understood by people or overlooked by people, is that constitution says that if at all there is a dispute as to what constitutes the discretionary power of the governor, the word of the governor shall be final, which means the governor, according to the constitution, gets to decide what are my discretionary. Go to the Supreme Court will say, we will tell you what are your discretionary powers because of ABC reasons that we will discuss in mains exam. So discretionary powers are not defined in the. And similarly, just now I recalled, I told you about Article 200 previously, that whenever a bill has been passed by the state legislature, it is sent to the governor. What are the options available with the governor? Governor may either give assent, governor may withhold assent and then send the bill back, or governor may reserve the bill for the consideration of the president. There are two things. One, the Supreme Court has clarified that there is no such thing as pocket veto. Pocket veto is alien to Indian constitutional scheme, according to the Supreme Court. Number one. Number two, when governor has a discretion that the governor can reserve any bill for the consideration of the president. In one instance, it is mandatory, not discretion. That means necessarily, mandatorily, the governor has to reserve this bill for the consideration of the president. Which is that bill? If that bill threatens, or should we say endangers, the powers of the High Court. So there can be one bill, any bill, and there is another bill which threatens or endangers the powers of the state High Court. These bills can be reserved by the governor for the consideration of the president. This is the discretion of the governor. But this is not the discretion. If the governor thinks, feels that this is a bill which threatens, endangers the status of the High Court, it is mandatory for the governor to reserve this bill for the consideration of the president. The governor cannot use his discretion here. You have to necessarily reserve this bill for the consideration of the president. And then president will decide how to deal with it. But for example, I want to be a governor, and I am appointed as the governor of Tamil Nadu, for example, how I wish. I cannot be the member of either house of parliament. I cannot be the member of any legislative assembly or legislative council. But even if I am, then the moment I am appointed as the governor and I have taken oath as the governor of that state from the chief justice of that high court, it shall be deemed that I have vacated my seat in the parliament or state legislature. Which means, long story short, if I am a member of Karnataka Legislative Assembly or Legislative Council, or I am a member of the Lok Sabha or the Rajya Sabha, now President says, on the advice of the Prime Minister, that you are appointed as the governor of Tamil Nadu, replacing Mr. Ravi, although I am a member of the legislature. But when I take the oath as the governor of Tamil Nadu, the moment I take oath, it shall be deemed that I have vacated my seat in the parliament or state legislature. That means it is not necessary that first I have to resign as a legislator and then be sworn in as the governor of that state. No, this fact is very, very important, can be relevant for your exam. Clear? Great. Similarly, when it comes to state machinery at the state level, I will take 10 more minutes. After that, I will give you a break. Just 10 more minutes. Stay with me. When it comes to state machinery at the state level, the state executive, it consists of governor, chief minister, council of ministers, and the advocate general of a state. This advocate general of a state is similar to the attorney general for India at the union level, but with some difference. Difference in the sense, this advocate general is appointed by governor on the advice of the chief minister, holds office during the pleasure of the governor as well. But this advocate general should be qualified to be appointed as a high court judge. In order to be appointed as the attorney general for India, you should be qualified to be appointed as the judge of the Supreme Court. But in order to be appointed as the advocate general of a state, you should be qualified to be appointed as the judge of the high court. And what is that qualification? You have to be the citizen of India, and you have to be an advocate in one or more high courts for 10 years. If not, you must have held a judicial office for 10 years. Maybe you can be a district judge for 10 years, then you are qualified to be appointed as the high court judge, which means these are the only qualifications required for someone in order to be appointed as the judge of a high court, which means for a high court judge appointment, there is no concept of distinguished jurist. Which means if you are a distinguished jurist, you are directly eligible to be appointed as the judge of the Supreme Court. But in order to be appointed as the judge of the High Court, you should be the citizen of India and you must have held a judicial office for 10 years. If not, citizen of India and advocate of one or more high courts for 10 years. Primarily means if you are a citizen of India and you have been an advocate practicing in one or more high courts for 10 years, which means you are eligible to be appointed as the advocate general of a. That's the difference. Clear? Any questions related to executive? I will give you 5 more minutes. If you have any questions, then we will take a break and then we will meet after the break. Any questions related to executive, any question related to president, vice president, prime minister, council of ministers, attorney general for India, cabinet committees, governor, chief minister, council of ministers, advocate general of the state, any questions, let me know. Can president or governor modify the speech drafted by the government? We have seen that unfortunate event in case of governors of opposition ruled states. When you say can, yes. In fact, there have been instances where the governor has refused to even give any speech which is prepared by the cabinet, or you have skipped some portions mentioned by the government. For example, the governor Ravi of Tamil Nadu skipped portions relevant, which related to Periyar, related to Dr. Ambedkar, related to Karunanidhi in the address which was prepared by the Tamil Nadu cabinet. So, can governor does this? Can governor do this? Yes. But should governor do this? That's a separate matter altogether. Can an ordinance be passed when the Lok Sabha is dissolved? Yes. Can governor pardon a death sentence? Governor cannot pardon a death sentence. What governor can do? Governor can commute a death sentence, which means convert a death sentence into life imprisonment. Sir, what about Solicitor General? Solicitor General, any advocate, senior advocate, can be appointed by the government, cleared by the appointments committee of the cabinet as the advocate, as the Solicitor General. There are so many questions. I think I need to check my phone. Does whip system apply to motion or vote of thanks? Yes. Conventionally, can a private member introduce a bill since Raghunath did the same? Can a private member introduce a money bill? Yes. 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 Can president declare war? Only president has the power to declare war and conclude peace. When vice president acts as the president on that time, vice president's seat vacant? Yes. Can president reject or withhold a constitutional amendment bill? No. Previously, he could have done that, but the constitution was amended in 1971, 24th Constitutional Amendment Act. The president shall give assent to a constitutional amendment bill. That means there is only one option available with the president with respect to a constitutional amendment bill, which is to give assent. But from one state to another. In that case, does he serve the full term or the remainder of the term? Once you're appointed, you can be for 5-year term, or you can be removed at any point in time, or you can be transferred at any point in time. So you hold office during the pleasure of the president, although technically you should be there for 5 years. Sir, a person of a state can be appointed as the governor of the same state? Yes. And we have seen instances in Jammu and Kashmir, in Karnataka, the resident of these states were appointed as the governors. Okay, so that is it for now. We will take a break, and this break will be till we will resume at 7 p.m. 40-minute break is my dinner time as well. I finish dinner before 7 o'clock, and you can also follow the practice. 7 p.m. till 7 p.m. Let's take a break and let's meet at 7 p.m. See you on the other side of the break. Take Welcome back, and let's look at union legislature as well as state legislature. Clear? Let's first look at union legislature. At the central level, we have the parliament, and parliament consists of president, Rajya Sabha, and Lok Sabha, which means you have to keep in mind that the president is an integral part of both union executive as well as union legislature. But at the state level, when we look at state legislature consists of governor, again, who is an integral part of both state executive as well as state legislature. We have legislative council in some states, and we have legislative assembly. Right or wrong? Right. When it comes to Rajya Sabha, we say Rajya Sabha has some elected MPs as well as nominated. How many nominated members do we have in Rajya Sabha? 12. These are nominated by the president from the fields of art, literature, science, social service. And in order to be elected as the member of the Rajya Sabha, what is the qualification required? You should be the citizen of India. You must have completed 30 years of age. And you should be a registered voter in any parliamentary constituency in this country. Which means even if you are a registered voter in Karnataka, but you can contest Rajya Sabha election from the state of Assam. When it comes to Lok Sabha, we have only elected MPs. There used to be two nominated MPs in Lok Sabha as well. These two nominated MPs were nominated by the president. From which category? Anglo-Indian community. Because the constitution said if the president is satisfied that the Anglo-Indian community is not sufficiently represented in Lok Sabha, then the president could have nominated two members from Anglo-Indian community to Lok Sabha. But this reservation for Anglo-Indians, it was stopped, not extended to 104th Constitutional Amendment Act. Which means you need to understand that in Rajya Sabha, there is no reservation for SCs and STs. But in Lok Sabha, there is reservation for SCs and STs. And it is this political reservation for SCs and STs which was meant to expire 10 years from the commencement of the Constitution. But each time this 10-year period got over, Constitution was amended, and this reservation for SCs and STs was extended by another 10 years, then another 10 years, then another 10 years. And right now, if a question is asked, this political reservation for SCs and STs would end in 2030. In 2030, then, another constitutional amendment needs to be passed if the government wants to further extend the political reservation for SCs and STs in Lok Sabha. In the Rajya Sabha, the election takes place through proportional representation system, which means from a particular state, how many MPs would there be in the Rajya Sabha? Where is it mentioned? This is mentioned in Schedule 4 of the Constitution. So Schedule 4 talks about representation of states in Rajya Sabha. So 31 MPs in Rajya Sabha will be from Uttar Pradesh, 19 from Tamil Nadu, 11 from Andhra Pradesh, 7 from Telangana, Where is it mentioned? It is mentioned in Schedule 4 of the Constitution. And from every state, these MPs would be elected, Rajya Sabha MPs would be elected based on the system of proportional representation system. But in this proportional representation system, we use a concept called open ballot. Open ballot in the sense that means whenever as an elector, as a voter, when you have to vote, because MLAs vote to elect MPs to Rajya Sabha, and when these MLAs have to vote, they have to show it to their political party that look, we are voting for the representative of our political party. But again, what about the whip under anti-defection law? Because we know under anti-defection law, if you violate the whip issued by the political party, you can be disqualified under the provisions of the 10th schedule of the Constitution. But this whip does not apply to Rajya Sabha elections. Can anybody tell me in the comment section why does the whip not apply in case of Rajya Sabha elections despite the fact that elections take place through open ballot? Why? Very good. Because the election to Rajya Sabha is not considered as the proceeding of the House. Because the whip is issued and is binding only with respect to the proceeding of the House. For example, in terms of no confidence motion, annual financial statement, which is the budget. In all these matters, the whip becomes binding because the whip is issued for the proceeding of the House. But election or voting for Rajya Sabha elections, when MLAs vote to elect Rajya Sabha MPs, this is not considered as the proceeding of the House, and as such, whip is not binding in case of Rajya Sabha election. But then, sir, something happened in Himachal Pradesh when six MLAs belonging to the Congress, they did not vote for their nominee Abhishek Manu Singhvi when it comes to the Rajya Sabha election, and basis that they were disqualified. Yes, they did not vote for Congress nominee, which is Abhishek Manu Singhvi, but it was not on this reason, on this ground, that they were disqualified under anti-defection law. These six MLAs belonging to Himachal Pradesh Legislative Assembly, they were disqualified because they violated whip, which was issued for the passage of annual financial statement, which means budget. So when the whip was issued by Congress to its MLAs that you have to vote in favor of this annual financial statement, which is the budget, and they violated that whip, they abstained from the voting. It was on the grounds of violating the whip issued with respect to the budget. That is why these six MLAs were disqualified from Himachal Pradesh Legislative Assembly. Not because they voted against their nominee when it comes to the Rajya Sabha election. That's something that you have to keep. And you have to also remember that these Rajya Sabha MPs, one third MPs retire every 2 years. This is to ensure the permanent nature of Rajya Sabha, which means Rajya Sabha is the permanent house of Indian Parliament. When we say it is the permanent house of Indian Parliament, that means it is not subject to the dissolution of the Rajya Sabha. Rajya Sabha is the house which cannot be dissolved. It's the permanent house of Indian Parliament. And this Rajya Sabha, it has got some special powers. Can anybody tell me what are the three special powers of Rajya Sabha? One special power is under Article 67, Clause B, which means for the removal of the Vice President of India, this process can be initiated only in Rajya Sabha. That's the special power of the Rajya Sabha. Then Article 249. What is Article 249? If Parliament has to legislate, make a law on any item mentioned in the state list, then such a law cannot be passed by the parliament unless and until Rajya Sabha passes a resolution by two-thirds of the members present and voting, saying it is a national interest that parliament enacts a law on state list. This cannot be done without Rajya Sabha passing a resolution under Article 249. And third, Article 312. Article 312 talks about creation of a new All India service. Who can create a new All India service? Anybody? Who can create a new All India service? Who has the power? A new All India service can be created only by the Parliament. But Parliament cannot create a new All India service without Rajya Sabha passing a resolution under Article 312 of the Constitution. Facts are very, very important for your prelims. And when it comes to Lok Sabha, these Lok Sabha MPs, they are elected on the basis of first past the post system, where the entire country is divided into constituencies, territorial boundaries, 543 constituencies. And from every constituency, one MP will be elected to the Lok Sabha based on first past the post system, which means whoever gets the highest number of votes, not the majority votes, highest number of votes. Majority votes means more than half. That's not required. You need to get more than anyone else. You need to get the highest number of votes. And then you are elected to the Lok Sabha from a particular constituency. And at the same time, what is the qualification required for someone in order to become the member of the Lok Sabha? You should be the citizen of India. You must have completed 25 years of age. And you have to be a registered voter in any parliamentary constituency of this country. Clear? This is related to the Lok Sabha. And Lok Sabha also has got some special powers. Can anybody tell me what are the special powers of Lok Sabha? Special powers, which means such powers are not available to Rajya Sabha, but these powers are available to Lok Sabha. What are the special powers available with Lok Sabha? Number one, money bill can be introduced only in Lok Sabha. Financial bill can be introduced only in Lok Sabha. When it comes to motions such as no confidence motion, censure motion, adjournment motion, these are the motions that can be introduced only in Lok Sabha. And most importantly, motion calling for the revocation or discontinuance of what? National emergency. When national emergency is imposed, although it is imposed by the president on the recommendations of the cabinet, on the written advice of the cabinet, but if Lok Sabha does not want this national emergency to continue, then under Article 352, Clause 8, a special session of Lok Sabha can take place. And if in this special session a motion has been passed by simple majority, then it is binding on the president to revoke national emergency. And this simple majority resolution is what we call statutory resolution. Clear? These are the facts that you have to keep in mind. But when we look at the state legislature, governor is an integral part of the state legislature as well as the state executive. But we may have legislative council as well. Legislative council where? Right now there are six states: Andhra Pradesh, Telangana, Maharashtra, Bihar, Uttar Pradesh, and Karnataka. These are the six states where we have a legislative council. But can you tell me what is the composition of Legislative Council? What is the strength of the Legislative Council? That is something which is not mentioned in the Constitution. What Constitution does talk about, it talks about a range. Range in the sense that minimum we can have 40 MLCs, maximum we can go up to, and this is one of the questions which was previously asked in one of the prelims examination. Minimum we can have one third of the Legislative Assembly. That means Legislative Council will have minimum of 40 MLCs and maximum it can go up to is one third of the strength of the Legislative Assembly. That's the range provided for a Legislative Council. Similarly, for a Legislative Assembly also, there is a range. And the range is minimum we can have 60 MLAs and maximum we can go up to is 500 MLAs. Right? But if you want to become a member of Legislative Assembly of UP, you have to be a registered voter in UP. If you want to become a member of the Legislative Council in Karnataka, you have to be a registered voter in any constituency in Karnataka. And in this Legislative Council, some MLCs are elected by MLAs. Some MLCs are elected by local bodies. Some MLAs are elected from graduate constituency. Some MLCs are elected by teachers constituency. And some MLCs are nominated by the governor. From which field? From the field of art, literature, science, social service. Cooperative service is a term that is used, or cooperative movement, which means the governor, on the advice of the chief minister, can nominate MLCs to the Legislative Council, those who have made beautiful contribution in the field of art, literature, science, social service, cooperative movement. This is something that you need to know regarding Legislative Council. Clear? Very good. Now, in order to become the president of India, you should also not be holding office of profit. In order to become the vice president, you should not be holding office of profit. In order to become the MLA or an MP, you should not be holding office of profit. Not just that. If you are holding office of profit before election, you cannot contest election. That means you are not qualified to contest election. But what if prior to election, you were not holding office of profit? But after election, now you are holding office of profit. Even then, you will be disqualified. That is why look at the constitution. A person shall be disqualified for being chosen, which means this is a qualification to contest election. You cannot even be chosen if you are holding office of. And for being, even if you are chosen, you are elected. Now you are the member of the parliament or member of the legislature or president or the vice president. You cannot continue in these offices if you are holding office of. But what is this office of profit? Remember, this phrase is not defined in the Constitution. What is this office of profit? This phrase has not been defined in the Constitution. But what does Constitution say? A person shall be disqualified for being chosen as and for being a member of either House of Parliament or either House of the State Legislature if you are holding office of other than that office which Parliament has declared by law that you will not be disqualified even if you are holding this office. But what does that mean? That means this. Although I will not go too deep into the details because I'm sure you are aware of it, the landmark case related to Jaya Bachchan. Jaya Bachchan, when she was disqualified from Rajya Sabha on the grounds of holding office of profit. Why? Because she was the member of the Rajya Sabha and at the same time she was the chairperson of the UP Film Development Corporation. And that's how she was disqualified. And in that case, Supreme Court said that there are four things that we have to prove. First, we have to prove that you are holding an office. How can we prove that you're holding an office? Supreme Court said office is an office if it has an independent existence. Conceptually, if you want to understand, do we have strict separation of powers between executive and legislature in India? No. Why? Because we are a parliamentary democracy. And in a parliamentary democracy, executive is drawn from the legislature. If it's a presidential system, in presidential system, there is strict separation of powers between executive, legislature, and the judiciary. President Trump, he is head of the US executive, but is he part of the legislature? No. Can they be part of the judiciary? No. There is strict separation of powers between executive, legislature, and judiciary when it comes to a presidential democracy, presidential form of government. But when it's a parliamentary form of government, there is no strict separation of powers between executive and legislature. Although in India, we have a strict separation of powers between executive and judiciary. And that is something Article 50 talks about, which is a directive principle that the state shall provide for a strict separation of powers between executive and the judiciary. But if you are asked that even if we are a parliamentary democracy where executive is drawn from legislature, but even then there is separation of powers, one small grain of separation of powers between executive and legislature, and that is through office of profit. Which means if you are a legislator and you are holding an office under the executive, you should be disqualified. Why? Because as a legislator, if you are holding office under the executive, there will be a clash between your duty and your interest. This conceptual understanding is very important because as a legislator, I have a duty. Duty is not only to make laws, duty is to hold executive accountable, to keep a check on the executive. But if I'm holding an office under the executive, how can I keep a check on the executive? Because I will be under the influence of the executive. So there is a clash between your duty to keep a check on the executive and your interest, which is to get some benefit from the executive. That is why, to ensure that the duty and interest do not clash, that is why Constitution provides that if a legislator is holding any office under the executive, you should be disqualified. And even before election, if you're holding an office under the executive, you cannot even contest election. And that is what Constitution says. If you are holding office of profit under the executive, you will be disqualified. But if you are holding certain offices which are exempted from disqualification, which means even if as a legislator you are holding these offices, you will not be disqualified. Why? Because Parliament by law has enacted a law, and through this law, it has exempted that the holders of these offices shall not be disqualified for holding office of. And for that, we have this landmark judgment of the court, 2006, Jaya Bachchan versus Election Commission of India. And Supreme Court said, first thing that we have to prove is that you should be holding an office. And what is an office? Office is an office which has an independent existence. Jaya Bachchan was asked, Madam, come here. Why are you saying that you should not be disqualified? Said, so what? I am holding office of the UP Film Development Corporation, but I'm not taking any benefit. I'm not drawing any salary. I don't even take the bungalow which is attached to this office. I live with Amitabh Bachchan. You know, we have a bungalow at Juhu. Jaya Bachchan was told that you are holding an office. For that, we have to see whether this is because you should be not holding office or profit. For that, we need to first prove that you're holding an office. And court said an office is an office if it has an independent existence. Jaya Bachchan was told, Madam, tomorrow if you die, will this office of the UP Film Development Corporation also die, collapse? I said, what are you saying? Why do you want me to? Not saying you should die. May God give you 1,000 years on this planet. But just hypothetically, if you die, will this office also collapse with you? No. Someone else will occupy this office, which means this office has an independent existence. The existence of this office is not dependent upon the holder of this office. If you are removed tomorrow, someone else will occupy this office. If you resign from this office, someone else will occupy this office. So this is an office because this office should have an independent existence, independent of the holder of this office. Second, this should be office of profit. Said, but this is not an office of profit because I don't draw any salary. Supreme Court said profit does not only mean in terms of monetary compensation. What we need to understand, it should be in terms of pecuniary benefit. Pecuniary benefit in the sense, even if you are not drawing any money, drawing salary, compensation, but you're still under the influence of the executive. Executive still has power over you, which means it is clashing with your interest and duties. You're holding office of profit. And then this office should be under the government, whether government of India or government of a state. Which means if you are an MP of Rajya Sabha, but at the same time you are holding an office of profit, but it is your own office. You are the chairman of United Breweries. You are the chairman of Z Telefilms. You are the chairman of Hindustan Times. That does not disqualify you for holding office of profit because that is not an office of profit under the government. But even if you are holding an office, which is office of profit, which is under the government, but this office Parliament has placed under a law which prevents disqualification. For example, when Jaya Bachchan case came to light, Sonia Gandhi was also accused of holding office of profit. That Madam Gandhi, you are the member of the Lok Sabha from the Raebareli constituency, but at the same time you are the chairperson of the National Advisory Council. Since you are holding this office under the government, which is office of profit, you should be disqualified. Then she resigned. By the time she came back, this parliamentary law was amended and National Advisory Council was placed in this exemption list, which means tomorrow, if somebody, for example, Sonia Gandhi, comes back to parliament, gets elected to Lok Sabha, but then is appointed as the chairperson of the National Advisory Council, you will not be disqualified because this office, although it is an office of profit under the government, but since this office has been placed under a law passed by the parliament in the exemption list, you will not be disqualified, even if you are the holder of this office. This question was once asked in your prelims examination. Office of profit is defined in the constitution. It's not defined. Office of Profit Act has been amended 5 times. Yes. For example, what is this law? This law is what we call Members of Parliament Prevention from Disqualification Act. 1959. Although originally it was passed in 1957, but that law was repealed. The new law in 1959 was passed. This law is famously known as Office of Profit Law. And this law was last time amended in 2006. Which means what? I'll give you a few examples. A legislator should not hold office under the executive. If you're holding office under the executive, you should be disqualified? Yes. But what if we have S. Jaishankar, who is a legislator, Rajya Sabha MP, but he is also a minister? Should he not be disqualified then? He will not be disqualified. Why? Because any office held by a minister is exempt. So a legislator can be a minister as well. You will not be disqualified. A legislator can be a minister of state, not disqualified. A legislator can be a deputy minister, not disqualified. Rahul Gandhi is a legislator from Raebareli constituency in Lok Sabha from UP, but he is also holding another office, and the office is that of leader of the opposition in the Lok Sabha. Even then, you will not be disqualified. Why? Because the leader of the opposition in parliament, both Lok Sabha as well as Rajya Sabha, exempt from disqualification. Similarly, office of the deputy chairman of the planning commission. Similarly, office of each leader and each deputy leader of a recognized party or a recognized group in either house of the parliament. Because in parliament, Lok Sabha, for example, if the leader of the opposition is Rahul Gandhi, the deputy leader of the opposition, the deputy leader of the Congress party is Mr. Gaurav Gogoi, the son of former Assam Chief Minister Tarun Gogoi from Assam. even then you will not be disqualified, although you are holding an office of the deputy leader of a recognized party or a group in the parliament. You will not be disqualified. Similarly, if you are the chairperson of National Advisory Council, if you are holding office of chief whip, deputy chief whip, or a whip in the parliament, or even that of a parliamentary secretary, long story short, some offices have been established as an exemption to office of profit, which means even if a legislator is a chairperson of National Commission for Minorities, you will not be disqualified. Even if a legislator is chairperson of National Commission for Scheduled Caste, National Commission for Scheduled Tribes, you will not be disqualified. And recently we have seen Sachin Pilot previously, he was also recruited in the Territorial Army. Anurag Thakur, former INB minister, captain of the Territorial Army. Even if you are holding office or a member of any force which is maintained under NCC or the Territorial Army, even if you are a legislator, you will not be disqualified. This act can become important for your exam. Here, done. Now, there is something else. Office of the leader of the opposition in news and can be important for your examination. Leader of the opposition, we have leader of the opposition, or we can have leader of the opposition in either house, which means both Lok Sabha as well as Rajya Sabha can have a leader of the opposition. But who is this leader of the opposition? You might have read about Rahul Gandhi could not become leader of the opposition in 2014 because Congress had less than 1/10 of the seats in Lok Sabha. Because Congress party got 44 seats in 2014, then 52 seats in 2019. And in both these terms, in the 16th and the 17th Lok Sabha, we did not have a leader of the opposition. But when I will show you this slide, you will see that there is no such mention of this 1/10 of the Lok Sabha seats, not mentioned anywhere. What this law says, this is a law which was passed in the year 1977. According to this law, member of the Council of State or member of the House of the People who is leader in that house of that party in opposition, which has the greatest numerical strength. Greatest numerical strength. So this term becomes important. This phrase becomes important. So any leader of the opposition political party which has the greatest numerical strength, there is no mention of 1/10 of the seats. Any leader of an opposition political party which has the greatest numerical strength and as such is recognized by the speaker. So the speaker should recognize somebody who has the greatest numerical strength in the Lok Sabha. Chairman has to recognize the leader of that party in opposition which has the greatest numerical strength. It is not mentioned anywhere that this party should have more than 1/10 of the seats in that house. The only requirement is you should be in opposition. You should be the leader of the party in opposition. It should have the greatest numerical strength and it should be recognized by the speaker for Lok Sabha, by the chairman for. And if you are recognized as such, you will become the leader of the opposition. But, sir, I have a question. What is the question? Sir, if there are two political parties in opposition, which has the equal numerical strength, in that case, who will be the leader of the opposition? Again, it will be decided by the speaker. But the speaker will decide on the basis of the status of that party, which means if Trinamool Congress as well as Congress has the equal number of seats in Lok Sabha, 99, for example, the leader of which political party will be recognized by the speaker as the leader of the opposition? It will be the Congress. Why? Because Congress is a national political party. Trinamool Congress is not. Congress is an old political party. Trinamool Congress came out of the Congress, is the result of Congress because Mamta Didi, she split from Congress and created her own political. Where is it mentioned? It is mentioned anywhere? is mentioned in the explanation to this law called the Salary and Allowances of the Leaders of the Opposition in Parliament. This law was enacted in 1970. And leader of opposition has a very important role to play. Where in some committees, which are these committees? Sir, if we have a leader of the opposition, does that mean Rahul Gandhi will draw the salary as leader of the opposition as well as the member of the Lok Sabha? No. Why? Because no leader of the opposition who is receiving salary under this 1977 law can receive another salary which is given to the members of the parliament. So you can't take two salaries. That much is certain, that much is clear. And even as a minister, you can't take salary as a minister and as well as the member of the parliament. You have to take one. Although, if such a statement is asked, you might think that politicians are greedy, they will take both the salaries, but it looks arbitrary. So you have to be clear that that's not the case. The point is, leader of the opposition has a role in the appointments of various constitutional functionaries. That is why he is part of various selection committees for the appointment of chief election commissioner and election commissioners, the director of enforcement directorate, ED, Lokpal, Central Vigilance Commission. The leader of the opposition plays a very important role. That is why you have to remember that leader of the opposition is not a constitutional post, it is a statutory post defined under this 1977 law. And there is no such thing as 1/10 requirement. What the law says, greatest numerical strength and recognized as such by the speaker or the chairman. And at the same time, you can't draw multiple salaries. The salary will be only of that of leader of the opposition. And you are part of very important selection committees for the appointment of the CEC and election commissioners, CVC, Director of the Enforcement Directorate, Lokpal, in fact, CBI Director as well. PAC, this is where the misconception is that leader of the opposition is also part of is the chairman of the Public Accounts Committee. Is that correct? Is that correct or not? I was going through various websites as well. These websites, some of them also mention that leader of the opposition is the chairman of the Public Accounts Committee. Is it correct or incorrect? No. A member of the opposition is the chairman of the Public Accounts Committee by convention. But that does not mean leader of the opposition in Lok Sabha is the chairman of the Public Accounts. Right now, the chairman of the Public Accounts Committee is Mr. Venugopal, who is very close associate and confidant of Rahul Gandhi, the MP from Kerala in Lok Sabha, but he is not the leader of the opposition. So somebody from opposition, anybody from opposition can be the chairman of the Public Accounts Committee, but that does not mean necessarily leader of the opposition has to be the leader of chairman of the Public Accounts. Okay, great. Then we have whips. We have chief whip. We have assistant whips as well. So what is the role of this whip or manager? And I will give you a simple story and you would be in a position to understand. First thing, important for your prelims. Is there any parliamentary law which talks about the status of these whips or chief whip? Yes. Which is that law? The law which was passed in 1990. What does this law talk about? Leaders and chief whips of recognized political parties and groups in Parliament Facilities Act. Facilities in the sense we have to give them office, we have to give them support staff. What facilities will be provided to the leaders Leaders means leader of the house, which we will discuss later after this. And whips. For that, there is this law which was enacted in 1990, right? But what is this whip? Floor manager. In a sense, I am from the BJP, for example, not from BJP, for example. I am from the BJP. I was given ticket by the BJP to contest elections. I got elected. And now I am a member of the Lok Sabha. Who gave me the ticket? BJP. How do I know whether I have to vote in favor or against the Waqf bill? Can I vote on the basis of my conscience? Or will I vote basis on the directive given by the party? I have to abide by the party. What is the position of my political party on this particular bill? Somebody has to communicate this to me. And who is that somebody? That person is the floor manager known as the whip. So every political party has its own whip to manage their MPs so that this whip can be a link between the party leader and the MPs, legislators, so that I can get in touch with party leader, and through party leader I can tell my people what should be your responsibility role on this. For example, it was in the news recently when on Waqf bill, amendment bill, there was confusion amongst the members of the BJD, Biju Janata Dal. There was no whip issued because the party said you vote according to your conscience. Then MP started meeting Naveen Patnaik. There is this confusion. We need a strong whip. The whip was not involved in this matter. He did not tell us what is the party line, what should we vote on this particular matter, how should we vote. That is the responsibility of the whip. But more importantly, that's what I said. Every political party has a chief whip and has assistant whips as well. So that in absence of the chief whip, who is going to communicate the party line? But for the ruling political party, it becomes important. From the ruling political party, who is the whip? The chief whip of the ruling political party is the Minister of Parliamentary Affairs. The Minister of Parliamentary Affairs is the chief whip of the government, and he is directly responsible to the leader of the house. Who is the leader of the house? He will have leader of the house in the Rajya Sabha. We will have leader of the house in Lok Sabha as well. Who is the leader of the house in Rajya Sabha? Prime Minister. If he is an MP of Rajya Sabha, else a senior minister. Who is the leader of the house in Lok Sabha? Prime Minister, if Prime Minister is the member of the Lok Sabha. Else, a senior minister. Sir, what is the role of this leader of the house? I will tell you slightly later, but here we are focusing on whip, which means all the MPs of the BJP. How will they get to know whether they have to vote in favor of Waqf bill or against? Whether they have to vote in favor of this particular resolution or against? Whether there is a private member's bill which has been introduced, whether we should vote in favor or against. For that, the Minister for Parliamentary Affairs is the chief whip of the government, and he closely is responsible to the leader of the house, which means the prime minister, so that from the party we get to know how to vote on a particular. And we say this chief whip is the eyes and ears of the leader of the party. He conveys the wishes of the leader to the members of the party and keeps the leader informed of the current opinion in the party. Because there has to be a link between party and its legislators. And then this chief whip is assisted by various assistant chief whips as well. But then, sir, what is the leader of the house's role? The most important, or one of the most important committee in parliament is called the BAC, Business Advisory Committee, which is headed by the chairman of Rajya Sabha, which is headed by the speaker of the Lok Sabha in Lok Sabha, which means Lok Sabha will have its BAC, Rajya Sabha will have its BAC. Business Advisory Committee. What is the business of the parliament? Today, we have to discuss these bills, these motions, these resolutions. This is the business of the House. Which bill will be taken up on what day? How much time to be allocated to this particular bill? Who gets to speak for how much time for this particular bill on this particular bill? That's decided by the BAC. And in UK, Prime Minister is part of the BAC. But in India, Prime Minister is not part of the BAC. Although you are the leader of the House, you are not part of the BAC. Who represents you in the BAC? Minister for Parliament. This you won't find in any book. I've carefully selected this from various books. When I say you won't find it any book, normally the books that you read, the Lakshmi Kants, the D.D. Basus, Subhash Kashyap and others. The leader of the Lok Sabha, which means the Prime Minister, he never sits in the Business Advisory Committee. In Lok Sabha's Business Advisory Committee, he is represented by the Minister of Parliamentary Affairs. But Prime Minister, if he was a member of the Rajya Sabha, which means you are the leader of the House in the Rajya Sabha, till 1996, you were, as a Prime Minister, part of the BAC in the Rajya Sabha. But since 1996, it is a practice that the leader of the Rajya Sabha is never a member of the Business Advisory. But in Rajya Sabha, if a senior minister is the leader of the House, he is invited to attend the meetings of the Business Advisory Committee, but as a special. And this topic, leader of the House, becomes important. I think becomes important this. Why? Because when there was ruckus, pandemonium in the parliament, in the Lok Sabha, members of the opposition alleged that speaker has been disrespected. Imagine opposition saying speaker has been disrespected. And Rahul Gandhi stood up in the Lok Sabha and said, Speaker, you have been disrespected. You are the leader of the House. To which the Speaker, Mr. Om Birla, replied and shot back and said, I'm not the leader of the House. Prime Minister is the leader of the House. The leader of the House is important for this year's examination. If the paper setter also follows parliamentary proceedings the way I do, then it becomes important. So, what is the position of this leader of the House? He shapes the course and content of legislation because he is the final voice. Whether this private member's bill which has been introduced, whether we should support this bill or not, that leader of the House decides. Any change in a government bill, leader of the House decides. And leader of the House is sometimes called up by the members of the Lok Sabha to speak when there is a disagreement between Lok Sabha and Rajya Sabha. So who will speak in one voice as the voice of the Lok Sabha when such a disagreement takes place between Lok Sabha and the Rajya Sabha? That person is the leader of the House. That is why he enjoys a very important position in our parliamentary convention. Clear? Okay. Whip is present in anti-defection law, or is it a mere convention? Whip is mentioned in anti-defection. How? Because in anti-defection law, we say that a member of a house belonging to a political party can be disqualified if you voluntarily resign from your party. Number one. Number two, if you vote in contravention of the whip issued by the political party. In contravention means it's not necessarily that you vote against your party whip. Even if you go contrary to the party whip, because party whip says you vote against, but instead you abstained, you can be disqualified. The only exception or safeguard here is If you vote in contravention of the whip issued by the political party, then political party has 15 days. 15 days to decide whether we agree with your violation or not, whether we condone your violation or not. If you are okay with you violating the whip, then no action will be taken. But after the expiry of 15 days, if my political party has not condoned my violation of the whip, then I will be disqualified by the. Okay? Whip is mentioned in the constitution. Who is the chief whip? Who is the whip assistant whip? That is not mentioned in the constitution. So only mentioned the whip is under anti-defection. But whip is defined, or whip facilities for the whip is provided under this law which was passed in 19. Now let's look at money bill. Procedure for money bill is mentioned where? In Article 109. The definition of the money bill is mentioned where? Article 1110. What is the logic of this marathon session or this revision? We are looking at high yielding topics from where the large number of questions have been asked and may be asked in your prelims exam. We first looked at the executive, state executive, union executive. Now we are looking at legislature, legislature, state legislature. Money bill, for example. What is the definition of the money bill? Any bill is a money bill if it deals with only money matters. And which are those money matters? Only those money matters which are mentioned under Article 110. Which means if a bill talks about imposition of tax, abolition of tax, alteration of tax, remission of tax, such a bill is a money bill. If tomorrow, for example, there is a bill which talks about charged expenditure, charged expenditure in the sense the salaries of the president, vice president, speaker, deputy chairman of the Rajya Sabha, they're charged on the Consolidated Fund of India, which means not subject to the vote of the parliament. But yes, Lok Sabha can discuss this charged expenditure but can't vote. Similarly, salaries and allowances of the chairperson of the UPSC. Similarly, CAG. Similarly, judges of the Supreme Court, pensions of the High Court judges. But the salaries of the Chief Election Commissioner and Election Commissioner, they are not charged on the Consolidated Fund. Yeah, they are expenditure made on the Consolidated. That means unless and until Parliament passes a money bill, passes a budget, you cannot get the salaries and allowances. What if tomorrow government wants to introduce a bill to say that even the expenditure related to Election Commission of India should be charged on the Consolidated Fund of India? Such a bill, when it is introduced, has to be a money bill under Article 100. But what is the procedure for a money bill? A money bill can be introduced only in Lok Sabha, that too with the prior approval of President. So many times in my Telegram group also repeated questions by students regarding whether private member can introduce a money bill. Although before the break I discussed this, albeit briefly, but right now I'll tell you the exact procedure. This money bill can be introduced in the Lok Sabha on the prior approval of the President of India, and then this bill should be passed by simple majority. If it is passed by the simple majority, then this bill is sent to the Rajya Sabha. What are the options available with the Rajya Sabha when it comes to a money bill? Rajya Sabha cannot reject a money bill. Rajya Sabha cannot amend a money bill. Rajya Sabha can make recommendations. Rajya Sabha can make recommendations. Or Rajya Sabha may not act on this money bill. But if the Rajya Sabha does not act on this money bill for 14 days, at the expiry of this 14-day period, there is something called deemed approval. Deemed approval in the sense it shall be deemed that Rajya Sabha has also passed this money bill, because Rajya Sabha has an inferior role when it comes to a money bill. And then when this money bill is sent to the president, what are the options available with the president? President has to either give her assent to money bill or withhold her assent. She cannot send the money bill back to the parliament for reconsideration. Sir, I have a question. What? Sir, can president use pocket veto on a money bill? The simple answer is no. Why? Because pocket veto is not mentioned in the constitution. But sir, what if the president not sign this money bill and keep it pending? That should not happen. That cannot happen. And we have seen that at the central level between the president and the prime minister, there isn't much conflict. Although there used to be conflict in the initial days, but even then, such a conflict we have never seen. Conflict in this initial days between Pandit Nehru and Dr. Rajendra Prasad. So, can pocket veto be used on a money bill? Simple answer is no. Can a money bill be sent back to the legislature for reconsideration? No. President will have to either sign or withhold her assent. But normally, president signs because she gave the approval. Now comes another question, sir. If you are a private member, and who is a private member? Somebody who's not a minister. And this private member wants to introduce a money bill, but money bill says without prior approval of the president, you can't introduce a money bill. And why will president give the approval? Genuine question. There are two things to look at this. Let's assume that president will not give the approval. That means you can't introduce a money bill. But does constitution ever mention that a private member cannot introduce a money bill? It doesn't. Sir, Lakshmikant says money bill only has to be a government bill. Lakshmikant is wrong, with due respect to Lakshmi. It is wrong, plain wrong, blatantly wrong. Why? I'll tell you one more explanation. What if money bill has been introduced? I am a private member, I introduced a money bill. Money bill was passed by Lok Sabha. But sir, without prior approval of the president, how can you introduce? Let's assume for a while. I've introduced a money bill. Money bill has been passed. But how do I know that this is a money bill? Because when this bill will be transmitted to Rajya Sabha, Speaker of the Lok Sabha will certify that it is a money bill. And now Speaker has certified this is a money bill. It goes to Rajya Sabha. Rajya Sabha also passed this. Now President receives this bill. And now President signs this bill. Now President signs this bill. Can you tomorrow approach the court? Sir, this was a money bill. But this was introduced by this private member without the prior approval of the President. So please declare this bill unconstitutional, null and void. Court will not declare it now. Why? Because this President's approval is only a matter of procedure. Now I have to sign this money bill as the President. What if I did not give the prior approval when the bill was introduced? But later, when the bill was passed by both houses of the parliament, it came to me and I signed. Now, on this ground that earlier I had not given the approval, that cannot be the basis to challenge this bill in the court of. Although it becomes difficult for a private member to introduce a money bill and on top of that get the money bill passed. Very difficult. But that does not mean it is impossible. That does not mean it is not even constitutional for a private member to introduce a private money bill. We are talking about can. We are not talking about whether it would be successful or can. Simple answer to this question: can a money bill be introduced by a private member? The answer is a simple yes. Any questions? Please let me know. Any questions? Let me know on this money bill so that it is clear once and for all. Okay. Another matter. Speaker and Deputy Speaker. Constitution says under Article 93 that the House of Lok Sabha, there is a similar provision for the states as well. The House of the Legislative Assembly shall, as soon as may be, elect two of its MPs, one as Speaker, the other as Deputy Speaker. If a question is asked in the exam, office of Speaker and Deputy Speaker according to the Constitution is a must. The answer is yes. How can you say that? Because Constitution uses the term shall. And whenever Constitution uses the word, most of the times when Constitution uses the word shall, that means it is mandatory provision. The Speaker, for example, currently which Lok Sabha are we in? 18th Lok Sabha. Who was the Speaker of the 17th Lok Sabha? Mr. Om Birla. Who is the Speaker of the 18th Lok Sabha? Mr. Om Birla. But when the Lok Sabha is dissolved, listen to me carefully. When the Lok Sabha is dissolved, when is Lok Sabha dissolved? Normally, when the Lok Sabha completes a 5-year term, then it is dissolved. Or if it is dissolved prematurely, on the advice of the Prime Minister, the President dissolves the Lok Sabha. Clear? Which means all the members of the Lok Sabha, they are gone. Their term is over. They're no longer the MPs of Lok Sabha because Lok Sabha is dissolved. Except one person, Speaker. Speaker does not resign. Speaker remains the Speaker, continues, even after the dissolution of Lok Sabha. He is still the Speaker. Now, when 18th Lok Sabha has met for the first time or is to be convened for the first time today, the newly elected members of Lok Sabha, 18th Lok Sabha will meet today. Today at 11 o'clock, we will meet. In the morning, today morning, the Speaker of the 17th Lok Sabha will resign. That means the Speaker does not resign along with other members of the Lok Sabha when the Lok Sabha is dissolved. Speaker is the last person to resign because we need continuity in this office of the Speaker. And in fact, Speaker resigns on the morning of that day when the new Lok Sabha is to meet for the first time. That's Speaker. And it is the Speaker which has wide ranging powers. For example, he is the final interpreter of the rules of Lok Sabha. Who is the final interpreter of the rules of the Lok Sabha? The Speaker, just like the final interpreter of the Constitution is the Supreme Court. Second, he is somebody who certifies money bill and his certificate is final. Although when Supreme Court looks at this term final, shudder and said, no, there is no such thing as final because we have the power of judicial review and judicial review is part of the basic structure of the Constitution. Speaker is performing the role and a very important role as the chairman of the Business Advisory Committee. It is the Speaker who nominates members to various committees. It is the Speaker who decides on anti defection law petitions. So the role of the Speaker becomes important. And the Speaker is elected by simple majority. But the Speaker can also be removed. If the Speaker is elected by simple majority, the Speaker is removed by effective majority. On what grounds is the Speaker removed? Those grounds are not mentioned in the Constitution. But the speaker can be removed if the resolution is passed by Lok Sabha by effective majority, which means majority of all the then members of the Lok. But the speaker can also lose his post if you are no longer MP of Lok Sabha. For example, I am the speaker, but I have been convicted by a court of law, which means I'm disqualified now. Which means I'm no longer the MP of the Lok Sabha, which means I'm no longer the speaker. Then deputy speaker, it is a constitutional requirement. It is not a constitutional discretion. For example, if you seek my permission right now, sir, can you please give me 5 minutes? I will come back. I have some work, but please don't teach anything. I will come back in 5 minutes. And I tell you, okay, please go and come back, but come back ASAP, as soon as possible. When I say as soon as possible, what does that mean? That senses urgency. I need an answer to this question ASAP. I need a response to this question ASAP. I need your response to a particular event ASAP. ASAP means urgency. But the government feels that as soon as maybe means never, or based upon our discretion. Because the election date of the deputy speaker, when deputy speaker's election has to take place, this date of election of the deputy speaker is fixed by, tell me, speaker. And the speaker in 17th Lok Sabha said there is no urgency because so what? We don't have a deputy speaker. We have a panel of chairperson. And we have 10 people who can assist me if I am not present, if I am not available. So we don't need a deputy speaker. In fact, there was a petition before the court as well, but before court could give an order, the Lok Sabha was dissolved. And it is not only peculiar to the Lok Sabha, there were 5 other legislative assemblies where there was no deputy speaker, including the opposition ruled Rajasthan and Jharkhand. But be that as it may, speaker becomes important again, deputy speaker becomes important again. So remember all the facts related to speaker and the deputy speaker. Plus, if this is Lok Sabha and it is to be presided, who will preside over Lok Sabha? If the speaker is not present, the speaker is absent. Who will preside over Lok Sabha? Deputy speaker. Deputy speaker is also not there or absent. Who will preside over Lok Sabha? There will be a panel. Panel of 10 chairpersons. And at least one person will be there who will preside over Lok Sabha. But this is only when the speaker is absent. Absent means the speaker is unable to attend the session today, but he is the speaker. What if the office of the speaker is vacant? Vacancy is because of the speaker is dead. Speaker has resigned. The speaker has been removed. Speaker has been disqualified. Sir, what is the difference between removal and disqualification in this case? Removal means you are still a member of the Lok Sabha, but you are removed as a speaker when a resolution is passed by effective majority. Disqualified is you are no longer the member of the Lok Sabha. You have been disqualified for these reasons. In this case, who will preside over Lok Sabha? Deputy Speaker. That is why Deputy Speaker is a must. But what if we don't have a Deputy Speaker? Then this panel will not come into picture. Why? Because this panel was set up by the Speaker. Office is now vacant. In this case, who will preside over the Lok Sabha? In this case, somebody who is nominated by the President of India. President will nominate anyone from the Lok Sabha to preside over Lok Sabha, not this panel. And same is the case with the Rajya Sabha as well. In the Rajya Sabha, who presides over Rajya Sabha? The chairperson. In absence of the chairperson, who presides over Rajya Sabha? The deputy chairperson. In absence of the deputy chairperson, who presides over Rajya Sabha? There is a panel. panel of maximum 6 vice chairpersons. But this panel comes into the picture when the chairperson is absent. When the chairperson's office is vacant, vacancy again is because of death, because of resignation, because of removal. Disqualification won't matter in case of chairperson because you're not a member of the Lok Sabha, so member of the Rajya Sabha, so you can be disqualified. In this case, who will preside over Rajya Sabha? Deputy chairperson. Deputy chairperson also is not present, then who will preside? Somebody who is nominated by the president will preside over. And here again, one more important entity becomes important, and that entity is Speaker Pro Tem. Who is Speaker Pro Tem? What is his role? What is the responsibility? Does Speaker has the vote while no confidence motion or every other bill? Normally, the Speaker does not vote in first instance. Votes in case of a tie. That's what we call casting vote. So if there is a bill which is to be decided upon by the Lok Sabha, on that bill, there are members who are voting in favor, members voting against. Speaker will not vote because you have to appear impartial. But in case there is a tie, half members in favor, half members against, just to resolve this deadlock, the speaker will have a casting vote to either vote in favor or against so that the bill is. But what is Speaker Pro Tem? Constitution says without you being administered oath or affirmation, you cannot sit in the parliament. In a sense, you cannot perform your duties as a parliamentarian. So even if these 543 MPs of 18th Lok Sabha have been elected, they cannot sit and perform their activities, work in the Lok Sabha without administered oath. Now, who will administer oath to them? One is the president. President will administer oath to them. But it is not normal also to envisage a situation where president administers oath to all these 543 elected people. In that case, Speaker Pro Tem becomes important. How? Listen to me carefully. Give me 10 minutes. I will explain this so that you can answer any question that is asked in the examination or speaker. Elections are over. Results have been declared. And now we have 543 MPs of right or wrong. And then the government is also formed. So is the first step after elections session of Lok Sabha, or the first step is swearing in of the Prime Minister and the Council of Ministers? First step is the swearing in of the Prime Minister and Council of Ministers. So Prime Minister and the ministers have been sworn in, which means now we have a Minister for Parliamentary Affairs as well. Parliamentary Affairs Minister. This Parliamentary Affairs Minister, he will head the Ministry of Parliamentary Affairs. And this Ministry of Parliamentary Affairs has one department called Legislative Wing. So in the Ministry of Parliamentary Affairs, there is one wing called Legislative Wing. Now, these officers of the Legislative Wing, what they will do, they will look at all these 543 MPs and will rank them according to the experience. Experience in the sense, these MPs are first time MPs, these MPs are 2-time, 3-time, 4-time, 5-time, this is the 7-time MP. So we will rank, this legislative department will rank these MPs according to their experience. And then list will be given to the Prime Minister. Prime Minister, here is the list. These are the senior most MPs of Lok Sabha in terms of their experience. Previously, we would look at this experience in terms of experience both in Lok Sabha as well as Rajya Sabha, which means maybe I have been the Rajya Sabha MP for 5 terms, and now I am a member of Lok Sabha and I have been a member of Lok Sabha for 4 terms. That means total for 9 terms, I have been the member of the parliament. And you are 8-time MP of the Lok Sabha, which means who is senior most member? Me. Because I am 5 times in Rajya Sabha, 4 times in Lok Sabha, 9-time MP. You're only 8-time MP. Now the rules have been changed because Speaker Pro Tem is something which Parliamentary Affairs Ministries handbook talks about. So the handbook of Ministry of Parliamentary Affairs, it talks about this term Speaker Pro Tem. It's not a constitution. It is a temporary post. And what is this temporary post? Now the government says that we will include only those as senior most members who have experience in Lok Sabha only, which means you are the senior most member. On top of that, if you are also 8-time MP, I am also 8-time MP. But you are 8-time continuous MP. That means your terms have been consecutive. You have never lost an election in the last 8 terms. For 8 terms consecutively, you are the member of the Lok Sabha. I am also 8-time MP, but somewhere there was a gap. In 2004, I lost the election. Otherwise, I have been elder to you. I have been more experienced than you. But you are an 8-time MP. I am an 8-time MP, but my terms were not consecutive. Your terms were consecutive. And according to this handbook, you are eligible for Speaker Pro Tem because you are the senior most member of the Lok Sabha and your terms have been consecutive as well. When such a list is presented to the Prime Minister says, okay, this is okay, give this name to the President, and we will also talk to this MP first. Are you okay? We want you to become the Speaker Pro Tem. Are you okay? And what is the job of the Speaker Pro Tem? The job is there are 2 roles the Speaker Pro Tem has to perform. Number one is to administer oath or affirmation to newly elected MPs. Sir, what is the difference between oath and affirmation? Oath is for believers. You believe in God. I believe in God. I swear in the name of God. If you're an atheist or a non-believer, you say, I solemnly affirm. So that is role number one of the Speaker Pro Tem, to administer oath to newly elected MPs. And role number two is election of the Speaker. To preside over the election of the Speaker, because we need a Speaker to be elected by the members of the Lok Sabha, because Constitution says under Article 93, the House of the People, the Lok Sabha, shall elect 2 of its members. One is the Speaker and the other is the Deputy Speaker. Speaker Pro Tem is not elected. He presides over the oath and affirmation of newly elected MPs and then presides over the election of the Speaker, because Speaker has to be elected. Sir, if Speaker Pro Tem will administer oath to newly elected MPs, who will administer oath to Speaker Pro Tem? If today Lok Sabha is meeting let's say Lok Sabha is meeting at 11 o'clock, 9:30 in the morning, I as the Speaker Pro Tem will be called by the President. Come here, come to Rashtrapati Bhavan. I will quickly swear you in as the member of the Lok Sabha, which means you are the member of the Lok Sabha. Now, on my behalf, you go to Lok Sabha and you administer oath to all the newly elected MPs. But Speaker Pro Tem is not alone, because we need people to assist him as well. If you are the senior most member of the Lok Sabha, there are others who are lesser experienced than you, with less number of experience than you. We will select 5 such people in total, and they will be there to assist you. That's the job of the Speaker. So Speaker Pro Tem will be administered oath by President. Speaker Pro Tem will administer oath to his assistants, MPs, senior most MPs, who will help me to administer oath to newly elected MPs. And then all of us together, one by one, we can administer oath. But sir, I have another question. Can we have 2 Speaker Pro Tems? But sir, you said Speaker pro tem and five other MPs. But these five other MPs, they are not Speaker pro tem. Can we have two Speaker pro tem? Yes, we can. How? In 2004, I think, when Somnath Chatterjee, who was the senior most MP, he was appointed as the Speaker pro tem. Then he also contested election to the post of the Speaker. So will this Speaker pro tem be eligible to contest the election to the post of the Speaker as well? Yes. At that time, two Speaker pro tems were nominated. So that I, as Somnath Chatterjee, will administer oath to newly elected MPs. And then when I am to be elected as the Speaker of the Lok Sabha, I will not sit on this chair. Someone else, the other Speaker pro tem, will sit on the chair and will preside over the election. These facts are important for your prelims exam. Any question? Okay. Let's look at the sessions of the Parliament. Constitution does not talk about budget session, does not talk about monsoon session, and clearly does not talk about winter session. Constitution has one requirement, that the Parliament should meet as often as possible, but in such a manner that the time between the last day of the previous session and the first day of the next session should not be more than 6 months. Which means Parliament must meet at least twice in a given year. But we meet thrice: budget session, monsoon session. But these sessions are not mentioned in the. Who has the power to summon the session of Indian Parliament? This power is with the President. If it is Parliament, and this power is with the governor when it comes to state legislature. That is this a discretion of the president or the governor? No, it is not a discretion. It is only on the advice of the Council of Ministers headed by the Chief Minister, Council of Ministers headed by the Prime Minister. For example, could I give that example? Okay. Some 200 teachers were selected by the Bhagwant Mann government in Punjab. You go to Singapore, you see how education system in Singapore is, and then whatever learnings you develop, you come back and implement them in Punjab. The governor, Mr. Purohit, wrote a letter to the chief minister. On what basis did you select these 200 teachers? What is their qualification? The chief minister, who was a stand-up comedian previously, he replies to that letter and said, on what basis were you appointed as the governor of our state? What is your qualification? Governor was obviously offended by this. Governor said, let me teach you a lesson. Chief Minister and his Council of Ministers advised the governor summon the Legislative Assembly, summon the budget session of the state legislature. The governor is not summoning. Matter went to the court. Supreme Court castigated both these people, said, what are you doing? You're making mockery of the Constitution. And dear governor, you do not have a discretion in these matters. Only on the advice of the chief minister and his council of ministers can you summon legislature. And when they say summon, you have to abide by it. There is no discretion here whatsoever. So president summons the sessions of Indian Parliament. The governor summons the sessions of the state legislature only on the advice of the political executive. And then comes adjournment. And there are two types of adjournments: adjournment with date and time specified, adjournment sine die. Sir, what is the difference between the two? And who has this power? This power to adjourn the House is with the presiding officer. Sir, is presiding officer always the speaker? Presiding officer is anybody who is sitting on the chair of the speaker. Can be speaker, can be deputy speaker, can be anyone from the panel of 10 chairpersons. Presiding officer has the power to adjourn the House. Adjournment means with date and time specified. And what is this adjournment? Adjournment primarily means a brief interval in an ongoing session. For example, this marathon session is going on. At around 6:20, I said the session is adjourned. We'll meet again at 7 o'clock in the evening. So session has not ended. It is still a marathon session going on. But I just gave a brief interval in an ongoing session by specifying the date and time when we are going to meet again. That's called adjournment with date and time specific. But maybe at 1 o'clock, 2 o'clock, 3 o'clock today, we have to end the session. Then I will tell you the session is adjourned sine die. Why? Because I will not tell you the date and time when we are going to meet again. Because next year, during the prelims examination, who knows where you, I would be? In a sense, when would we conduct the session? So I would say the House is adjourned sine die. And when the presiding officer says the House is adjourned sine die, it paves way for the session to be prorogued. Prorogued means prorogation means termination of the session. That means this budget session has ended, monsoon session has ended, winter session has ended. This is what we call prorogation. And who can prorogue the House? If it's Parliament, and governor if it is the. So who can summon Parliament or legislature, state legislature? President, governor. Who can prorogue, terminate, end the session? President and the governor. Because you have called it, you can end it. Just like tomorrow, when you become the IAS officers, who can appoint you? Who is the appointing authority? President. Who has the power to remove you, dismiss you from the service? The president. But then during the session, there can be a brief interval, and that is what we call adjournment. And then the final thing is dissolution. And dissolution takes place of Lok Sabha or Legislative Assembly. Because Legislative Council and Rajya Sabha, these are the permanent houses of the legislature. They're not subject to dissolution. Lok Sabha can be dissolved, Legislative Assembly can be dissolved. One is automatic dissolution. Automatic dissolution in the sense 5-year term is over, Lok Sabha is dissolved, Legislative Assembly is dissolved. The other is premature dissolution. And this premature dissolution, who has the power to do this? President if it is Parliament, governor if it is the state legislature assembly. And they do it on the advice of the chief minister, on the advice of the prime minister. But is this advice of the chief minister, is this advice of the prime minister binding on the president or the governor? Yes or no? Both yes as well as no. If the advice has come from the prime minister who still commands majority in the Lok Sabha, it is binding on the president. I say dissolve it. If the advice is coming from the chief minister who commands the majority in the legislative assembly, when I say dissolve it, you have to dissolve it. But what if, as the prime minister, I lost the vote of confidence? Vote of no confidence was passed against me. I am a defeated prime minister. I am a defeated chief minister. And then if I advise the president or the governor that you dissolve the Lok Sabha or the legislative assembly, it is not binding. That's the difference you have to keep. Dissolution. And during dissolution, you also have to mention something, also have to remember something related to bills. That is what we call lapse of bills. When the Lok Sabha is dissolved, what are the bills which lapse? Everything lapses except three kinds of bills. Which are the three kinds of bills which do not lapse upon the dissolution of Lok Sabha? Number one, bills originating and pending in the Rajya Sabha, bills awaiting President's assent, bills on which joint sitting has been notified by the President. For example, tell me in the comment section if a bill on which there is a deadlock, does such a bill survive the dissolution of Lok Sabha? Majority saying no. Very good. That does not mean all those bills on which there is a disagreement between the two houses, such bills survive. No. Bills on which there was a deadlock. And to resolve that deadlock, a joint sitting has been notified by the President. Only such bills do not lapse. Otherwise, all bills lapse. Bills originating and pending in Rajya Sabha, they survive. Bills awaiting President's assent, they survive. But sir, if a bill is waiting for the President's assent and President wants to send the bill back for reconsideration, which is the power available with the President, what? The President can send the bill back to Rajya Sabha for reconsideration, and Rajya Sabha is there because Rajya Sabha is the permanent house of Indian Parliament. Those bills which wait, which are on which there was a deadlock, to resolve this deadlock, a joint sitting was notified by the President. Clear? Sir, what if a bill has originated in Rajya Sabha and has been passed by it and is yet ending in Lok Sabha, pending in Lok Sabha? This bill also lapses. Both conditions have to be met. Bills originating in Rajya Sabha, pending in Rajya Sabha. Such a bill will not lapse. If bill is passed in Rajya Sabha, pending in Lok Sabha, lapses. Sir, if Speaker resigns from his party, does account for anti-defection law? There is an exception to anti-defection. If Mr. Om Birla is a member of the Lok Sabha from Kota constituency in Rajasthan on the ticket given by the BJP, once you got elected as the speaker, you can resign from the party and you will not be disqualified because that's an exception. Because you are resigning from your party. Why? Because you want to appear impartial. Although it is not necessary for him to resign, it is not mandatory for him to resign. But what if he wants to resign to appear impartial? He can resign and he will not be disqualified. But what if after his election as the speaker, he remained speaker for a few years and then he was removed as a speaker? Now Om Birla has to join BJP again because it is on the ticket of the BJP that I got elected to Lok Sabha. If I join any other political party, I will be disqualified. Sir, if bill touches Lok Sabha, lapses doesn't matter where it. Okay, very good, sir. Great. Now, when we discussed Legislative Council under Article 169, who has the power to create, establish, or abolish a legislature? This power is given to the Parliament. Parliament may. What Parliament can do? Parliament can pass a law. And this law is an ordinary law. And what is the majority required to pass an ordinary law? Simple majority. That means to establish a legislative council in a state or to abolish a legislative council in a state. What Parliament has to do? Parliament has to enact a law, which is an ordinary law, which means it is not a constitutional amendment. And this ordinary law passed by simple majority. To this, we can abolish a legislative council. That means we can abolish a legislative council where it is present, for example, Karnataka. Or we can establish, we can create a legislative council where it is not present, for example, Tamil Nadu. But Parliament cannot do this on its own. For that, Parliament will have to act on the basis of the resolution passed by Legislative Assembly of that state. Which means, for example, this is Tamil Nadu, and Tamil Nadu has a Legislative Assembly. And for example, this is Karnataka, and Karnataka has a Legislative Assembly. Karnataka has a Legislative Council as well. But Tamil Nadu does not have a Legislative Council. So if we want to create a Legislative Council for Tamil Nadu and we want to abolish Legislative Council for Karnataka, what is the procedure? Procedure is Parliament will enact a law by simple majority, will establish Legislative Council for Tamil Nadu, will abolish Legislative Council for Karnataka. But for that, Parliament has to depend upon a resolution passed by Legislative Assembly. If the Legislative Assembly passes a resolution by the majority of the total membership of the House and majority of the two-third members present and voting, this is special majority flavor 2. If such a resolution is passed by the Legislative Assembly, then Parliament may, which means it is the discretion of the Parliament, which means this resolution is not binding on the Parliament. But this resolution is necessary. Without this resolution, you cannot proceed as the Parliament. And if the Legislative Assembly of Tamil Nadu passes a resolution by special majority flavor 2, requesting the Parliament to enact a law and through this law create Legislative Council, Parliament may or may not create a legislature. Similarly, if the Legislative Assembly, be carefully. But sir, Karnataka has Legislative Assembly as well as Legislative Council. If Legislative Council is to be abolished, for that, do we need the resolution to be passed by Legislative Council as well? Legislative Assembly of Karnataka will have to pass a resolution by special majority flavor 2 requesting the Parliament that please abolish Legislative Council. This is the procedure that needs to be. Right or wrong? But something else. Few more things, and then our legislature is over. I will give you 10 more minutes so that whatever questions you have related to legislature, shoot them. I will respond. And then we will take another break, another half an hour break, and then we will. Okay? Very good. One is deadlock. What constitutes a deadlock? For example, this is Lok Sabha and this is Rajya Sabha. Lok Sabha passes a bill, Rajya Sabha passes a bill. There is no deadlock whatsoever. Lok Sabha passes a bill, Rajya Sabha rejects this bill. This leads to deadlock. Rajya Sabha is not even saying that we will consider, we will amend, we will do this and that. Rajya Sabha is saying directly, we will reject this bill. Lok Sabha passes a bill, Rajya Sabha amends this bill. If Rajya Sabha amends this bill will go back to Lok Sabha. If Lok Sabha accepts these amendments, there is no problem, the bill is passed. If Rajya Sabha rejects these amendments or amends this bill again, there is a deadlock. If Lok Sabha passes a bill and Rajya Sabha does not act on this bill, and after the expiry of 6 months, we can say that finally there is a deadlock. And it can be vice versa as well, which means on these ordinary bills, Rajya Sabha and Lok Sabha has an equal role to play. And this procedure is there for the financial bill as well. Financial bill under Article 117 can be introduced only in the Lok Sabha. It requires simple majority. What if financial bill is defeated in Lok Sabha? Nothing will happen to the stability of the government survives. But if Lok Sabha passes this financial bill, it is sent to Rajya Sabha. What are the options available with the Rajya Sabha? Rajya Sabha can pass a financial bill. Rajya Sabha may reject a financial bill and then there is a deadlock. Rajya Sabha may amend a financial bill. Rajya Sabha may not act on this financial bill and after the expiry of 6 months, there is a deadlock. And then to resolve this deadlock, there is joint sitting of the two. And it can be reverse as well. Rajya Sabha passes a bill, Lok Sabha rejects, deadlock. Rajya Sabha passes a bill, Lok Sabha amends. These amendments are not acceptable to the Rajya Sabha, deadlock. Rajya Sabha passes a bill, Lok Sabha does not act on this bill, and after the expiry of 6 months, we can say that there is finally a deadlock. And to resolve this deadlock, what do we need? Joint sitting of the. Which means when in this joint sitting, we will have 543 MPs from Lok Sabha. We will have 245 MPs from Rajya Sabha. Who has the numerical majority? Who has the numerical strength? In joint sitting, the will of Lok Sabha prevails. Because of its numerical strength. But it's a joint sitting. And in this joint sitting, such a bill requires what type of majority? Simple majority. And who will preside over this joint sitting? Who presides over this joint sitting? Let me know in the comment section first. One, first option is Speaker of Lok Sabha. If he is not present, then Deputy Speaker of Lok Sabha. He is also not present, then Deputy Chairperson of Rajya Sabha. If Deputy Chairperson is also not present, then who will preside over this joint sitting? Yes? Anyone chosen at the joint sitting. When we say anyone, that means any member at this joint sitting. That means member can be from Lok Sabha, can be from Rajya Sabha. But under no circumstance can the Vice President, who is the chairperson of the Rajya Sabha, the chairperson of the Rajya Sabha, the Vice President of the Rajya Sabha, does not preside over joint sitting. Why? Because this Vice President, this chairperson of Rajya Sabha, is a joint sitting of the two houses. and you are not a member of Rajya Sabha. That's why you can't preside over this joint sitting. And how many times these joint sittings have been conducted since the enactment of the Constitution, since the development of our parliamentary system? Three times. One was on the dowry bill, the other was on the banking bill, and the last one was in 2002, quota, Prevention of Terrorist Act. Okay? And this is something that we discuss with respect to the governor under Article 200 and 201. What happens when the bill is passed by the legislature and sent to governor? What are the options available with the governor? And what happens when the governor reserves a bill for the consideration of the president? Then, when the president either can, because it should not be a money bill. So does that mean money bill cannot be reserved by the governor for the consideration of the president? No. Money bill can also be reserved for the consideration of the president. But I'm saying if it is not a money bill, then this bill can be sent back to the state legislature. Because if a money bill has been reserved by the governor for the consideration of the president, president can either give assent or withhold assent. President cannot send this money bill back for reconsideration. So if it's a non-money bill, the president may direct the governor that you please return this bill to the state legislature and these are my objections. And then the state legislature has 6 months to decide. But once the same bill is passed again, then it shall be again presented to the president for his consideration. That means it is not mentioned, neither time limit is mentioned, nor action is mentioned. Whether it is binding on the president to sign, no. It is to be presented back to the president for his consideration. Let's look at the question. All mega Okay, let's look at the question on your screen. The quorum to constitute the sitting of the Lok Sabha is 55 members, excluding the Speaker. While the President has the authority to prorogue the session of the Parliament, the Speaker has the authority to adjourn the House sine die. All the bills pending in the Lok Sabha, except the ones originating in the Rajya Sabha, lapse upon the dissolution of Lok Sabha. How many statements given above are correct? Tell me. The quorum to constitute the sitting of the Lok Sabha is 55 members, including the Speaker. So 1/10 of the members of the Lok Sabha, that constitutes the quorum. That means quorum is the minimum number of people who should be present in the Lok Sabha, because of which the proceeding of the Lok Sabha can continue. Clear? While the president has the authority to prorogue the session of the parliament, speaker has the authority to adjourn the house sine die. Correct? All bills pending in the Lok Sabha, except the ones originating in the Rajya Sabha, lapse upon the dissolution of the Lok Sabha. Even if the bill has originated in Rajya Sabha, but it is pending in Lok Sabha, this will lapse. So two statements are incorrect. A, one statement is the right answer. Okay? Great. Question number 24. While the returning officer for the election of the President of India is always the Secretary General of the Lok Sabha, the returning officer for the election of the Vice President is always the Secretary General of Rajya Sabha. According to parliamentary conventions and traditions, if the Deputy Speaker is also appointed a member of a parliamentary committee, he is also appointed its chairman. Which of these statements given above is or are correct? Quorum of Rajya Sabha is also 1/10 of the Rajya Sabha, means 25 MPs. Returning officer. Who is the returning officer for the election of the president? It is the Secretary General of Lok Sabha and the Rajya Sabha by rotation. So if in 2017, I'll tell you what that rotation is. If in 2017 president's election, the returning officer was the Secretary General of Rajya Sabha, in the 2022 Lok Sabha, in the 2022 presidential election, Secretary General of Lok Sabha was the returning officer. So if Secretary General of Lok Sabha is the returning officer for the president, for vice president, it will be the Secretary General of the Rajya Sabha. So by rotation, in today's election, Secretary General of Lok Sabha will be the presiding officer. In the next election, Secretary General of Rajya Sabha will be the presiding officer. So it is not always, it is by rotation. According to parliamentary conventions and traditions, if the deputy speaker is also appointed a member of parliamentary committee, is also appointed as its chairman. And that is the privilege available with the deputy speaker. And also another convention is this deputy speaker is by convention the member of opposition. If the speaker belongs to the ruling political party or the ruling coalition, by convention, the deputy speaker is the member of the opposition. Another question on your screen. The hour before the question hour in both houses of the parliament is known as the zero hour. Right? Zero. During the zero hour, matters are raised by the members without any prior notice or permission. The rule book does not mention zero hour. The duration of the zero hour is not specified in any rules. Which of the statements given above is or are incorrect? Sir, I'm appointed as law clerk to Justice J.V. Pardiwala, the judge who passed 10 bills of Tamil Nadu government. Kudos to your polity lectures I mentioned. Very good. Okay. This is question hour. And what happens in question hour? Questions are asked. These questions can be asked to ministers as well as private members. So, question hour is not, contrary to popular perception, reserved exclusively for asking questions to the ministers. No, questions can be asked to private members as well. And question can be either a starred question or an unstarred question or a short duration question, so on and so forth, but notice is given. After question hour, we have the agenda, the business of the house. But sometimes we can sneak in zero hour. Why is it called zero hour? Because the question hour starts at 11 o'clock in the morning, the zero hour at 12. Clear? But this zero hour is Indian innovation. You don't see zero hour in other democracies, parliamentary system. It is Indian innovation. And this Indian innovation started from 1962. And it is in this zero hour that questions are asked without prior notice. Because here, with prior notice, questions can be asked. For example, you might have seen that I've asked a question to a minister. I am the member of the parliament. The speaker says, "Do you want to raise this question?" I say, "Yes, this is my question." The concerned minister gets up and says, since it's an unstarred question, the answer to this question is lying at your desk. Which means, was there a paper leak? Does he already know the question? Yes, the minister already knows the question because I have to give him notice. That's how you can come up with the authentic answer to that question, because you can't mislead the House. That's why we say one of the roles, functions played by the parliament is that it is the authentic source of information. So, long story short, notice is given and then questions are asked. But here, without notice, questions are asked. It's an Indian innovation. Question hour is not mentioned in the Constitution. It is mentioned in the rules of business and procedure. But 0 hour is not even mentioned in the rules. And when it is not mentioned in the rules, so we can't say that 0 hour has to be necessarily for 1 hour. It can be for 2 hours, it can be half an hour. Right? So what's the question? The hour before the zero question hour in both houses of the parliament is known as 0 hour. No, it is after. After the question hour, before the agenda. During 0 hour, matters are raised by members without any prior notice or permission. The rule book does not mention 0 hour. The duration of the 0 hour is not specified in any rules. Which of the statements are incorrect? Only one is incorrect, which is the statement 1. A is the right answer. Okay. Now, if you have any questions, please let me know. Another 10 minutes. Let's take the questions related to legislature. Then we will take a break and then we will meet again. The money bill requires special majority. Money bill requires simple majority. Star questions are oral questions. If it's a starred question, that means I expect answer to this question in a oral format, which means supplementary questions can be also. Sir, if vice president is acting as the president, who presides over Rajya Sabha? Deputy chairperson of the Rajya Sabha. Please explain appropriation bill and financial bill under the budget. It is appropriation bill, but it is not financial bill. It is finance bill. And there is appropriation bill. Appropriation bill talks about expenditure. Finance bill talks about revenue, which primarily means that finance bill talks about the taxation proposals. Both these bills put together, these are basically money bills. The long story short on money bill with respect to private member. Is 0 hour necessary in all sessions? No. In financial, long story short for money bill, if you want to know, reiterate. Can a private member introduce a money bill in Lok Sabha? Yes. 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 Is financial bill, does prior recommendation of president is necessary? Yes. Because financial bill can be introduced in Lok Sabha with the prior approval of the president. Please explain lame duck session. It's the last session of the Lok Sabha where election has already taken place. New members have been elected. But this last session, most of the members who are attending the session, they have lost the election. So you won't see them attend the Lok Sabha again. The lame duck session. Sir, please explain about double membership of Legislative Assembly. Rajat, we will discuss that in elections. So the last topic that we will discuss is elections. In elections, we will discuss the Representation of the People Act. Representation of the People Act 1951 talks about this double membership. We'll discuss it there. Sir, is there any provision of joint sitting in case of finance bill? Finance bill is this part of budget. On this, there can be no joint sitting because this is a money bill. If you're talking about financial bill under Article 117, yes, there can be a joint sitting. Sir, how is notice required for start questions as there are oral questions and supplementary questions can follow? Even if they are oral questions, the moment you ask these questions, you have already given the notice. Now I'm allowing you, as the speaker, I'm allowing you to ask these questions because the concerned minister already is aware of these questions, which does not mean it's an oral question, which means I have given the question in written format, but it is differentiated by an asterisk mark, which means when I've asked this question, when I will ask this question, I need an answer not in written format, but in oral format. Answer is in oral, not the question. Can financial bill be introduced in Rajya Sabha? No. That in India, constitution is supreme or the people. Constitution is supreme, but popular sovereignty lies in the people. Okay, then let's take a break. Let's meet at 9:35. See you on the other side of the break. Welcome back. Now, in this segment, let's look at some of the high yielding topics from where questions may be expected and from where large number of questions have been asked over the last 10 years. Let's first look at reorganization of states, and specifically, we will talk about Article 3 of the Constitution. We are a federal polity, right? And in federal polity, there are two units, union and states. Between union and states, there is a federal relationship in the sense that we have dual government, one government in the center, one government in states. We have distribution of powers. But despite that, despite the fact that ours is a federal polity, ours is a federal constitution. In fact, federalism is one of the basic structures of Indian constitution. But there are some provisions of the Indian constitution which are biased in favor of a strong center. And what do we call it? We call it centralizing tendency of Indian federalism. Which means despite the fact that we have dual government, we have distribution of powers, ours is a federal polity, but our federal polity is biased in favor of a strong center. And the most beautiful reiteration of this is Article 3 of the Constitution, which gives power to the parliament. That is why we say Indian Union has destructible states. India is a union of indestructible union, but of destructible states, where the states can be destructed, reorganization can take place, and that is done by a central authority, which is the legislature at the union, known as the parliament. And what parliament can do? Parliament can enact a law. And through this parliamentary law, which is passed by simple majority, and through this law passed by the simple majority, what parliament can do? Parliament can merge two or more states. Parliament can bifurcate or trifurcate states. Parliament can split states, increase the area of a state, decrease the area of a state, alter the boundaries of the state, change the name of the state. All this can be done by the Parliament using Article 3 of the Constitution. But for that, there is one consultative process that is required. And what is this consultative process? First, we need a bill, and this is what we call a reorganization bill. For example, we have to reorganize a state into two states, or we have to reorganize a state. One part will remain a state, the other will be a union territory. Or we have to merge states, we have to change the name of a state, alter the boundaries of the state. For that, we need a bill. And this bill ideally is a government bill. That means introduced by a minister. But this government bill has to be introduced in the parliament. But this government bill cannot be introduced in the parliament without the prior approval of the President of India. So we say that there are money bills, financial bills, which cannot be introduced in Lok Sabha without the prior approval of the President of India, recommendation of the President of India. There is only one ordinary bill for which prior approval of the President is necessary. And such a bill is a bill under Article 3 of the Constitution. But before President gives approval, he has to follow or she has to follow a consultative process. And the process is that this bill should be referred to the legislature of that state which is going to be the which is going to be affected by this bill. For example, we want to bifurcate or trifurcate UP. Such a bill has to be introduced in the parliament, but for that we need prior approval of the president. And the president, before giving her approval to this bill, will follow a consultative process which is laid down in Article 3. And that consultative process is that this bill has to be referred to Uttar Pradesh legislature, because Uttar Pradesh is going to be affected by this bill. And Uttar Pradesh legislature will have to give its views on this bill to the president. In how much time? In a time period which is not mentioned in the constitution, but in the time period which will be specified by the president. So president may say that I need your views on this particular bill in 15 days or 1 week, whatever it is. That time period, you have to be sure, is not provided, mentioned in the constitution. These views are to be presented to the president in a specific time period, which will be decided by the president. But these views are not binding on the president. That means even if UP says we are not okay with the reorganization of our state, even then the president may give a go ahead and this bill will be presented before the parliament. But which house of parliament? Either Lok Sabha or Rajya Sabha. That means it is not necessary that such a bill should be introduced first in Lok Sabha or first in Rajya Sabha. When Andhra Pradesh was reorganized in 2014, that bill was introduced in Lok Sabha. When Jammu and Kashmir was reorganized in 2019, that bill was first introduced in Rajya Sabha. This bill, under Article 3, can be introduced in either of the two houses. And in both the houses, this bill requires simple majority. And once this bill is passed, this is sent to the president for assent. Once president signs that bill, this bill becomes an act, it becomes the law of the land, and reorganization of the state will take place. Clear? But now listen to me carefully. This bill, under Article 3, will effect changes in Schedule 1 and Schedule 4 of the Constitution. Because Schedule 1 talks about names and details of the territories of states and union territories. Schedule 4 talks about representation of the states in the Rajya Sabha, which means if Andhra Pradesh is to be reorganized into Andhra Pradesh and Telangana, you have to mention Telangana in Schedule 1. Andhra Pradesh previously had 18 MPs in Rajya Sabha. Now it is split. Andhra Pradesh will have 11, Telangana will have 7. You have to mention these details in Schedule 4 of the Constitution. But making any changes to the Constitution, including the schedules, requires a constitutional amendment. And that constitutional amendment is done under Article 368. And any amendment of the Constitution requires special majority, not simple majority. So, how is it possible? It is possible because there is an exception. An exception in the form of Article 4 of the Constitution. Article 4 says whenever there is a bill which can be introduced either under Article 2 or Article 3, because Article 2 talks about Parliament may by law admit into India, admit into Union, or establish new states on such terms and conditions as it thinks fit. So, when Parliament enacts a law under Article 2 or Article 3, there will be changes in Schedule 1 and Schedule 4 of the Constitution. But these changes are consequential, these changes are incidental, and these changes shall not be deemed as amendment to the Constitution, which means Constitutional Amendment Act under Article 368 is not required. By simple majority, you can pass an ordinary bill and change Schedule 1 and Schedule 4. When Jammu and Kashmir was reorganized, for that there was an important judgment given by the court. And I will tell you in just 1 minute what is the crux of this judgment. Jammu and Kashmir was reorganized into two UTs, J&K and Ladakh. Ladakh will be without a legislative assembly. Jammu and Kashmir will be with the Legislative Assembly. When Jammu and Kashmir Reorganization Act was challenged before the court, Supreme Court said carving out Ladakh from Jammu and Kashmir is constitutional. But what about carving out Jammu and Kashmir as another union territory? The court did not answer this question. The court said when the matter comes later again, then we will decide it. Because look at it this way. Article 1, it talks about India, that is Bharat, shall be a union of states. Do you know that this phrase union of states includes only states? It does not include union territory. Why? Because this union of states, although it is union of states mentioned, but Dr. Ambedkar has said it is basically federation. It is basically federation of states, which means ours is a federal polity. And in federal polity, union and states, they share relationship with each other. Right or wrong? Right. But union territories do not share federal relationship because union territories are directly controlled by the center. So if Article 1, Clause 1 says India, that is Bharat, shall be a union of states, if an entire state can be downgraded to two union territories, by that logic, any state can be converted into a union territory. That means we had 29 states. With Jammu and Kashmir gone as a state, we have 28. Tomorrow we can have 27, then 25, then 10, then 9, then 8, 6, 5, 4, 3, 2, 1, or then 0. That means this phrase, India, that is Bharat, shall be a union of states, can become India, that is Bharat, shall be a union of union territories, which would violate federalism principle in the constitution, and as such is against the basic structure of the constitution. But Supreme Court has said carving out Ladakh as a residue from a state into a union territory is okay. But a specific question whether J&K it was right to carve it as a union territory, downgrading the entire state to a union territory. The Supreme Court looked at the assurance given by the Solicitor General. Solicitor General said this UT status for Jammu and Kashmir is temporary in character. We are going to restore statehood to Jammu and Kashmir. So Supreme Court looked at the promise made by the Solicitor General on behalf of the government and said, since it is a temporary nature, we will not decide as yet whether it was right to carve it as a union territory or clear. This is about Article 3 of the Constitution. Now there is a question on your screen, question 28. Match the following. This is related to part 2 of the Constitution, which deals with citizenship. Tell me what is the right answer. What is Article 5 of the Constitution? Article 5 talks about citizenship at the time of the commencement of the Constitution. When the Constitution was enacted on 26 January 1950, but provisions related to citizenship were implemented and enforced on 26 November 1949 itself. According to Part 2 of the Constitution, which deals with Articles 5 to 11, it primarily talks about citizenship at the time of the commencement of the Constitution. Article 5 says, whoever is born on the territory of India is a citizen. Whoever has been ordinarily residing in this territory of India for 5 years is a citizen. Whoever whose parents were born on the soil of India is a citizen. So at the time of the commencement of the Constitution, whoever was born on the territory of India is a citizen. Whoever has been ordinarily residing in India for 5 years is a citizen. Whosoever's parents or grandparents have been the citizens of India, they are the citizens. Article 6 and 7 have been swapped. Article 6 talks about rights of citizenship of certain persons who migrated to India from Pakistan. So if you migrated to India from what became Pakistan and you have migrated prior to 19th of July 1948, you are a citizen of India. But if you migrated after 19 July 1948, you have to apply for citizenship. You have to register for the citizenship. And only those individuals will be given citizenship which the central government decides. Article 7 talks about citizenship status of persons who have migrated to Pakistan from India. And whoever has migrated to Pakistan from India after 1st of March 1947, such people are not citizens of India. Who is citizen at the time of the commencement of the Constitution? That is something that Part 3 talks about. Article 8 talks about citizenship of certain persons of Indian origin residing outside India. So even if you are born, even if you are a citizen, even if you are born outside the territory of India, but you were born to Indian parents, and now you are residing outside, there, if you want, you can register to become the citizen of India. Article 9 talks about if you have voluntarily acquired citizenship of another country, then you are not the citizen of India, which means we do not recognize dual citizenship. This is Article 10. Article 10 says whoever was granted citizenship under Part 2 of the Constitution, even after the commencement of the Constitution, you will still continue to be the citizen of India, subject to a law passed by the Parliament. And who has been given the power to make any law with respect to the citizenship? That power is provided to Parliament under Article 11 of the Constitution. But what are you saying? Let's recap. Part 2 of the Constitution, Article 5 to 11. Article 5 says if you were born on the territory of India, you are a citizen. If you were born to an Indian parent, you are a citizen. If you have been ordinarily residing in India for 5 years, then you are a citizen of India. Article 6 talks about if you have migrated from Pakistan to India before 19th of July 1948, you are the citizen. But if you migrate after that, then not all of you, but some of you, who the central government will decide under a permanent system, will get the citizen. Article 7 says if you have migrated from India to Pakistan after 1st of March 1947, you are not the citizen. Article 8 says if you are residing outside the territory of India, but you are eligible to become the citizen of India because you were born in India, but now you are outside. Or you were born of Indian parents, but these Indian parents are now outside. Then you can register to become the citizen of India. And Article 9, it says if you have acquired the citizenship of another country, you are no longer the citizen of India because we don't recognize dual citizenship. And Article 11 gives power to the Parliament that you can regulate all matters related to citizenship. And if under Article 10, Article 10 says if you were given citizenship because of these provisions, because these provisions, listen to me carefully, these provisions talk about citizenship at the time of the commencement of the Constitution. What about after that? After that, also, you continue to be the citizen, but subject to any law passed by the Parliament. Because Article 11 says real power is given to the Parliament to regulate all matters. Because Dr. Ambedkar also said it is not the matter of this article that we do not want to lay down a permanent law for citizenship. That is left to the legislature. Legislature get. Sir, commencement is 26 November or 26 Jan. Constitution was enacted, came into force on 26 Jan 1950, but some provisions were enforced on 26 November 1949 itself. And one such provision is Part 2 of the Constitution, which came into force on 26 November 1949 itself. So Article 1 is correctly paired, Article 8 is correctly paired, but 6, 7, 9 are not. So three pairs are not correctly matched, incorrectly matched. C is the right answer. Okay. Then this Citizenship Act was passed by the Parliament in 1955. This is the law which regulates all matters related to citizenship. It talks us and tells us about the ways by which one can acquire Indian citizenship and ways by which one can lose Indian citizenship as well. How? This is the law, the Citizenship Act of 1955, which also defines illegal migrant. Because Citizenship Amendment Act 2019 is in the news. Rules were made in 2024. Recently, also, we saw CAA was in the news. This matter is before the court. A judgment was also given by the court last year regarding Section 6 capital A of Citizenship Act. This is where it becomes important for your examination. Illegal migrant is such an individual if you have entered India without any visa or travel document. Second type of illegal migrant is if you have entered India on the basis of a valid passport, valid visa as well. But maybe the visa was valid for 6 months and now you are overstaying in India. You are also an illegal migrant. So what you need to know is that this law, Citizenship Act of 1955, it defines who is an illegal. And illegal migrants are not eligible to become the Indian citizens. Full stop. I repeat, illegal migrants are ineligible to become the Indian citizen. But, sir, what about the illegal migrants from Pakistan, Afghanistan, Bangladesh who have entered India on or before December 31, 2014? This law says they shall not be deemed as illegal migrants. So, if you are not deemed as illegal migrants, which means you are eligible for citizenship. And in fact, this law also says that any person who is a Hindu, Christian, Sikh, Buddhist, Jain, Parsi from Pakistan, Afghanistan, Bangladesh, if you have entered India on or before 31st December 2014, you are exempted from Passport Entry into India Act. You are exempted from Foreigners Act as well. And in fact, you will not be deemed as illegal migrant. When you are not deemed as illegal migrant, which means you are eligible for citizenship. Clear? That's the fact that you have to keep in mind. Something else. Who is a citizen of India? If you were born on the territory of India, but this is where there are various dates that you have to keep in mind. If you were born after the commencement of the Constitution and before 1st of July 1987, if you were born on the territory of India, you are a citizen of India. It doesn't matter who your parents are. It doesn't matter whether they are legal or illegal migrant. They are Indians or not. Doesn't matter. A child is born on the soil of India till 1st of July 1987. The child is an Indian, which means we are following a concept of Yas Soli, law of the soil. Whoever is born on the soil of India is the citizen of India. Citizenship chapter also becomes important because Donald Trump in previously he decided that we will stop this Yas Soli citizenship. We will change it because they also follow Yas Soli citizenship. But although it was thwarted by the Supreme Court, but this topic becomes important. But if you were born after 1st of July 1987, on or after 1st of July 1987, till 2003, necessarily one parent has to be an Indian. Other parent can be non-citizen, illegal migrant, doesn't matter. One parent has to be an Indian. Only then you can become an Indian, which means from Yasoli, we started progressing towards Yas Sanguini, law of the blood. Through blood, you should be related to India. But after 2003, if a child is born on the soil of India, the child can become a citizen only if both the parents are Indians, or one of the parent is an Indian and the other is not an illegal migrant at the time of the birth. Which means the children born to illegal migrants, even if they are born on the soil of India, they are not citizens by birth. They cannot become the citizens of India because illegal migrants are eligible to become the citizens. That is citizenship by birth, which means from now onwards, if a child is born on the soil of India, the child can be an Indian only if both the parents are Indians, or one of the parent is an Indian and the other is not an illegal migrant. If not by birth, then by descent, you can become an Indian citizen. By descent, in the sense, the child is born, but to Indian parents, where outside India. Then can this child who is born to an Indian parent become the citizen of India? Yes, by descent. What you need to do, you need to register the birth of this child at an Indian consulate within 1 year. And if you're able to do that, then the child is an Indian. But, sir, I have a question. If this child is born to an Indian parent outside India, but let's say in US, which recognizes dual citizenship, then will this child have dual citizenship of India as well as US? Yes. This is the only way in which you can have dual citizenship. But only till this child becomes an adult, which means crosses the age of 18. And within 6 months of you turning adult, you have to then decide, because now you are an adult, you can make that call, you can take that decision. Within 6 months of you turning 18, you have to now decide whether you want to continue as the Indian citizen or you want to remain a US citizen. After that, if you are unable to choose, we will terminate your Indian citizenship. You will remain only a US citizen. Clear? Or by registration. So you can be a citizen of India by birth, by descent, by registration. Registration in the sense, you may be aware that in 2002, a scheme was launched by the Ministry of Home Affairs known as PIO, Person of Indian Origin. Somebody who once held Indian passport but now is the citizen of another country. Since you once held Indian passport, you are eligible to apply for this card, PIO card. And with this PIO card, you can enter India without visa for 15 years. Some privileges were provided to these PIOs. But can these persons of Indian origin become Indian citizens as well? Yes. For that, what they need to do? They need to stay in India for 7 years. After that, they can become the citizen. Then this PIO scheme, it was scrapped in 2015. It was merged with OCI scheme, Overseas Citizen of India Card Holder Scheme. And under this scheme, which is a scheme under Indian Citizenship Act of 1955, which started in 2005, under this scheme, if you have this OCI card, you can enter India without visa for life. That's the privilege. What if you are holding this OCI card? Can you also become an Indian citizen? Yes. But for you, you have to reside in India for 5 years. If you have this OCI card, reside in India for 5 years, you're eligible to apply for Indian citizenship through registration. Or somebody who is married to an Indian, Sonia Gandhi, for example, not born in India, which means cannot be the citizen by birth, not born to an Indian parent outside India, which means is not eligible to become the citizen by descent, but is married to an Indian. And if you're married to an Indian, then you have to reside in India for 7 years. Once you complete 7 years, then you can apply for the citizenship through registry. So, one way to become the citizen is by birth, second by descent, third by registration, fourth by naturalization. Naturalization in the sense, Mother Teresa, Adnan Sami. You are not citizen of India by birth or registration or descent, but you still want to become the citizen of India. For that, what you have to do, you have to come to India on a long time visa, long term visa. If you ordinarily stay in India for 14 years, that does not mean for these 14 years you should have never left this country. Cumulatively, you should have stayed in India for 11 years. And if you have stayed in India for 11 years of the last 14 years, then you become eligible to apply for citizenship through naturalization. And you can become citizen through naturalization. But there are some conditions as well, which are mentioned in the Schedule to Citizenship Act of 1950. If you want to apply for an Indian citizenship through naturalization, you should not be a citizen of a country where Indians are not allowed to become citizens. You have to give up your previous citizenship. Your intention to be to reside in India for a permanent period. You should have a knowledge of any language mentioned in the eighth schedule of the Constitution. So there are some conditions which you need to fulfill in order to be eligible for citizenship through naturalization. But which ministry is responsible for all these citizenship matters? Which is the nodal ministry for citizenship matters? That ministry is MHA. If the MHA feels that you have made significant contribution in art, in world peace, in human progress, then all these conditions will be waived off. Only one condition, that you should not continue as the citizens of another country, because under no circumstance can we recognize, can we value, can we accept dual citizenship. Apart from that, any other condition can be waived off. You may not be even residing in India for 14 years. You may not even have the working knowledge of any language mentioned in the eighth schedule. Doesn't matter. You may even be from a country where Indians are not allowed to become citizens. But if you have made glorious contribution to the fields of art, literature, world peace, human progress, then these conditions can be waived. And what if tomorrow we acquire Pakistan citizenship by incorporation of a territory? Does that mean automatically all the citizens of Pakistan will become the citizens of India? No. The central government will specify which of these people of the territory which we have acquired can become the citizens of India, which means maybe Asim Munir will not be given citizenship. Hafiz Saeed Masood Azhar will not be given citizenship. So, by incorporation of a territory, this is another way by which you can acquire the citizenship of India. And an exception was provided by CAA 2019, which we have discussed. That means those people are not deemed as illegal migrants. When they are not deemed as illegal migrants, that means you are eligible for citizenship through naturalization. And for such migrants, This period of naturalization, which used to be 11 years, it has been slashed to how many years? 5 years. That means if you are from these three countries, belonging to Hindus, Christians, Buddhists, Jains, Sikhs, and Parsis, and you have entered India on or before December 31, 2014, if you stay in India for 5 years, you are eligible for citizenship through naturalization. You don't have to necessarily stay in India for 11 of the last 14 years. Clear? Great. Then there was a special provision for those persons covered under Assam Accord, because you would know that there was a massive movement launched in Assam from 1979 till 1985 called Assam Agitation. And this was launched by the people of Assam, led by All Assam Students Union, primarily to impress upon the government that you should identify the illegal migrants and deport them. Because this illegal migration has affected our culture, affected our demography, and affected our unique identity. And we don't want illegal migration into Assam. Long story short, an Assam Accord was signed in 1985 between the representatives of the central government, state government, and the protesters led by All Assam Students Union. And ultimately, this Assam Accord said if there are people who have entered Assam before 1st January 1966, we can't deal with them. They are the citizens of India, they are the residents. But if you have entered Assam between 1st Jan 1966 till 25th of March 1971, for 10 years, you will lose political rights, which means for 10 years, you cannot contest elections. For 10 years, you cannot vote in the elections. And once this 10-year period is over, listen, once this 10-year period is over, you have to register as the citizen. But whoever entered Assam after 25th March 1971, these individuals are to be identified, arrested, and deported. Tribunals, foreigners' tribunals will take up their cases. And ultimately, if it is proven that they are indeed foreigners, illegal migrants, have entered Assam after 25th March 1971, they will be deported. And to implement this Assam Accord, Citizenship Act of 1955 was amended. That's how Section 6A was added. Section 6A is nothing but this. Why was it challenged before the court? Because now you will see that there is a different cutoff date for citizenship. What is a different cutoff date? We discuss provisions related to citizenship under Part 2 of the Constitution. If you are migrating from Pakistan to India, and if you have migrated before 1st of July, 19th of July 1948, only then you are citizens. If you migrate after that, then you have to enter India through a permit system, and then we will decide whether we will give you citizenship or not. Which means the cutoff date to apply for citizenship from one part of India is 19 July 1948. But from the other part of India, from the northeastern part, the cutoff date is 25th March 1971. Can in a single country there will be two different cutoff dates for citizenship? Don't you think this is arbitrary? And right against arbitrariness is a fundamental right under Article 14 of the Constitution. But a constitution bench of the Supreme Court decided in its favor and said, no, Section 6A is not unconstitutional. We don't have to go into details why or why not. Just have to keep in mind that this Section 6A upheld by the Supreme Court. Maybe for the mains examination later, we will discuss it in great detail. In fact, there is already a video that I've released on this on our YouTube channel. Should you wish to watch it after the prelims exam, please do that. Clear? But something important, you can also lose your citizenship. And how can you lose your citizenship? By renunciation. What is renunciation? Voluntary act. Voluntarily, you may give up your Indian citizenship. This is how large, more than 2.5 lakh people every year renounce their citizenship. But if I have kids, and these kids are minors below the age of 18, if I renounce my citizenship, my minor kids will also lose their citizenship. But once these kids become major, become adults, then they can reapply for Indian citizenship through registration. But what if, for example, there was war between India and Pakistan? Although there was not a war, war is declared, the war was not declared between the two countries. But what if I renounce my citizenship during war? The central government may not accept it. So, this renunciation, voluntary declaration that I don't want to become the citizen of India. How do I do that? I'm in Australia. I go to a consulate. I ask them for a form, renunciation form. I fill that form and say I'm renouncing my Indian citizenship. This form will not be accepted or may not be accepted if there is a war between India and Australia. And if I give up my citizenship, if I renounce my citizenship, my minor kids will also lose their citizenship. But once they become adults, then they can resume their citizenship through registry. Clear? Then there is termination. There are people who have dual citizenship, but somehow their citizenship, Indian citizenship, is not terminated. Why? Because they bypass the system. How, for example, why are we discussing that? Let's leave that. Let's say you have the citizenship of United States, you have the citizenship of India as well, but from US you don't travel to India directly, you go to Nepal, and from Nepal you come to India. So there is no stamp on your passport in US. So that's how you escape it. And nobody comes to know that you have dual citizenship. But be that as it may, if the central government finds that you have acquired the citizenship of another country without renouncing your Indian citizenship, your citizenship can be terminated. Your citizenship can be terminated. That is termination. Third one is deprivation. And on deprivation, there is a lot of confusion that students have. But let me ask this question to you. Can an Indian citizen who is a citizen by birth be deprived of his citizenship? Answer. Can an Indian citizen who is citizen by birth be deprived of his citizenship? Majority saying yes. Look at the Citizenship Act of 1950 and tell me. If you have registered as the citizen of India, that means you're a citizen through registry, or you are a citizen through naturalization. But the Home Ministry comes to know that you have applied for citizenship and you have received the citizenship through registration and naturalization by through fraud, false representation, concealment of material facts. You can be deprived of your citizenship, which means maybe you said I'm married to an Indian, although you were not. And then this false marriage certificate became the basis for your citizenship through registration. Can be deprived of your registry citizenship. That means only if you are a citizen through registration or naturalization. That's number one. Number two, a citizen. And who is such citizen? If you have received citizenship through registration or naturalization, or if you were ordinarily residing in India for 5 years at the time of the commencement of the constitution, through that means you got the Indian citizen. which means you were not born on the soil of India. You were not born to Indian parents as well. But since you were ordinarily residing in India for 5 years, then you got the citizenship. If you are such an individual, and if you are an individual who has got the citizenship through registration or naturalization, and then you are disloyal to the constitution, then you can be deprived of your citizenship, not the citizen. Now there is a citizen who during war engages with the war, with the enemy, or supports that enemy. If you have received citizenship through registration, through naturalization, or if you were ordinarily residing in India for 5 years at 1950, then you got citizenship. If such individuals engage with the enemy during war, conducts, carries out trade with such enemy country, then your citizenship can be deprived. Now, if you have received citizenship through naturalization, but within 5 years of getting citizenship through naturalization, you have been sentenced in any country for imprisonment term of not less than 2 years. Any country, you can be deprived of your citizenship. Similarly, this citizen, this, who is this citizen? If you got citizenship through registration, if you got citizenship through naturalization, or if you got citizenship under clause 3 of article 5, which means you were ordinarily residing in India for 5 years. Now, if you are outside of the country for 7 years continuously, your citizenship, which primarily means, although there is not much clarity on this, but we can safely say that citizen by birth cannot be deprived of their citizenship. Even if you are convicted in any case, that does not mean you will lose your citizenship. Even if you have committed horrific crimes, that does not mean you have lost your or you can be deprived of your citizenship. Clear? That's something that you have to keep in mind. If you have received citizenship through registration, through naturalization, or if you have been ordinarily residing in India for 5 years at the time of the commencement of the Constitution, such people can be deprived of their citizenship. Right? Then, one more thing. For example, there is Shripad. On his citizenship, there is a doubt whether he is or he is not the citizen of India. But Home Ministry gives a certificate that you are a citizen of India. From the date the certificate was given to you, even if your citizenship was under doubt, you are the citizen. You might have read about tea voters in Assam whose citizenship is under doubt. If your citizenship is under doubt, but the central government issues your certificate, from that date you become the citizen. That is something which is the power available with the central government. And there was a lot of talk about NRC, National Register of Citizens. To implement NRC, do we need a constitutional amendment? No. To implement NRC, do we need a law? No. Because that is already provided under the Citizenship Act of 1950, which was amended in the year 2003. And what is that amendment? The central government may compulsorily register every citizen and issue national identity card to him. For example, national population register that we have, it is compulsory. Every resident has to register in the national population register. And every person, every citizen may be compulsorily forced to register as the citizen under NRC. And that is what Citizenship Act says. Central government may maintain a national register of Indian citizens and for that purpose set up National Registration Authority. All the government has to do to implement NRC is to establish a National Registration Authority through a government resolution and then carry out NRC. Doesn't require a constitutional amendment. It doesn't require any law. It is just an executive action that needs to be performed. Right or wrong? That is citizenship. Any questions? Let me know. How to prove that I am an Indian? Aadhaar is not a proof of citizenship. Ration card is not a proof of citizenship. Driving license is not a proof of citizenship. PAN card is not a proof of citizenship. So we don't know what is the proof of citizenship. Maybe passport can be viewed as a symbol or basis for citizenship, the proof of citizenship. Voter ID also is not a proof of citizenship. So we still don't know, because that we will come to know if at all there is a NRC exercise carried out. Then the central government will list down that these are the documents which, if you possess, you are citizens. The Interstate Council and Contingency Fund of India are constitutional body and constitutional fund. Interstate Council is a non-permanent constitution, but contingency fund is a statutory fund. It is not a constitution. One citizenship, one domicile. Yes. Tania Mirza's son is Indian or Pakistani because they got divorced recently. He's an Indian because Citizenship Act does not say that necessarily father has to be an Indian. Okay, let's look at Atrocities Act. Article 17 talks about abolition of untouchability. But what is this untouchability? This term is not defined in the Constitution. Constitution refers to untouchability in courts, which means we are not talking about the literal meaning of this word untouchability. We are referring to a historic practice of untouchability, which was practiced in India after the later Vedic period. Discrimination on the grounds of caste, where there was a hierarchy created in the society on the basis of purity and pollution. Long story short, whoever practices untouchability needs to be taught a lesson, needs to be penalized. Such persons are criminals. And for that, we have a law called Atrocities Act, although it is commonly called as Atrocities Act, but the real name of this act is SCs and STs Prevention from Atrocities Act 1989, famously known as Atrocities Act. What are the main features of this act? Number one, burden of proof is on the accused. So if there is a fight between two individuals, one of them belongs to SC or ST community and the other is a non SC ST, this person has to prove that he is not guilty of atrocity, that he is not committing atrocity on this member of the SC and ST community. Burden of proof is on the accused, although normally the burden of proof is on the prosecution. Prosecution has to prove. But there are some laws which reverses this burden of proof. One such law is Atrocities Act. Another such law is Prevention of Money Laundering Act, where the burden of proof is on the accused. Another such stringent law is NDPS, Narcotic Drugs and Psychotropic Substances Act, where the burden of proof is on the accused. But be that as it may, this is one aspect of Atrocities Act. Second, immediate FIR, automatic arrest. No need for a preliminary inquiry. So, what are you talking about? In 2018, a judgment was given by the court known as Subhash Mahajan case. And in this case, Supreme Court said that this Atrocities Act has been misused and has been weaponized by SCs and ST community against non-SCs and STs. That is why, to prevent the misuse of this law, what we are saying, number one, there has to be a preliminary inquiry. No immediate registration of FIR, no automatic arrest. Whenever somebody approaches the police for a case under the Atrocities Act, the police should not immediately jump and arrest the accused. The police will have to conduct a preliminary inquiry to see whether it is a case related to atrocity, or is it a marital dispute or a land dispute or a property dispute or any other dispute whatsoever. Only if it is proven that yes, this is a case of atrocity, then the written permission should be given by the superintendent of the police. Only after that, the accused can be arrested. And here, there is no bail either. These are non bailable offenses under the Atrocities Act. The court said no, bail should also be given. We don't want to make this non bailable offense because that is how it has been weaponized. There were protests, some deaths as well, and ultimately Parliament got together, amended this Atrocities Act in 2018. And because of that amendment, all these safeguards were removed. Which means now, if you're booked under the Atrocities Act, immediate FIR will be filed, automatic arrest will take place, and there is no bail as well, which means for such cases, bail is an exception. Jail is the norm. Otherwise, it is reverse. Jail is the exception, bail is the norm. But for such cases, jail is the norm, bail is the exception. And there is no need to conduct a preliminary inquiry, and there is no need for a written permission of the superintendent of the police before the arrest can be made. That is Atrocities Act. These laws can also be important for your examination. Okay? Great. What is the difference between procedure established by law and due process of? I was going through some of the videos as well of various people. Most of them made mistakes in explaining what is the difference between procedure established by law and due process of. And that is why it is morally incumbent to teach you the right stuff. Very important concept. And we have seen questions related to Article 21 directly asked in the exam. Article 21, it talks about right to life, and personal liberty. But this Article 21 is not absolute, because your right to life and personal liberty can be snatched, but only according to the procedure established by law. And what is this procedure established by law? Three things. There has to be a law. This law has to be a valid law. Procedures which are mentioned in this law have to be strictly followed. For example, there is a police at the door knocking. Sarmad sir, come, we are going to arrest you. Why? Because you're teaching students live from 4 o'clock and we will arrest you. You can't do that. You will go to the court. How dare you arrest our sir? At least before the prelims examination, no. After that, take him. We don't care, but at least for the or at least let him finish this marathon session. Then you can do whatever you have to do with him, but not now. You will approach the court. The court will prescribe three tests. Is there a law which justifies my arrest? Has Parliament or state legislature passed a law saying you can't be teaching live from 4 o'clock, which means for roughly 8.5 hours? You can't do that. 6.5 hours, you can't do that. You are arrested. So there is a law. If there is a law, then the court has to decide whether it is a valid law. Valid in the sense, valid does not mean that procedure has been followed in passing this law, whether voting has taken place or not, whether the bill was introduced correctly or not, because that is beyond the remit of the judiciary. Because of the separation of powers, you can't strike down a law on the basis whether voice vote was taken or the voting took place through division of votes. Courts cannot get into that. No. So it is not that whether correct procedure was followed to enact this law. No, none at all. What is this valid law? There are two things. Does the legislature have competence to pass this law? Is it within the competency of this legislature to enact this law? Competency in the sense, what if Karnataka legislature is passing a law on currency, on extradition, on communications? Does Karnataka legislature have the power under the constitution to enact laws on currency, extradition, or communication? No, that's the power available with the parliament. So if I'm arrested under such law, this is an invalid law because Karnataka legislature does not have the competence to enact such a law. That is what we call an invalid law. So even if a law such as this was passed, but it is an invalid law because this legislature concerned does not have the competency to pass such a law, I will be set free. Or second thing can be, there is a law called Information Technology Act 2000. And under that law, there is section 66 capital A, which says you can't use an electronic device to transmit messages which cause annoyance to the public. And from 4 o'clock, you're screaming at the top of your voice and you're irritating us. And because of that, you are under arrest. I will be arrested, but the court will say, although there is a law, but this law is not valid. Because this section 66 capital A was declared unconstitutional by the Shreya Singhal case in 2015. So you are being arrested under an invalid law. I will be set free. So first, there has to be a law. Second, the law has to be valid as well. Third, the procedure has to be followed. And what is the procedure? When the police comes to arrest me, the police has to tell me in written, in the writing, that these are the grounds on the basis of which we are arresting you, so that I can use that basis to call my lawyer and set up my legal defense. But what if I am arrested under a law and the law is valid as well, and the procedures have also been strictly followed? The court will not come to my rescue. Which means in this case, in procedure, this is what we call procedure established by law. And if the procedure established by law is followed, your right to life and dignity can be snatched by the state. But if you notice this clearly, courts will come to your rescue only if there is executive tyranny. If the police has arrested me, but there is no such law, I was arrested without a law backing, without the backing of a law, without any law, I was arrested. I will be set free. If the court arrested me under if the police arrested me under an invalid law, I will be set. If the procedures have not been followed by the police, I will be set free. So the courts will protect me against the tyranny of the executive. God's sake, tell me, what if Parliament indeed passed such a law and say teaching on Unacademy platform from 4 o'clock till 11 o'clock is unconstitutional, bad, crime? My God, what sort of a law is this? Pass a law to give universal basic income to the people. Pass a law to minimize the gulf between rich and the poor. Passing a law saying teaching on Unacademy YouTube channel is a crime after 6 hours. It's a bad law, but the courts are helpless. They can't protect me because such a law has been passed by the legislature. So, in procedure established by law, you are protected against the tyranny of the executive, but not the tyranny of the legislature. What if this law is bad, unfair, horrible, preposterous? What if one such procedure in this law is that you should file charge sheet in 1000 years? 1,000 years, I will be dead. Or the procedure is vaguely worded. The charge sheet should be filed in the long run. In the long run, we are all dead. The procedures are unfair, unreasonable, unjust. But the courts cannot protect me because courts will protect you against executive tyranny, but not the tyranny of the legislature. This is where due process of law comes into. And in due process of law, the court will now say, will now check. Even if there is a law, this law has to be fair. It just the procedures have to be reasonable. In 1950 Constitution, we followed procedure established by law. In various cases, whether it is A.K. Gopalan, the Supreme Court said, no, we can't protect you against the legislature. We follow procedure established by because we have to follow what is there in the Constitution. This is where, during emergency, a law was passed called MISA, Maintenance of Internal Security Act. And the law said, it was such a horrible law that the law said that even if you are arrested during emergency, you can't even approach the court. Somebody who is arrested under MISA is deprived of his right to approach the court under Article 32 of the Constitution, which means habeas corpus is suspended. This case came to be known as the habeas corpus case or ADM Jabalpur. Matter went to the court. 5 judges had to decide. And in fact, 9 High Court judges said, no, this law is bad. Matter went to the Supreme Court. At that time, it was argued that L.K. Advani gave that speech wherein he said, in 1975, when we were under emergency, the judiciary was asked to crawl. Instead of crawling, it bent before the executive. 5 judges had to decide whether this law is constitutional or unconstitutional. 4 judges said it is constitutional. Only one judge dissented, Justice Hansraj Khanna, whose nephew was the Chief Justice of India till recently, Justice Sanjeev Khanna. Why? Because the court said we cannot protect you against the legislature. We can protect you against the executive, but if the legislature is passing a law, even if it's bad, horrible, preposterous, no matter what it is, we cannot protect. But luckily, 2 years later, in the Menaka Gandhi case, Supreme Court said, no, we don't follow procedure established by law. We are the final interpreters of the Constitution. We say it is procedure established by law, but the implication is due process. Which means now we will perform test number 4, whether the law is just, whether the procedures are reasonable, fair. And apart from that, we also follow principles of natural justice. And what are the 3 important principles of natural justice? Can anybody tell me what are the 3 important principles of natural justice? Nobody shall be sentenced without being heard. If you are filing a case before the court has to hear both sides of the story. The court cannot give verdicts ex parte. Second, nobody shall be the judge in his own case. And third, authority will have to act bona fide. That means when the legislature is making a law, its intention has to be good. You can't pass a law with bad intention to target a particular group of people, to target a particular race, to target a particular community. That's something that you can't do because you have to act in good faith, bona fide. And we follow principles of natural. Now, what we basically do, follow the spirit of due process of, despite the fact that procedure established by law is explicitly made. And this procedure established by law was followed in Japan, from where it traveled to United Kingdom. Due process of law is followed in the states. Because the makers of the US Constitution thought that we have to protect our citizens not only against the arbitrary actions of the executive, but also against the arbitrary actions of the legislature. And we are protected against the legislature from the arbitrariness of the legislature under due process of. Okay? Any questions as of now? Procedure established by law is from Japan, United Kingdom. Due process of law is from United States. Then why was confusion in UPSC fair application and principles of natural? There was no confusion. Confusion was in the minds of students and teachers. Child labor law. And if you notice, we are going provisions by provision. We started with part one, union and its territory. Then we shifted to citizenship. Now we are dealing with fundamental rights. Because let's not forget, what are these fundamental rights basically? Fundamental rights are limitations on the powers of the state. These are what we call negative obligations. And this is one way to ensure constitutionalism. The governments can and should be legally limited in its power, and that its legitimacy depends upon whether it is observing these limitations or not. Whether Supreme Court can review its own judgment, Supreme Court can review its own judgment, yes. But whether high courts can review the judgments like the Supreme Court, no. Okay. What are these fundamental rights? Basically, fundamental rights are limitations on the powers of the state. That is how, if you look at the reading of these fundamental rights, the state shall not deny any person equality before law and equal protection of the law. The state shall not deprive an individual of his right to life and personal liberty. The state shall not discriminate. The state shall not do this. The state shall not do that. That means limitations on the state, and limitation is constitutionalism. So fundamental rights don't go by this definition that fundamental rights are very important for rights. That is why these rights are called fundamental rights. These are most important of all the most important rights. That's not the correct way of looking at it. Okay. And in fundamental rights, somebody was asking, sir, what about Article 13? I will make it simple for you. Article 13 talks about four clauses. Four clauses under Article 13. Clause number one: if there is a pre constitutional law. And what is a pre constitutional law? A law which has been in operation prior to the commencement of the Constitution. If this pre constitutional law is in agreement with fundamental rights which are provided under Part 3 of the Constitution, this pre constitutional law will continue. But if this pre constitutional law violates fundamental rights guaranteed by Part 3 of the Constitution, then this law will not continue. That does not mean this entire law will be struck down. This is where you need to understand doctrine of severability. Doctrine of severability, to make it clear to you, I just need 10 more minutes of your time and then we can wrap this up. For example, we had Indian Penal Code, and in Indian Penal Code, we had Section 377. Section 377 of Indian Penal Code spoke of unnatural offenses. Section 377 said whosoever voluntarily undergoes, indulges in carnal intercourse, and this carnal intercourse is against the order of nature, then it is a crime. What is a carnal intercourse? Against the order of nature, any sexual interaction which is not peno-vaginal in nature, it is an unnatural crime against the order of nature. And this section 377 was used predominantly to criminalize homosexuality, affecting the liberty of LGBTQIA plus community. Clear? Long story short, there were so many cases. Naz Foundation in 2009, then Kaushal judgment in 2012, then Nalsa judgment in 2014, then finally Navtesh Johar. And in Navtesh Johar, Supreme Court invoked what is known as constitutional morality. Morality in the sense, you have your own morality, I have my own morality. Just like we say, you have your truth, I have my truth. So far as the only truth, the absolute truth is concerned, it doesn't exist. What may be moral to me may be immoral to you, and vice versa. Why should we deprive LGBT community from engaging with in love with this, with their own gender, with their own sex? Gender is a social construct. So we have to apply the morality of the Constitution. And that morality is based on liberty, that is based on justice, that is based on dignity of an individual. If what this community is doing inside the four walls of their homes, that is none of my business. I'm not getting affected. So why should I impose my morality saying this is bad, this is against Indian culture, this is against my religion, this is against my eyesight, whatever it is? So we have to apply constitutional morality, and Supreme Court said this section 377 is read down. Read down in the sense, Section 377, insofar as it was used to criminalize homosexuality, now it cannot be used to criminalize homosexuality. Homosexuality is no longer a crime. Right to love is your fundamental right. But Section 377 will still be used for other unnatural offenses. For example, bestiality, sex with animals. Sex with animals is an unnatural offense. As such, it is a crime under Section 377. Which means when this pre-constitutional law, Indian Penal Code, is to be tested on the grounds whether it is in agreement with fundamental rights or not. If if it is in agreement with fundamental rights, it will continue. If it is not, then that aspect of that law, which is in violation of fundamental rights, that will be severed, that will be cut. Section 377 was not declared unconstitutional. It was read down. Read down in the sense, if this provision is used to criminalize homosexuality, can't be done. But this section can still be used to criminalize those, to prosecute those, to give punishment to those who indulge in sex with animals. That is what we call doctrine of severability. That's Article 13. Now, the irony is that we needed Section 377 again in Bharatiya Nyaya Sanhita. But we don't have such a provision. Which means now sex with animals cannot be invoked as a crime under unnatural offense related to Section 377, because there is no Section 377 equivalent of mentioned in the Bharatiya Nyaya Sanhita. But be that as it may, this is Section Clause Article 13, Clause 1. 13, Clause 2, it says state cannot make any law to delete or modify or abridge a fundamental right. And what is this law? The definition of this law is provided under Article 13, Clause 3. Law includes rules, regulations, customs, usages, bylaws, notifications, ordinances. Does that mean through a law we cannot delete, modify, abridge fundamental rights? For that, there is an exception provided under Article 3. Or if at all you want to delete, modify, abridge fundamental right, for that you need a Constitutional Amendment Act under Article 368 of the Constitution. So long story short, Article 13 says if there is a pre-constitutional law and it is in agreement with fundamental rights, it will continue. If it is not, it will not continue. And to the extent of contravention, that part will be severed. Then state does not have the power to make any law to delete, modify, or bridge fundamental. When we say any law, law is different. Constitutional Amendment Act is different. Through an ordinary law, you cannot delete fundamental. But through a Constitutional Amendment Act, you can, provided that fundamental right is not a basic structure. If a fundamental right is a basic structure, then even using Article 368, you cannot delete that fundamental. For example, Article 14, Article 17, Article 21, these are part of the basic structure. Article 25, Article 29, these are part of the basic structure. Clear? I am homosexual. Can I become IS? You can become the President of India, somebody who appoints the IS officer. Why not? Can ordinary law violate basic structure? Question should be different. Can an ordinary law be challenged in the Supreme Court on the grounds that it violates basic structure? I think that's what you mean. And the answer is no. An ordinary law can be challenged in the court only on two grounds. One, if it violates fundamental rights. Second, if it is beyond the legislative competence of that legislature. These are the only two. But yes, a Constitutional Amendment Act can be challenged in the courts on the grounds of violating the basic structure. Okay. Now, we were talking about fundamental rights being limitations on the powers of the state. Let's look at the child labor law because here we are dealing with the laws. In Bare Act, we dealt with the provisions of the Constitution. Here we are trying to look at the laws. For example, we discussed the Citizenship Act of 1950, discussed the Atrocities Act, now discussing the Child Labor Act. This child labor Prohibition and Regulation Act was passed in the year 1986, and then significant amendments were made in 2016. What is the crux of this? The crux is if there is a child, and who is a child? Somebody who is less than 14 years of age. This child is prohibited from employment. You cannot employ a child who is under the age of 14. Complete prohibition. But there are exceptions. What are the exceptions? This child can work in audio visual entertainment industry, but only after school hours, or during vacations, so as to not to impede the child's fundamental right to free and compulsory primary education. Second, this child can work in family business, but that too only after school hours and during vacation. Exception in entertainment industry is circus. Circus is considered to be exploitative, and this child circus cannot be viewed as entertainment industries. Except circus, you can work in entertainment industry, in audio visual entertainment industry. But then this law also talks about adolescents. And who are these adolescents? Who are in the age group of 14 to 18? These adolescents are prohibited from being employed in hazardous industries. But these adolescents, they can work in non-hazardous industries where their conditions of work will be regulated. There is a lot of criticism and lots of praise for this law as well, but that is the subject matter of mains examination. Here, just keep in mind that adolescent who is defined within the age group of 14 to 18 is prohibited from being employed in a hazardous industry, but this adolescent can work in non-hazardous industry. What about somebody who is employing this child or employing this adolescent in contravention of this law, violating this law? That person will be arrested and a fine up to 50,000 can be imposed or 2 years jail can be given to that. But can the father, mother, the parents, the guardians of this child or adolescent be also convicted under this law? Unless and until it is conclusively proven that they were the ones who pushed the child or adolescent to child labor. Long story short, can the parents or the guardians of this child or adolescent be penalized under this law? No, unless and until it is conclusively proven that it is this parent or the guardian which has pushed this child or adolescent into the illegal child labor. That's the Child Labor Act as amended in. Any questions? Let me know. What if the family business is the hazardous one? Even then, you can't be employed in family business. This family business has to be non hazardous. Any other question? What do we mean by locus standi? If I am an aggrieved individual, only I can approach the court if my rights have been violated. Because Article 32 gives us a constitutional remedy. Constitutional remedy in the form of if fundamental rights are violated. If my fundamental rights are violated, I can approach the courts. Which court? I can approach the Supreme Court under Article 32, but I can also approach high courts under Article 226 of the Constitution. Right or wrong? Right. But here you need to understand locus standi. How many writs are there? If your fundamental rights are violated, you approach the court. The court will have the power to issue writs to protect and force your fundamental rights. We have five writs. For example, habeas corpus, mandamus, certiorari, prohibition, and quo warranto. In these three writs, locus standi applies. In these two writs, Locus standi does not apply. What does that mean? That means anybody can approach the court for habeas corpus and quo warranto. Anyone. But for issuing mandamus certiorari and prohibition, you have to be necessarily an aggrieved individual. Only the aggrieved individual, only somebody whose rights have been violated, only such individuals, aggrieved individuals, can approach the court. Please keep that in mind. That can be a very, very important concept for your examination. But there is no such concept of locus standi when it comes to PIL. PIL was basically Indian judiciary's response to ADM Jabalpur case. And after that, Supreme Court became such an important institution, emphasizing its independence, started innovating and interpreting constitution differently because the image of Supreme Court sullied during emergency. And this is where Justice Krishna Iyer, Justice Bhagwati, and others, they innovated and diluted this locus standi concept to say any public spirited individual can approach the court on behalf of marginalized, weaker sections of the society, can institute public interest litigation. And in PIL also, locus standi does not apply. So that is something that you have to keep in. Okay. Even Jolly had not approached the court in the larger public interest. There was personal interest involved initially. Okay, great. Are there any questions related to fundamental rights? If there are no questions, then we can shift to DPSP. Any questions related to fundamental rights? Any question? Right to vote is a constitutional right. Right to vote is a constitutional right under Article 326, which provision provides for right of under trials to contest election. That is provided under Representation of the People Act. Okay. Now let's look at directive principles of the state policy. For that, you have to keep in mind that these DPSPs, which are mentioned under Part 4 of the Constitution, these are positive obligations on the state. The purpose is to ensure a welfare state. And these provisions we have borrowed from the Irish Constitution. If fundamental rights are negative obligations on the state, restrictions on the state, directive principles are positive obligations on the state. In a sense, in fundamental rights, the state is told by the Constitution, stay away. Don't interfere with the life and liberty of the citizens, of the individuals. But in DPSP, the Constitution is asking the state, please interfere so that you can establish a welfare state. These are the principles that the state has to keep in mind when the state is making laws, when the state is enacting policies. These are the principles that we call directive principles of the state policy. For that, you need to understand that under Article 37 of the Constitution, there are two important characteristics of directive principle. Which are these characteristics? Number one, these principles are not enforceable in the court of law. Which means if your fundamental rights are violated, you can approach the court. The court, through the issuance of writs, will protect your fundamental rights, enforce your fundamental rights. But if DPSPs are not implemented, you can't go to the court. These DPSPs are not enforceable in a court of law. Nevertheless, the second important characteristic, Constitution says these principles are fundamental for the governance of the country. And it shall be the duty of the state to implement these directive principles of the state policy, because the idea, the objective is to ensure a welfare. For that, although Constitution does not talk about this, but constitutional experts, they have divided or categorized these DPSPs into three. Some directive principles are liberal intellectual in character, some are Gandhian in character, some are socialistic in character. But please understand, this is the classification not provided by the Constitution. These are the constitutional experts who look at these directive principles and categorize them into Gandhian, liberal intellectual, socialistic principles. But please go through all these directive principles one by one and start identifying them, whether these are Gandhian, liberal or socialistic in their nature. Can be important for your exam because previously questions have been asked. But at the same time, when we look at directive principles of the state policy, there are two directive principles which are important: 39B and 39C. What is 39B saying? And because these were in the news and because they have massive significance, that is why it becomes important. 39B says 39B, the material resources of a community shall be so distributed so as to subserve the common good. And 39C, the operation of economic system should not result in the concentration of wealth and means of production to a common detriment. Basically, should not result in the concentration of wealth in fewer hands. For that, you may have read about, heard about Krishna Iyer doctrine. According to Justice Krishna Iyer, this phrase, material resources of a community, includes private property. So, all the private property is the material resource of a community and can be distributed so as to subserve the common good. But this Krishna Iyer doctrine was overturned when a 9 judge bench of the Supreme Court in Bombay Private Property Association case, this judgment was authored by the Chief Justice of India. The Supreme Court said that all private resources, all private property is not material resource, overturning the Justice Krishna Iyer doctrine. Maybe Justice Krishna Iyer doctrine is related to Which of the following can be important for you? And one more thing, when we say 39B and 39C, these are the only two DPSPs which have superiority over two fundamental rights, Article 14 and Article 19. This is something that you have to keep in mind. These are the two directive principles, 39B and 39C, which have superiority over two fundamental rights, Article 14 and Article 19. Now, any question on directive principles, please let me know. Then after that, we will take a break. 11:30, we'll take a break till 12. From 12, we will take a look at various other provisions which we have to discuss. We will look at judiciary, we will look at elections, we will look at Representation of People Act, we will look at Lok Adalats. So another 2 hours maybe. By 2:30, we should wrap up. And even if I have only 10 people to stay with me, I will take the session. What happens in AMU case is AMU minority educational institution. That is something that we had discussed in the previous classes. The court has not ruled yet whether AMU is a minority educational institution or not. But when a three-judge bench will decide that, it will have to look at what the seven-judge bench of the Supreme Court said, because seven judges said these are the criteria that you have to keep in mind while deciding whether an institute is minority or not. Can mandamus be issued against a governor or the president? Till recently, no, but now, if they don't pass the bills within the time limit prescribed by the Supreme Court, then yes, mandamus can. Can government company be issued mandamus writ? Yes, why not? Okay, then let's take a break. Break till 12 a.m. We will meet tomorrow morning at 12:01. See you on the other side of the break. Bye bye. Welcome back. Let's get started with the judiciary. Judiciary, in the sense, we have Supreme Court at the top, followed by High Court for every state, then the district courts, and then statutory courts in the form of Gram Nyayalas. These are constitutional courts. This is a statutory court which was created in 2019, 2009, right? What does Constitution talk about the Supreme Court? Constitution says under Article 124 that there shall be a Supreme Court headed by the Chief Justice of India and not more than how many judges? 7 judges. This was the original constitution as it stood on 26th January 1950. These 7 judges are also known as the brother judges or puisne judges. Can we increase the number of judges? Yes, we can. Who has the power to increase the number of judges to the Supreme Court? That power is available with the Parliament. And Parliament can do that by enacting a law, and this is an ordinary law. And this ordinary law is passed by simple majority. That means, in order to increase the number of judges to the Supreme Court, for that we don't need recourse to Article 368. There is no need to amend the Constitution. It can be done by an ordinary law passed by simple majority. And right now we have a situation where we have the Chief Justice of India and 33 other judges. So, who has the power to decide the strength of the Supreme Court? That power is with the Parliament. But how many high courts do we have? We have 25 high courts. And Constitution says that every high court will consist of Chief Justice of that high court and as many judges as may be appointed by the President, which means President gets to decide what will be the composition of a high court. Clear? But how are these judges appointed? We have discussed the qualification of these judges previously. When? When we spoke of Attorney General for India and the Advocate General of a state, therein I told you what is the qualification required for someone in order to be appointed as the judge of the Supreme Court or High Court. Now let's look at the appointment of these judges. Constitution was clear that every judge of the Supreme Court or High Court has to be appointed by the President. Every judge of the Supreme Court or High Court has to be appointed by the President, but the President will have to consult. Who is the President going to consult? The Chief Justice of the Supreme Court and such of the judges of the Supreme Court and High Court as she may deem necessary. But the same Constitution also says that if a judge other than the Chief Justice of India is to be appointed, necessarily the President will have to consult the Chief Justice of the Supreme Court. And then a convention developed that a senior most judge of the Supreme Court is appointed as the Chief Justice of India. And while appointing other judges to the Supreme Court and High Court, the Chief Justice is always consulted. In fact, Constitution says when the judge of a High Court is to be appointed, you have to consult, the president will have to consult the governor of that state as well. And this process continued. And then, because of the impact of second judge's case, because it is this second judge's case which led to the emergence of collegium system of judicial appointments. Because of the second judge's case, then followed by the third judge's case. And what was this third judge's case? It was basically a presidential reference under Article 143 of the Constitution, when the then president asked the Chief Justice, the Supreme Court, what are the ways through which the appointment of judges can take place? And the fourth judge's case, which is known as the fourth judge's case, it was basically what? NJAC judgment, where the Supreme Court said in 2015 that NJAC is unconstitutional. Why? Because it violates independence of judiciary. It also violates primacy of Chief Justice of India in judicial appointments, which is also part of the basic structure of the Indian Constitution. Right? So, right now, what is the current status? Status is that this collegium system, and where do we see this collegium system? There is a collegium system in the Supreme Court as well. There is a collegium system in the High Court as well. So, at the High Court level, you have the Chief Justice of that High Court and two senior judges of the High Court. At the Supreme Court, you have the Chief Justice of India and four senior judges of the Supreme Court. And it is this collegium which recommends names to the president, and president has no other option but to appoint that individual. In practice, what we see, can somebody who is not recommended by the collegium be appointed by the president? No. But is it necessary that all the recommendations of the collegium are appointed by the president? No. Because we have seen instances where the central government blocks a particular name, refuses to appoint somebody, delays appointment of that individual who is recommended by the collegium. But can somebody be appointed as a judge who is not recommended by the collegium? No. But does that mean everyone who is recommended by the collegium gets appointed by the president? No. But how is the Chief Justice of India appointed? The Chief Justice of India is appointed by the president. How? The outgoing Chief Justice of India nominates his successor. And this successor has to be the senior most judge of the Supreme Court, quote unquote, fit to hold the office. So the outgoing Chief Justice, for example, Justice Khanna, recommended Justice Gawai as the Chief Justice of India, and the President appointed Chief Justice of India, Mr. Gawai. But this successor has to be the senior most judge of the Supreme Court, fit to hold the office. But this is where it becomes important for your exam. Who gets to decide whether the senior most judge of the Supreme Court is fit to hold the office or not? Is this something to be decided by the government, or is it something to be decided by the outgoing Chief Justice of India? Answer is not no. And such a controversy has not luckily erupted yet. So we still don't know who gets to decide whether the senior judge of the Supreme Court or the senior most judge of the Supreme Court is fit to hold the office or not. But we know for sure that the outgoing Chief Justice nominates the successor, who is the senior most judge of the Supreme Court, fit to hold the office. And then every other judge of the Supreme Court is appointed by the president, but only on the basis of the recommendation given by this collegium system. This is how the judges have been appointed. What was the composition of this NJAC? Because now, because of the controversy surrounding the judiciary, there is a talk of NJAC getting revived. You may be asked about what was the composition of the NJAC. NJAC before it was struck down by the Supreme Court in 2015. NJAC consisted of the Chief Justice of India, two senior most judges of the Supreme Court, Union Law Minister, Law and Justice Minister, and four, two eminent persons. But who is going to appoint these two eminent persons? President? Yes. But how? On the basis of the recommendations of the committee. And this committee will was consisting of or would be consisting of the Prime Minister, the Chief Justice of India, and leader of the opposition in Lok Sabha. Or if we do not have the leader of the opposition in Lok Sabha, then leader of the single largest party in Lok Sabha. These three members would come together, recommend these two eminent persons to the president, and the president will appoint these two eminent persons. This used to be the composition of NJAC before it was struck down by the Supreme Court. But we also need to understand as a concept, which is almost always in the news, known as independence of judiciary. What do we mean by independence of judiciary? Independence of judiciary is part of the basic structure of the Constitution. This is one way in which we can ensure constitutionalism. But what is this independence of judiciary? There are three aspects to independence of judiciary. One is that judiciary should not get influenced by other organs of the state while giving justice, while deciding case. So while deciding a particular case, the judiciary should not be influenced by the executive or the legislature. Judiciary should independently decide this particular case. That's independence of judiciary. Second aspect is there are some inherent biases that a judge has. For example, I may be a judge, but I may be homophobic. But while deciding a case, I don't have to use my personal bias. I have to divorce my personal bias in deciding this personal case. So I have to be independent of my personal biases as well. And third, I should not be influenced by the media as well. So this trial by media should not dictate, should not determine the outcome of a case that I'm hearing. That is what we call independence of judiciary. Does Constitution provide for independence of judiciary? If yes, how does the Constitution ensure independence of judiciary? For that, let's look at some of these constitutional provisions. Independence of judiciary, number one, judges hold office not during the pleasure of the president, but till they attain a retirement age, which is 65 for a Supreme Court judge, 62 for a High Court judge. So judges, if they are not holding office during the pleasure of the president, which means they are not influenced by the executive, which means that's how Constitution envisages independence of judiciary. That's number one. Number two, they have the power punish people for contempt. That's how judiciary ensures independence. Which means if there is an individual or there is an entity which tries to interfere with the judicial proceedings, which tries to impede the administration of justice, such an individual, such an entity can be punished for committing contempt of court. This power of the courts to punish people for contempt is also one way of ensuring independence of judiciary. Third, removal. Such is the complicated process of removal that till date no judge of the Supreme Court or High Court has ever been removed. Although this may change if Justice Yashwant Verma is removed. Who will remove a judge? President. Executive. But president cannot remove a judge without the resolution passed by the legislature. And legislature has to pass this resolution by special majority flavor too. That too only after an inquiry. which is clearly defined under the Judges Inquiry Act of 1960. So this law Judges Inquiry Act becomes important. And what is this procedure? The process may initiate in either Lok Sabha or Rajya Sabha. If 50 members of Rajya Sabha write to the chairperson that we want to remove a particular judge, then it is the discretion of the chairman of the Rajya Sabha or the speaker of the Lok Sabha, because this process can be initiated in Lok Sabha as well. If Lok Sabha MPs write to the speaker that we have to remove a particular judge, it is then the discretion of the speaker whether to accept this motion or to reject this. If it is Rajya Sabha, 50 MPs will have to write to the chairperson. If it is Lok Sabha, 100 MPs will have to write to the speaker. But the speaker will have the discretion whether to accept this motion or not. If the speaker accepts, then a three-member committee has to be constituted. Who is a member of this committee? One is the Chief Justice of India or a senior Supreme Court judge nominated by the Chief Justice of India. The second is the Chief Justice of a High Court. And the third one is a distinguished jurist. What they have to inquire into? Because on what grounds is the judge of the Supreme Court or High Court removed? What are the charges? What are the grounds? Crude misbehavior or incapacity. This is the ground on the basis of which the judge of the Supreme Court or High Court can be removed. And this committee will have to investigate whether indeed the charges of misbehavior or incapacity are proven or not. And basis that, this committee will submit the report. Is this report binding on the parliament? Is this report binding on the parliament? Yes, as well as no. Yes, in the sense, if this committee says no, these charges have not been proven, parliament cannot go ahead and remove that judge. But if this committee says yes, the charges have been proven, even then parliament may or may not remove that judge because it depends upon the majority. But once both houses of the parliament pass a resolution by special majority flavor 2, which means this becomes a statutory resolution. And this statutory resolution, you would know, is binding on president. Which means now president will have no other option but the president will have to remove that judge. The complicated process, and it is through this complicated process that we ensure independence of judiciary. Fourth is salaries, allowances, pensions. They are charged on consolidated fund of India, which means not subject to the vote of the parliament. That's to ensure independence of judiciary. Five, parliament is prohibited from discussing the conduct of judges. This is to ensure independence of the judiciary. The only time parliament can discuss the conduct of a judge is when you want to remove a particular judge on the grounds of misbehavior or incapacity. These are the ways in which our constitution ensures independence of judiciary. Can be important for your examination. Clear? But then there are other things such as what is the original jurisdiction, appellate jurisdiction, advisory jurisdiction, revisory jurisdiction, writ jurisdiction, original and exclusive jurisdiction. That is something that I'm sure you would have revised, and that becomes important for your exam. Any questions related to the jurisdiction? Any question if you have? Can presiding officer reject such resolution to submit? When the motion is to be introduced, 14-day notice is to be given. That motion can be rejected by the presiding officer. Sir, I have a doubt in the Atrocities Act whether the court judgment was held in the amendment or not. You are saying that whether that amendment to the Atrocities Act was challenged in the Supreme Court? Yes, it was challenged, and the court upheld that amendment, saying, yes, this is fine. Difference between original and exclusive. Original jurisdiction means the power of the Supreme Court to hear the case in the first instance. For example, fundamental rights. Does the Supreme Court have original jurisdiction over fundamental rights violation cases? Yes, because you can directly approach the Supreme Court. But exclusive jurisdiction means only Supreme Court has the power to hear and determine such a case. No other entity, no other court has the power to hear such a case. And this is what we call cases under Article 131. Federal cases. A dispute involving center and state. Dispute involving states with each other. Dispute involving center and states on one hand and other states on the other hand. Such disputes of federal character can be heard only and only in the Supreme Court. So, Supreme Court has exclusive jurisdiction over these federal cases. Similarly, a dispute, election dispute regarding the election of the president or the vice president can be filed only in the Supreme Court, and the decision of the Supreme Court is final, which means on these matters, election disputes related to president and the vice president, there is the exclusive jurisdiction of the Supreme Court. That's the difference. But now let's look at Legal Services Authorities Act 1987. It is this Legal Services Authorities Act which gives basis to Lok Adalat, which gives recognition to the Lok Adalat. Now, Legal Services Authorities Act, for example, we have free legal aid. Is there any provision of Indian Constitution which talks about free legal aid? Yes. Article 39 capital A talks about free legal aid. That means those who are from marginalized, weaker sections of the society who cannot afford a lawyer to defend themselves, don't worry. We are going to provide you a lawyer who will assist you, who will defend you in the court of law. Free legal aid for the marginalized, weaker sections of the society, SCs, women, so on and so forth. And to implement this free legal aid, we have the Legal Services Authorities Act of 1987, which talks about setting up of Legal Services Authority at the national level, National Legal Services Authority. It also talks about establishing State Legal Services Authority. It also talks about establishing District Legal Service Authority. You might have heard till here, but it also talks about Taluk Legal Services Authority at the Taluk level as well. And at the same time, it talks about National Legal Aid Fund, because from where will the money come to assist these marginalized sections of the society? Legal Aid Fund, which should be established at the national level, at the state level as well, at the district level as well. But for our examination, we will focus on National Legal Services Authority. What is the composition of this National Legal Service Authority? The Chief Justice of India is the patron in chief. Remember, patron in chief of NALSA, not the chairman. The chairman is and listen to me carefully, the chairman can be either serving or retired judge of the Supreme. And this person is nominated by the president in consultation with the Chief Justice of India. And such an individual is the executive chairman of National Legal Services. Normally, what happens? The Chief Justice is the chairperson, patron in chief of National Legal Service Authority. And the second most senior judge of the Supreme Court is the executive chairman of National Legal Service. Who are the other members? Such number of other members. who are appointed by the central government on the basis of the consultation with the Chief Justice. So the government, central government, will nominate any number of members of this National Legal Service Authority, but only after consultation with the Chief Justice of India. This is the composition. This composition is very important, can be relevant for your exam. And now we will have to talk about Lok Adalats. There are two kinds of Lok Adalats. Now listen to me carefully. For example, there are lots of cases related to motor vehicle insurance pending, or there are a lot of cases pending regarding, let's say, accidents. All such cases will be clubbed together and will be assigned to a Lok Adalat. That means one mega Lok Adalat will be set up, will be organized, where we will hear all these motor vehicle insurance cases. Clear? That's what Lok Adalat is. Every state authority or every district authority, and at the central level, we have the authority, the Legal Services Authority, or at the High Court level, we have the Legal Services Committee. All these entities, whether district authorities, state authorities, Supreme Court Legal Service Committee, or High Court Legal Service Committee, they can organize local adalat or lok adalat. Is there interval mentioned in this law? No. How many times in a particular year? After what interval? This is not mentioned. At such intervals and at such places as it thinks fit. That means Supreme Court Legal Services Committee will decide that we will organize a lok adalat at this particular place. Taluk Committee can also decide that. High, High Courts Committee can also decide that. State and District Authority can also decide that at their own time and convenience. But Lok Adalat will have to hear only those cases which are compoundable. That means on which cases offenses are either offenses can be broadly divided into two. Offenses can be either compoundable or non-compoundable. Compoundable offense, these are mostly civil offenses where there can be an out of court settlement, where there can be an out of court agreement. Okay, you agree this, I agree this, let's resolve this case. That means you can settle this case out of the court as well. But non-compoundable offenses cannot be settled outside of the court because these are serious criminal cases where justice has to be delivered. Lok adalats will hear these compoundable cases. The only exception is because mostly Lok adalats hear civil cases. Those are compoundable in nature. The only exception is check bounce case, which can be heard by the Lok Adalat. And the decision of the Lok Adalat shall be final and binding on all the parties to the dispute. And you cannot file an appeal against the judgment of this Lok Adalat. That is something which is explicitly mentioned in the law. But then there is something called permanent Lok Adalat. What is this permanent Lok Adalat? Any party to a dispute. Now, whether you approach the court or you are yet to approach the court, whether the matter is pending before a normal court, regular court, or you are yet to approach the court, any party to this dispute may approach a permanent Lok Adalat. And this permanent Lok Adalat will have to be set up only to look at those offenses which are not compoundable under any law. That means civil case, and that too which are compoundable in nature. But what is this permanent Lok Adalat? Listen to me carefully. Permanent Lok Adalats have been set up as permanent bodies with chairman and two members. The chairman can be retired or serving judge. Two members, one will be an advocate, the other will be a social activist. And they are required to provide compulsory pre-legislative mechanism to settle these disputes outside of the court. It is a conciliation mechanism where two parties approach the Lok Adalat and they want to settle this case outside of the court. It's a permanent Lok Adalat, which means it is not established for a particular purpose. For example, motor vehicle insurance. Such Lok Adalats are established at some place at such intervals as the local committee decides, as the High Court decides, as the Supreme Court decides, as the District Authority decides. But then there can be permanent Lok Adalat, any civil case which is compoundable in the nature. Any party to this case can approach this permanent Lok Adalat. And permanent Lok Adalat will have a chairman and two members. And they will only hear civil cases and only those cases which are compoundable in nature. And for example, there is a civil case involving dispute, and the value of this dispute or this property is 10 lakh rupees. Such cases can be heard by the Lok Adalat. Listen to me. If you and me have a dispute related to our property and the value of this property is 10 lakh rupees, we can approach the Lok Adalat. If the value of the property is more, can we approach Lok Adalat? No. But central government may say, central government may change the rule and say, we will enhance this minimum value from 10 lakh to more. And that is how now there has been a change that if the value of the property is 1 crore, you can approach to Lok Adalat. And yes, it is an alternate dispute resolution. That means instead of going to the court, you can go to a Lok Adalat. And whatever decision has been given by the permanent Lok Adalat, that becomes final and binding. No appeal will lie before any other court in this country. So that's the difference between a permanent Lok Adalat and a Lok Adalat which is established at any such time at a given interval which is decided by the committee. Let's now look at emergency provisions very quickly. These are the provisions, or before that, if you have any questions related to judiciary, please let me know. No question, all good. Okay. There are provisions of the Indian Constitution which convert our Indian Constitution from federal polity to a unitary polity, albeit briefly. And such provisions are what we call emergency provisions. And in these emergency provisions, the first is Article 352 of the Constitution. What does Article 352 say? If the president is satisfied what will satisfy the president? If there is war or external aggression or armed rebellion. If the president is satisfied because there is a war or external aggression or armed rebellion, or the president anticipates that there can be war or external aggression or armed rebellion, what the president can do, president can proclaim national emergency. But the president can proclaim national emergency only on the written advice of cabinet. This is where this term cabinet was not originally part of the constitution. It was added to the Constitution by 44th Constitutional Amendment Act, 1978. Because in 1975, when the emergency was imposed, it was imposed on the oral advice of the Prime Minister. Prevent the misuse of Article 352, 44th Amendment was enacted, which made it binding on the President to accept or to proclaim national emergency only on the written advice of the Cabinet. But can national emergency be imposed only in the entire country? Or can it be imposed in a state? Or can it be imposed not only in the entire state, it can be imposed in any part of the state? This national emergency can be imposed in the entire country or in the entire state or any part of that state. If today national emergency is imposed on the grounds of war, can tomorrow we modify it and impose it on the grounds of armed rebellion? Yes, that's also something that can happen. And when this national emergency is proclaimed, then what happens? Within 30 days, both Lok Sabha and Rajya Sabha separately will have to approve this national emergency. And how will Lok Sabha and Rajya Sabha approve this national emergency? By passing a resolution. And this resolution requires what type of majority? This resolution requires special majority. And if this resolution is passed by special majority approving national emergency, then national emergency can continue for months. Can this national emergency be extended for another 6 months? Can it be extended further? Another 6 months. Extended further? Another 6 months. Is there an upper limit? There is no upper limit. National emergency can be imposed any number of times for any time duration for any number of years, but every time you need to approve it for 6 months, get the parliament's approval again, then extend for another 6 months, another 6 months, another 6 months, because there is no limit. Because we don't know for how long the war will continue, the national external aggression will continue, the armed rebellion will continue. And in fact, it is this 44th Amendment inserted this ground, armed rebellion, on the basis of which national emergency can be imposed. Because previously it was not armed rebellion. The term used instead was internal disturbance. Such a vague term that it was misused in 1975 and emergency was imposed. How many times national emergency has been imposed? 3 times. 1962 war, 1971 war, and 1975. Was there no need to impose national emergency in 1965 war between India and Pakistan? There was no need. Why? Because this emergency, which was imposed in 1962, was revoked in 1968. Which means during the 1965 war, we were already in a state of emergency. But because of this, when national emergency is imposed because of this, how can it be revoked? Tell me. How can national emergency be revoked? At any point in time by the president. On her own? No. President cannot do anything on her own. She needs the written advice of the cabinet. Or it can be declared unconstitutional, null and void, arbitrary by the Supreme Court because there is judicial review. If you are able to convince the judiciary that this national emergency has been imposed and the intention of the government was malified, bad faith, then the Supreme Court will revoke this national emergency. Or a special power, as I told, is given to Lok Sabha under Article 350, Clause 8. If Lok Sabha passes a resolution, and that resolution passed by what type of majority? Majority. then it becomes binding on the President of India to revoke national emergency. This time, not on the advice of the Prime Minister and Council of Ministers, but this time on the advice of the Lok Sabha. Then, because of this national there, there is an impact. There is an impact on fundamental rights. If the national emergency is imposed on the grounds of war or external aggression, Article 19's enforcement is automatically suspended. What about other fundamental rights? They can be one by one, their enforcement can be suspended when the president passes an order under Article 359. But all fundamental rights can be suspended except Articles 20 and 21. These are the two fundamental rights whose enforcement is not suspended even during emergency. Then there is an impact on the state legislature. There is an impact on the Lok Sabha as well. When we are in a state of emergency, even if the term of the legislature is over, the 5 year term is over, the tenure is over, we can extend the tenure of legislature, which means legislative assembly and legislative assembly and Lok Sabha, by 1 year. Can it be extended further? By another 1 year. Can it be extended further? By another 1 year, till the time national emergency is in place. Then there is an impact on state executive as well. And there is an impact on the state legislature as well. We say during national emergency, Parliament enjoys concurrent power of legislation. Sir, what does that mean? We have state list, union list, concurrent list. Who has the power to make a law on union list? Parliament. Who has the power to make a law on state list? State legislature. Who has the power to make a law on concurrent list? Both Parliament as well as state legislature. During national emergency, we can say all the items which are mentioned in the state list, they are as if part of the concurrent list, which means on state list, both Parliament as well as state legislature will have the power to make laws. So this misconception you have to leave your mind. Does that mean during national emergency, state legislature cannot make laws on state list? No, it can make law. But Parliament also has the power to make a law. And in case there is a clash, which is the law which will prevail? It's the parliamentary law which will prevail. Similarly, state executive is kept under the direction of the union government. Union government can issue any directive to the state and it is binding on the state. And if the state does not abide by those directives, it can be viewed that is breakdown of constitution. Dismiss the state government. National emergency. It is not that state legislature is dissolved or state executive no longer functions. But the entire machinery is made unitary, which means state legislature and state executive are as if they are at the mercy of the center. That's the impact of national emergency, which means the entire system is concentrated in the hands of the center. Clear? Not suspended animation. The state legislature continues. It is not suspended. Then what is Article 355? Very important article for your exam this year because of the crisis in Manipur. Under Article 35, 355, there is the duty of the union. What is the duty on the union? That you have to protect every state from external aggression and internal disturbance. So it's the duty of the union to protect every state from external aggression as well as internal disturbance. And at the same time, it is the duty of the union to ensure that governance is carried out in every state according to the constitution. And what if it is not followed? What if the governance is not being carried out according to the provisions of the constitution? Then in that case, Article 350 comes into the picture. And under Article 356, if the president is satisfied, and what will satisfy the president? On the basis of the report of the governor, or even otherwise, which means the governor's report is not even necessary. Even in absence of the report of the governor, if the president is satisfied what? That there is a breakdown of constitution. But what is this breakdown of constitutional machinery? Is it defined in the constitution? Not defined. Under Article 356, if the president is satisfied on the basis of the report of the governor or even otherwise that there is a breakdown of constitutional machinery, what the president can do? President can proclaim what is known as the president's rule. And once it is proclaimed, then this president's rule has to be approved as well. Who will approve this president's rule? Lok Sabha as well as Rajya Sabha. When? 2 months. How? By passing a resolution by simple majority. If not passed, then president's rule gets revoked. If passed, then president's rule continues for 6 months. Can it be extended further? Yes, for another 6 months. But again, both Lok Sabha as well as Rajya Sabha will have to pass a resolution by simple majority, and then this president's rule gets extended for 6 more months. Can it be extended further? Yes, as well as no. No, if the conditions are not met. Yes, if the conditions are met. Which are these two conditions? One, either national emergency is imposed in the entire country or any part of that state, or Election Commission of India should certify that under the existing system, under the current situation, the current security situation is not prominent, is not conducive to organize elections. In such a case, we can extend president's rule by 6 more months, then by 6 months, then by 6 months, then by 6 months. That means total 2 years. Previously, 1 year, 6 months at a time, which means the maximum constitutional validity of president's rule is what? What if we want to extend it beyond 3 years? For that, we need to amend the constitution. Because if the constitution says that the maximum limit is 3 years and you want to go beyond that limit, for that, you need to amend the constitution. Because if constitution imposes a limit, you want to go against that limit, then amend the constitution. Right or wrong? Right. Then what is the impact of president's rule? Does president's rule affect fundamental rights? But sir, how 5 year happened in 1970s? It happened in 1980s in Punjab, and for Punjab, the constitution was amended. Does president's rule affect fundamental rights? No. What president rule affects? State executive, state legislature. What happens to the state executive? Immediate casualty. Gone. First impact of president's rule is the state executive is dismissed. Chief minister dismissed, council of ministers dismissed. That's what happens in president's rule. And then who will be the executive? President. And president will govern the state through his agent. This time it is the governor. Previously he is not the agent. Previously he is the constitutional head of that state. But during president's rule, you are the agent of the center. What will happen to the state legislature? Not dissolved immediately, kept under suspended animation. What is this suspended animation? That means legislative assembly will not be dissolved. For example, in Maharashtra, when president's rule was imposed, why? Because no political party was able to form the government on its own. The governor asked the BJP, asked the NCP, asked the Shiv Sena, did not ask the Congress, will you be able to form the government? All these parties said, no, we don't have the majority. Then the legislature was kept under suspended animation. But once it was decided that yes, two political parties may come together to form the government, president's rule was revoked. Which means not necessarily legislative assembly is not dissolved. It is kept under suspended animation so that a new government may be possible. But if the governor feels that no government is possible because of this legislative assembly, then it can be dissolved. Does president rule affect local government, Panchayati Raj institutions and municipalities? No, there is no impact. There is no impact of president's rule on the local bodies. But there is an impact on state legislature. And in absence of the state legislature, who will make law for that state? Now listen to me carefully. Answer this question. Is it necessary and is the only option that the president's rule in a state will lead to only the parliament making the law for that state? No. Then who will make law? You? Yes. Any other authority, as mandated by the parliament, parliament may give this responsibility of lawmaking to another authority, but parliament will decide. That's what happens in a president. And we have seen that this decision to impose president's rule, it can be challenged in the court as well. There is judicial review. And that is possible thanks to which case? SR Bombay, the Union of India, 1994, in which the Supreme Court made a distinction between breakdown of law and order and breakdown of constitutional machinery. President's rule cannot be imposed on the grounds of breakdown of law and order, but only on the grounds of the breakdown of constitutional machinery. Nandita Gupta, Article 2021 are not suspended during national emergency. What about Article 32? How will one go to the court? That is why it is not correct to say that Article 20 and 21 is not suspended and others are suspended. We say enforcement of fundamental rights is suspended. Now, what's the difference? Can you approach the Supreme Court for the violation of Article 19 under Article 32? Because under Article 32, you can approach the Supreme Court if your fundamental rights are violated. But you cannot approach the Supreme Court if Article 19 is violated because Article 19's enforcement is suspended. But Article 20 and 21 is not suspended. Their enforcement is not suspended, which means you go to the Supreme Court under Article 32 because your 20 and 21 has been violated because their enforcement is intact. That's the correct stance. Now, even during emergency, you can go to the court under Article 32 if your Article 20 and 21 have been violated. Article habeas corpus is not suspended if it is because it is related to Article 21, right to life and personal liberty. That is why habeas corpus is not suspended. Okay. I need a blank slide. Financial emergency. Under Article 360. If the President of India is satisfied, and what will satisfy the President? That the financial system or credit of India is under threat, then what the President can do, President can proclaim financial emergency. And what will happen because of financial emergency? Maybe all the money bills which are passed by the state legislative assemblies will be reserved for the consideration of the President. You will be asked, all the states will be asked, directed, observe canons of financial propriety. That means use austerity measures, reduce cost as much as possible. For example, when companies are in loss, they resort to cost cutting. They save on marketing, save on expenditure, remove the employees, cost cutting drive to survive as a company. Similarly, when the financial system or the credit of the nation is under threatened, then the president will proclaim financial emergency. And what will be the impact? Salaries may be cut, salaries may be reduced. States will be directed to observe the canons of financial propriety. Don't travel in business class. Don't stay at the five-star hotels. Use Oyo, right? Or One Day Bharat Express. Similarly, all the bills, all the money bills, the budget passed by the states may be reserved for the consideration of the president. Okay? Clear. But once this financial emergency is imposed, within 2 months, both Lok Sabha as well as Rajya Sabha, it needs to approve this financial emergency. And how will it approve? By passing a resolution by simple majority. If approved, financial emergency continues unless revoked by the president. which means there is no upper limit. It can continue forever and ever and ever unless and until revoked by the president. You may have read Lakshmi Kant also, wherein it said that president's rule can be revoked by the president on his own. National emergency can be revoked by the president on the advice of the government. Financial emergency can be revoked by the president on her own. There is no such thing as the discretion of the president. Whether it is national emergency, whether it is president's rule, whether it is financial emergency, president can proclaim, but only on the advice of the government. President can revoke, but only on the advice of the government. There is no such thing as the discretion of the president when it comes to these emergency provisions. Now, any question that you have regarding emergency provisions, please let me know. No questions at all. If there are no questions, why are you wasting your sleep time? Sleep. Okay. Now, I think this is the last segment that we have to understand. This is related to elections. Elections, for that, first you need to look at the constitutional provisions, articles 324, which talks about Election Commission of India. The superintendence, direction, conduct, and control of all elections, whether it is Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, President, Vice President, it is entrusted in this body called Election Commission of India. What is the composition of Election Commission of India? Election Commission of India consists of Chief Election Commissioner and as many election commissioners as may be appointed by the president. Initially, Election Commission of India was a single member body. We only had a chief election commissioner, that's it. But then in 1989, two more election commissioners were appointed. But after the elections, they were removed. But then in 1991, law was passed saying we will have a chief election commissioner and not more than four election commissioners. Not more than four election commissioners. He can have less than four, but not more than four. And at that time, we had CEC and two election commissioners. Despite the fact that Constitution was clear that yes, President can appoint Chief Election Commissioner and as many election commissioners, but how? What is the process that needs to be followed? What is the way of appointment? For that, Constitution envisaged that a law will be passed by the Parliament to regulate how these election commissioners and the chief election appointed, but such a law was not passed by the Parliament. Although Parliament did pass a law in 1991 called Election Commissioners Conditions of Service Act, but it was only talking about conditions of service. That means your term can be 6 years. You can be appointed as the CEC, but you cannot be appointed as the election commissioner. You can be removed just like you can be removed on the basis of the recommendation of the CEC. But how exactly you are to be appointed, for that there was no law. And matter went to the court. Anup Baranwal. So Anup Baranwal case is related to the appointment of the CEC and the election commissioner. Petitioner argued, Prashant Bhushan was the lawyer, saying the appointment of the CEC and election commissioner, it violates free and fair elections. It is arbitrary. Why? Because it gives unrestricted power to the government, to the union government. Union government recommends the president, president appoints CEC, president appoints the election commissioner. And if you are appointed by the president on the recommendations of the prime minister, who is the head of the ruling political party, the assumption is that these election commissioners who have to preside over free and fair election will be biased in favor of the political party which has appointed them. Supreme Court said, yes, you are right. So till the time Parliament enacts such a law, which Parliament did not enact since 1950, till the time Parliament enacts such a law, these CECs and election commissioners will be appointed by the President based on the recommendation of a committee. And this committee will consist of Prime Minister, Leader of the Opposition in Lok Sabha, and the Chief Justice of India. So, a law which was not passed since 1950. Within months of this judgment given by the court in Anu Baranbal, Parliament said we will enact a law. And Parliament enacted a law in 2023 called Chief Election Commissioner and other election commissioners appointment, conditions of service, and term of office. So this law does not only talk about appointment, it talks about conditions of service, it talks about the term of office. What does that mean? This act, first you have to keep in mind, repeals the 1991 Act, because when I told you that a law was passed in 1991, it was with respect to the service conditions, the term of office of election commission. Now, this law of 1991 has been repealed. Now, this 2023 law, it says that if chief election commissioner and election commissioners are to be appointed, they are appointed by the president based on the recommendations of a committee. And this selection committee will consist of prime minister, leader of the opposition in Lok Sabha, or if we do not have the leader of the opposition in Lok Sabha, then leader of the single largest party. And the other member will be a union cabinet minister nominated by the prime minister. So, Chief Justice of India has been replaced by a union cabinet minister nominated by the prime minister. So, again, it is the dominance of the ruling political party at the center. And in fact, this law has been challenged in the court, but the court has decided not to hear it. But be that as it may, this selection committee will have to look at names. Randomly, who should be appointed as the CEC and election commissioners? For that, we need names to decide, to discuss, to debate. These names will be provided by a search committee. So, a search committee will have to be set up, which will be headed by the Union Minister of Law and Justice. This search committee will look at names, senior IAS officers, whatever, and 5 names will be suggested. This 5 names will be suggested to this selection committee, and selection committee will pick one from this panel and will appoint that, will recommend that to the president that appoint this person. Listen to me carefully, important for your prelims exam. Not necessary that the selection committee, consisting of prime minister, union minister, and leader of the opposition, they have to necessarily look at these 5 names. They can appoint somebody who is not even there in the list provided by the search committee. And in fact, in this selection committee, if there is a vacancy, if Rahul Gandhi is absent, even then the selection committee can go ahead and recommend somebody to be. These facts are important. This law also talks about that when it comes to the criteria, who should be appointed as the CEC or election commissioner? This person should be a person of integrity. But what is that person of integrity? Not defined. Should have knowledge and experience in the management and conduct of elections. Should have been a secretary or equivalent to the government, which is a senior IAS officer with more than 10 years of experience. Should have been holding the position of the secretary to the government or above. Such individuals who are the persons of integrity can be appointed as the CEC or the election commission. But for how long? The term is 65 years or 6 years, whichever is earlier. Which means if I am 50, which I am not by the way, but just for example, if I am 50 and I am appointed as the CEC, will I remain in office till I attain the age of 65 or for the next 6 years? for the next 6 years, whichever is earlier. Or for that matter, if I'm 54, I'm 64, I'm appointed as the CEC. Will I remain in office for 6 years? That means till I attain the age of 70? No. I will remain in office for the next 1 year, because 65 years or 6 years, whichever is earlier, that's the term. If I am the CEC, can I be further reappointed as the CEC? No. If I am the EC, can I be reappointed as the EC? No. But if I am the EC, can I be promoted as the CEC? Yes. But even as an EC, if I am promoted to the CEC, my combined term at the election commission should not be more than 6 years. Which means if I was the election commissioner for 4 years, now I'm promoted as the chief election commissioner. My term as the CC will only be for 2 years max, not more than that, because 6 years is the total. How is the chief election commissioner removed? The chief election commissioner is removed just like the judge of the Supreme Court is removed. Who removes the judge of the Supreme Court? President. On the basis of the resolution passed by both houses of the parliament by special majority. On what grounds? Proved misbehavior and incapacity. And constitution says, this law also says the same thing. The judge of the chief election commissioner shall be removed in the same manner and on the like grounds as the judge of the Supreme. But how is the election commissioner removed? Election commissioner may be removed only on the recommendations of the CE. But this recommendation is not binding on the president. Which means that the CEC recommends to the president that I want this EC to be removed. President may not go ahead and remove that election commission. But without my recommendation, the president cannot remove the election commission. My recommendation is, that's something that you have to keep clear. Any questions as of now? Okay. What is the criteria for declaring a political party as a state political and then a national political? And then what are the benefits? There are some conditions that you need to fulfill. For example, if I start a political party today, let's say it is ABC, a mixture of Aam Aadmi Party, the Bharatiya Janata Party, and the Congress, ABC. If I start this political party, I have to first register with the Election Commission of India. And if it is registered with the Election Commission of India, this political party becomes a registered political party. But if I fulfill certain criteria, over a period of time, my party can be recognized by the Election Commission of recognized by the Election Commission of India either as state political party or a national political party. Right? What is the criteria to be recognized as a state political party first? If I secure 6% of the valid votes polled in this particular state at a general election, and I also win 2 seats in the same legislative assembly. So I am contesting election in Karnataka. If I get 6% of the valid votes in Karnataka and I get 2 seats as well, I win 2 seats as well, my party ABC is a state political party of Karnataka. And if I perform this way in 3 or more states as well, in 4 or more states as well, I will be a national. Clear? If not this condition, then you meet another condition. I am contesting Lok Sabha election from Karnataka. If I secure 6% of the total valid votes in Karnataka in the Lok Sabha election, and I win one seat, one Lok Sabha seat from Karnataka, I will be recognized as a state political party in Karnataka. If not, then there is an election to the Legislative Assembly. Forget about votes. Let's look at the seats. If I get 3% of the seats in the Legislative Assembly, if I get three seats in the Assembly, whichever is more, so in this particular state, what is more, three seats or 3%? If I get 3% or three seats, forget about vote share. Vote share can be anything. But if I can get three seats or 3% of the seats, I am a recognized state political party in Qatar. If not, let's look at Lok Sabha election. If for every 25 seats I get one Lok Sabha seat, then I will be a state political party in Karnataka. If not, then forget about seat share, just look at vote share. If I get 8% of the valid votes, regardless of the seats, don't care about the seats. If I can get 8% of the votes, I am a recognized state political. You have to keep these conditions in mind. And if you are declared as a state political party of one state X, and if you are recognized in four or more states, then you become a national political. So if you replicate this performance in four or more states, you are a national political. What if I don't have time to replicate my performance in four or more states? I want to do it in one go. For that, if you are setting up candidates in the Lok Sabha elections, this is the election right now, and you win 6% of the total valid votes in at least four states, and you also get four MPs, then you are a national political. Or you win 2% of the total seats in the Lok Sabha from at least three states. These are facts. These facts you have to remember. If you can remember them, it becomes easier for you to answer the question. And if you replicate this performance, you will be declared as a national political. But then what is the benefit? Benefit is you will have exclusive use of your symbol. If your symbol is, let's say, pen, you can contest on this pen symbol even in Sikkim where you are not recognized because you are a national political. That means you have the exclusive use of your symbol in all the states in this country, even in states where you have no presence because you are a national political. This political party, recognized political party, can have 40-star campaigner. What is the benefit? You know that there is a limit to the amount of money that a candidate can spend in the elections. If you breach that limit, you will be disqualified. But if you have a star campaigner campaigning for you, then the expenditure related to that star campaigner will not be added to your expenditure. And a recognized political party can have 40 star campaigners. And whenever these star campaigners will campaign for the party, their expenditure will not be added to the expenditure of the candidate contesting from. Which means if I'm contesting election from, let's say, Bengaluru South, and I'm given ticket by the BJP, and I call Mr. Modi as the star campaigner because BJP releases the list of 40 star campaigners. When Mr. Modi will come to my constituency to campaign for the BJP, he won't take my name, he won't sit with me on the days, but he will generally ask people to vote for the BJP. And whatever money has been spent to bring Mr. Modi here, that money will not be added to my election expense. But for a registered political party which is not recognized yet, they can have only 20-star campaign. And if the candidate belonging to this recognized political party dies before the voting, the election is adjourned, or should we say suspended in that constitution till the time my party can set up another candidate. If the candidate belonging to a registered political party or an independent dies, doesn't nothing happens to the election continues. But if the candidate belonging to a recognized political party, recognized as national or state political party dies, the election to that constituency is suspended for some till the time the political party is setting up a different candidate. Okay. Now, Representation of the People Act also talks about disqualification. It also talks about qualification. What is the qualification required in order to contest the election? Some qualifications are mentioned in the Constitution, but some are mentioned in the Representation of the People Act. But it also talks about disqualification. And for that, we have Section 8, Clause 1, Clause 2, Clause 3. And we also have Section Clause 4, but it was declared unconstitutional by the Supreme Court in the famous Lily Thomas versus Union of India. Somebody was asking about this section, and let's discuss. If you are a legislator, whether Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, you're a legislator, and you have been convicted for those offenses which are mentioned under Section 8, Clause 1 of the Representation of the People. Even if a fine is imposed, you are disqualified. Even if a fine is imposed, you're disqualified. Matters, offenses related to terrorism, arms act, so on and so forth, untouchability. Even if a fine is imposed, you are disqualified, and you are further disqualified for 6 years after your release. Which means if I am given a sentence of 14 years, for 14 years I cannot contest election because I'm convicted. There is a difference. If you are an under trial, you can contest election. But if you are convicted individual, you cannot contest election. That is how engineer Rashid, Amrit Pal Singh, they are able to contest elections. They won the election as well because they are yet to be convicted. They are only accused. And there is a golden rule of criminal justice system. You are innocent until proven otherwise. But if you are convicted for those offenses mentioned under Section 8, Clause 2, even if you are convicted for 6 months, you are disqualified. You are sentenced for less than 6 months, you will not be disqualified. But you are sentenced for 6 months or more, you are disqualified. And then you are further disqualified for 6 years till after your release. But if you are convicted under Section 8, Clause 3, for example, defamation, unless and until 2 years punishment is given to you, 2 years or more, only then you will be disqualified. If you are sentenced to 2 years or less, if you're sentenced to less than 2 years, then you will not be disqualified. Long story short, if you're convicted for offenses under Section 8, Clause 1, you're disqualified, even if only a fine is imposed. If you're convicted for those offenses mentioned under Section 8, Clause 2, minimum 6 months punishment should be given, only then you should be disqualified. And these are offenses related to adulteration of food, so on and so forth. But if you are convicted for those offenses mentioned under Section 8, Clause 3, then if you are sentenced to 2 years or more in jail, only then you are disqualified. And once you are released, For 6 years after your release, you cannot contest it. But there used to be Section 8, Clause 4, which provided a remedy. And remedy was, even if a legislator who has been convicted under these sections, immediately you will not be disqualified. Instead, a 3-month window is provided. That means if the trial court has convicted you, you will not be disqualified. You have 3 months, you appeal before the High Court. If High Court also declares you guilty, you will not be disqualified. You have 3 months, appeal before the Supreme. And only when the Supreme Court declares you are guilty, then you are disqualified. But Supreme Court said under Lily Thomas case that this is arbitrary. Why arbitrary? Because this exception is only for a legislator, not for a common person. What if I am guilty of Section 8, Clause 3? I am guilty of, let's say, defamation. I cannot contest election. I'm an ordinary person. But if there is an existing legislator who is convicted of defamation and sentenced to 2 years or more in jail, he will not be immediately disqualified because he has 3 months to appeal before the High Court. So, this arbitrary classification of people violates political justice, which is an objective mentioned in the preamble. And hence, Lily Thomas case, Supreme Court said the moment you are convicted, you are disqualified. But yes, you are convicted. You can also appeal before the court, and if the court sets aside your conviction, if the higher court sets aside your conviction and decides to hear your case again, then you can be reinstated. Which means Rahul Gandhi, when he was disqualified because he was convicted for defamation, he appealed before the court set aside his conviction, said, we will hear this case. Till the time, you can continue as the legislator. That is Section 8 clause. Clear? Any questions? Are you tired? Yes. Why are you tired? What have you done? Okay, if there is a legislator, if there is a person, he can be disqualified if you are entering into a contract with the government for the supply of goods. If, as a person, you have a contract with the government that you are supplying goods to this government, you cannot contest election. You're disqualified from contesting election. Similarly, if you are a managing agent or a manager or a secretary of any company, and in this company, the government has not less than 25% share, then unless and until you resign from that company, you cannot contest election. You are disqualified from contesting. Similarly, there is a limit to the amount of money that you can spend in the election. There is an expenses limit. If you fail to lodge that expense account with the Election Commission of India, you will be disqualified. And you will be disqualified for 3 years. Failure to lodge the election expenses account with the Election Commission of India. But further, this becomes important because Sikkim, when was Sikkim admitted into India as an associate state? 1974. Then it became a full-fledged state in 1975. 50th anniversary, isn't it? Can be important. And the chief minister of Sikkim, the current chief minister of Sikkim, he was also convicted in a court of law, sentenced to jail, which means he should have been disqualified. And after the release, he should have been disqualified for 6 years. But Election Commission of India has the power. That what Election Commission of India it can do, it can remove or reduce disqualification. That means the power with Election Commission of India is not only to reduce the disqualification, it can remove altogether. That means even if somebody is disqualified for 6 years, Election Commission of India may say, we will reduce your disqualification from 6 to 2 years, or we will remove it altogether. You are no longer disqualified. But when Election Commission of India takes such a decision, it has to record its reasons in the writing. Why and on what grounds are we reducing or removing this period of disqualification, which the Election Commission of India did with the current Chief Minister, Mr. Prem Singh Tamang of Sikkim. Can be important for your prelims examination. And as I told you, if there is a death of a candidate belonging to a recognized political party, then the election is adjourned. And the time is provided, opportunity is provided to the political party. You set up an alternative candidate. Clear? Few more things and then we are done. I will only take 10-15 more minutes. Stay with me. Okay. Procedure in contested and uncontested election. If the number of contesting candidates is more than number of seats to be filled, a poll should be taken. Which means if this is a constituency, from this constituency, one candidate has to get elected. But if the contesting candidates are 10, there has to be an election because out of these 10, how many should be elected? Just one. So we have to contest. But if the number of such candidates is equal to the number of seats, what if there is only one candidate and we have to select one? Then all such candidates will be declared elected. Which means if there is only one seat and only one candidate, this person is elected uncontested. Something that happened in Surat. When all other candidates they withdrew their nomination papers, only one candidate was left, was elected uncontested, unopposed. But the point is this: what if from, because here it raises another important question, the matter is before the court, you are depriving people of nota. Election should have been necessarily conducted. What if people will opt for nota? Right or wrong? But be that as it may, that's a matter that we can discuss in the mains examination. This becomes important. From this constituency, one candidate is to be elected. What if nobody wants to contest elections? In this case, what will happen? So you have read about a situation where there are 10 candidates for one seat. Let's conduct election. Let's see who will win. There is one candidate for one seat. Only one candidate from this seat. This person gets elected uncontested. What if there is from this constituency nobody is contesting election? What will happen in this case? Have you heard of the situation? In this case, the Election Commission of India will ask the people again, contest election, file nomination. But even this time, if nobody is willing to contest election, then public notification will be issued in the official gazette that from this constituency we will not have a candidate. Unless and until it is proven, or unless and until Election Commission of India is satisfied that maybe now if we ask people to contest again, maybe this time we will have a candidate. Otherwise, you have to remind them once again. If again there is no candidate, then you have to stop. You can't announce candidate. You can't announce election there. That is something that you have to keep in. Election Commission of India shall not be bound to call again upon the constituency unless and until it is satisfied that there will be no such failure. Somebody will contest election. Somebody will file the nomination. Otherwise, Election Commission of India is not bound to call up again somebody to contest election from that constituency. That seat will remain vacant. Somebody was asking right at the start or towards the middle part of the lecture, what about double membership? What about vacation of seats? This is something that we have to discuss towards the end. What about a person who is chosen as member of both Lok Sabha as well as Rajya Sabha? That means at the same time you have been elected to Lok Sabha as well as Rajya Sabha, but you have not taken seat in any of these houses. You are yet to decide whether I should be member of Lok Sabha or Rajya Sabha. Pinky Ponky, what should I choose? You have to send a notice to the Secretary of the Election Commission of India within 10 days, deciding, choosing whether it should be Lok Sabha or Rajya Sabha. And if you are unable to decide that, then your seat in the Council of States will become vacant. Sir, what are you saying? I am saying I got elected to Lok Sabha as well as Rajya Sabha, but I have not taken oath in either Lok Sabha or Rajya Sabha. Then what will happen? I have 10 days to decide whether I should be part of Lok Sabha or Rajya Sabha. If within 10 days I write to the Secretary of the Election Commission that I want to be the member of the Rajya Sabha, I will remain member of Rajya Sabha, I will lose Lok Sabha seat. But if in 10 days I am unable to decide, then I will lose the seat in the, I will only be the member of the Lok Sabha. Similarly, if a person who is already a member of the House of the People, and I've taken oath there as well, I am a member of the House of the People, and then I become the member of the Rajya Sabha as well. That means since I was already a member of the Lok Sabha, I took oath there as well. Now I contested Rajya Sabha election as well. I won the Rajya Sabha seat as well. My previous seat, which is the Lok Sabha seat, becomes vacant. Now, if you are already a member of the Rajya Sabha and I've taken a seat there, I've taken oath there. Now I have chosen that I want to become the member of the Lok Sabha. My seat in the Rajya Sabha becomes vacant because when you decide, already you are a member of one house, you decide to contest election and you are chosen as the member of another house, your previous seat becomes vacant because you can't be the member of both the houses at the same time. Now, what if a person is elected to more than one seat? You have contested elections from two constituencies and you have been elected from both the constituencies. Or if a person is elected to more than one seat in either house of the parliament or in house of the legislature of that state, then unless within the prescribed time he resigns all but one of that seat and he has to address this to speaker or chairman, then all seats will become vacant. If I am elected from Lok Sabha, I have to communicate to the speaker that I am giving up Wayanad and I am taking Raebareli. If I don't take this decision within the time period which is mentioned by the speaker, then I will lose both the seats. Both Wayanad and Raebareli gone. This is something that you have to, and this can be important for your. Let's look at few questions. The Parliament can empower the Supreme Court to issue writs for any other purpose other than fundamental rights. Because right now, writs can be issued by the Supreme Court for the enforcement of fundamental rights. Can these writs be issued for other rights as well? For that, Parliament has to empower the Supreme Court. The statement is correct. It is said that the law declared by the Supreme Court shall be binding on all courts within the territory of India. This, however, is the Indian innovation of the top court and not explicitly mentioned in the Constitution. This is mentioned in the Constitution. under Article 141 of the Constitution. Article 141 says the judgment given by the court becomes law of the land and it is enforceable throughout the territory. It is not an innovation of the Supreme Court. Which of the statements are correct? A, only one is the right answer. The Delimitation Commission is a constitutional body. It's a statutory body. The award given by the Delimitation Commission cannot be challenged in any court of law. Can be challenged because of the recent Supreme Court judgment. In India, Delimitation Commission has been set up 4 times since the enactment of the Constitution. Correct. When? 1952, 1963, 1973, 2002. Only a delimitation commission can be tasked with the redrawing of electoral constituencies in India. No, it can be either delimitation commission or it can be election commission of India. How many statements are correct? A, only one statement is correct. A is the right answer. The second statement is incorrect. How? Because the Supreme Court has said in Gujarat case that the award given by the Delimitation Commission can be challenged in the court of law if the award is malified. It can be challenged in the court of law because I told you at the start, judicial review, anything can be reviewed in the judicial, even if it is explicitly mentioned in the constitution that you can't do that. For example, Article 329 does talk about that the award of the Delimitation Commission cannot be challenged in any court of law. The court has said, yes, if it is malified, bad faith, we can challenge it. You can challenge it. Okay, that is it for today. Thank you so much for staying with me and staying with me to learn Indian polity. I hope whatever we discussed today and over the past few weeks, the questions would be asked from these topics, and hopefully, you will be able to answer all the questions from Indian polity. And please remember, polity is one area where you can score 100%, where the chances of scoring 100% is huge. So please trust yourself, trust your logic, trust your preparation, be confident. You will be able to answer every question in the prelims examination, specifically to polity. If you have any questions, please let me know. Okay, thank you. All the best. Bye bye. Good night.